Good morning. Please take your seats. We're about to get started. Thank you.
How's it going? Hello, hello. Good morning from Chicago, everyone who's watching online, and good morning to all of you in the room. Thank you for joining us again. This morning, we're very happy to host a breakfast keynote with Tim Wu and Benjamin Applebaum. And before we begin, please note again that we're on the record and live streaming, and we'll post this on the Stigler channel, YouTube channel later. And the opinions expressed are those of Tim and Benjamin, not those of the Stigler Center or the University of Chicago. It's always a good reminder. And always, of course, check our website, check promarket.org, where we have a lot of publications for this conference in particular, and the Capitalism podcast. So let me briefly introduce our speakers. Tim Wu is the Julius Silver Professor of Law, Science, and Technology at Columbia University. In 2021, he was appointed to serve in the White House as a Special Assistant to the President for Technology and Competition Policy, a post he has just left. His most recent book is The Curse of Bigness, Antitrust in the New Guided Age. And Tim Wu actually once explained net neutrality to Stephen Colbert in a roller coaster. I watched this last night. It's a fascinating movie. I recommend everyone to do it.
It's terrible.
Yeah. Benjamin Applebaum is the lead writer on economics and business for the New York Times editorial board. Before joining the editorial board, he worked a decade as the Washington correspondent for the Times, covering the Feds. His work has often explored the evolution of economic policy, in particular the rise and faith in markets and the solution to a wide range of problems. And in 2019, he told that story in his first book, The Economist's Hour, False Hope, False Profits, Free Markets, and the Fracture of Society. We actually explained it also at the Stigler Center event. You can find online. If you're interested for a summary, you can find the discussion online as well. So please, Binia, take it from here.
Good morning, all. Thanks for getting up and joining us. We're going to do this basically as a conversation and hope to keep it free-flowing and interesting. So I'm just going to dive right in.
Sure.
A couple of years ago, the American people engaged the law firm of Cantor, Kahn, and Wu to handle our antitrust business. You've recently left the firm. Tell us how it went. What was accomplished during those 2 years?
Yeah, thanks. That's great. Thanks for first having me. And this Stigler, this antitrust conference is great. I'm really happy to come back to it. So I was thinking about this morning and thinking about what we did. We had this metaphor inside the White House where we said, what we're trying to do here is turn the aircraft carrier. Antitrust is big. It involves judges, enforcement officials. It's not going to be like snap your fingers and everything moves. So we need to change the direction of things. We feel that the last 40 years or so, we've gone too far in one direction. We want to turn to another direction. And we had this internal document called the Grand Unified Theory of Antitrust Revival. And we had, I can't remember how many points, but like a 5-point plan for what we wanted to do. And, we did a lot of it. It's a stereotype. It's hard to get things done in government. It's true. But the first 2 years of administration, if you're going to try and do something, that's the time. Some of the things we wanted to do were this. We wanted to reset what the United States and what the president was saying is the U.S. policy in antitrust, and firmly put the president. The president historically has played a role talking about antitrust back in the role of Theodore Roosevelt or FDR, of saying, he believes in a strong antitrust enforcement, believes that, we should do these things. Obviously not getting involved in individual cases, but have the president, democratically elected leader of the United States, be saying what he thinks antitrust policy should be. That a lot of that came in the early parts of our executive order on competition of July 9th, 2021. We wanted to begin a whole of government antitrust effort. This is something we had to give credit where it's due, and the Obama administration started to do. Jason Furman, many other people in this room were involved, Howard Shalansky. But the idea was to double down and institutionalize that effort and to collect the agencies outside the antitrust agencies that have relevant authority. That's one thing you notice. There's a lot of competition statutes in the U.S. Codebook, whether it's at the FCC, the DOT, even HHS, where there's some commitment to competition or improving conditions of competition or something, to try to use that authority and also sort of unify and coordinate how it was being used. We created this body, which hopefully people in this room are familiar with, the Competition Council, headed by the National Economic Council. But I think most importantly, set it up to have meetings with the president every 6 months so that the cabinet secretaries would feel like there's a little bit of like, what have you been done lately kind of sense, that there's some feeling that part of their job was to pay attention to competition areas in their authority, in their industries. And that, I don't want to go on forever on this, but it was based on the premise that there's a lot of good work to be done there, but that agencies in some ways lacked a sort of direction when it came to competition policy. The third thing we wanted to do was personnel related. We wanted to appoint people who believed in strong antitrust enforcement and antitrust revival. And we did that with Jonathan Cantor and Lena Khan at the antitrust agencies. But we also, in something that we didn't fully finish, wanted to seed the other agencies with antitrust expertise. So we wanted there to be more people thinking about prices inside HHS and CMS. I mean, what I mean is people who were thinking about the problems of creating barriers to entry or their effects on drug prices, for example, certain regulatory conduct inside HHS or the FDA. And that we got part of the way done. And finally, we wanted to pay attention to the judiciary. We had felt that there had been sort of an indifference to antitrust and I guess economic justice issues on the part of our party, Democratic Party. Obviously, a lot of attention to people's records on civil rights and other issues, but on economic issues, kind of a little bit more like anything goes. So we wanted to bring more attention and scrutiny to that, and along with repopulating the judiciary. So those were on our Grand Unified. Obviously, this is just from memory; it's probably totally wrong, but vaguely what we were trying to do. And I think we did a lot of it. Doesn't mean we did everything. We did a lot of it. Particularly proud, I'd say, of the the executive order on competition. We wrote that thing to be a document that we hope survives and as a statement of principle, but also as a model for how to set up a whole of government program. And obviously the council at the front of it, at the center of it's very important. And, I'm also proud of the stuff the agencies did. Of course, the antitrust agencies who brought a lot of cases blocked some very significant mergers, some of them with the cooperation of agencies, which I was very happy with. Good example being the missile, the Lockheed Martin merger, FTC and DOD to some degree collaborated on. But also our big antitrust rulemakings, like the hearing aid rulemaking, the electrical vehicle net neutrality charging rulemaking, Packers and Stockyards Acts, and also finally the junk fees initiative. So I feel like we did a lot. I certainly felt busy. I was tired. I slept for a month after leaving, but that's kind of where I felt we did.
Step back from those particulars. When you talk about a grand unified theory of antitrust, articulate that for us. What is that?
Well, it was just a sort of a goofy memo title, but part of the sense that if we wanted to turn that battleship, it wasn't going to be, as I think sometimes other administrations might have hoped, you just appoint a couple people and just let it go. we felt that there were so many areas where if we wanted to turn things around, we had to be active. I guess that's what I meant. Maybe that's less ambitious than you're hoping for, or less theoretical. If there was a theory, I think it was a sense that we had become, in some ways, allowed the antitrust laws to become too technocratic, too far from democratic oversight in a sense. One of the things that I think is an innovation or a change in perspective was a sense that competition policy is economic policy. In other words, we felt that there had been a sense of seeing antitrust as, it's obviously very case by case, and merger and all these and enforcement centered. But we thought the issue of the competitiveness of the economy was in macro or a bigger kind of economic issue that the presidency and the White House should be concerned with. I'm not saying other White Houses weren't concerned with that, but I think there was a tendency to sort of see antitrust in its own little world. And we thought, I don't know if this is rhetoric, but we often called competition sort of the third pillar of the president's economic policy. So we wanted competitive competition to be a big part of our broader economic policy, and that was what the grand unified theory was related to.
I mean, you've written that you think that one reason that antitrust enforcement declined over the course of the 20th century and into the 21st is that it became too focused on sort of the details and the nuances and insufficiently focused on the pain that people experience as a result of corporate concentration and the exercise of monopoly power.
Yeah, I think that's right. I think there's often been a question of why did antitrust, historically become quiet, and I do think it's partially because it became more technocratic. It went away from elected leaders, the president, figures like that, and towards small cases and conferences, not unlike this one where you debate things that are very interesting to us, but don't always feel that important to people. The president in particular, Joe Biden is not into the minutia of Section 7 analysis or anything like that. He wants everything to be translated into what does this mean for Scranton, people in Scranton? What's going on? What does this mean for the workers? I think that the thing that got the president, in fact, so into antitrust was the sense that it was going to be important for workers as well as for consumers, that there had been, in areas like non-compete agreements. That was something he was very passionate about, spoke at length in the launch of the executive order. And so the sort of visceral nature, bringing back the sense of antitrust as, particularly after a period, the antitrust winter of weak enforcement, to fire things up again in visceral nature was very important. I also think it was important for the Competition Council that we had things that the president or other elected officials or cabinet secretaries wanted and liked talking about. Junk fees is a good example of that. Sometimes I thought of us having, a dual track of whole of government initiatives. Some of them were more visible, talkable, politically important for the president. The other, something, like the merger guidelines. It's not like you're going to have the president out there giving a speech about the merger guidelines. Maybe in 1912 or something like that. But, it's a little difficult to get people other than this room jazzed up about merger guideline reform, but junk fees, airline seating, that kind of stuff is a way. And I think it's important, I think it's important that we communicate in government why we're doing things the way people understand. I think everyone agrees with that. I think it was a fault of the Obama administration. I think we meant well, but we sometimes assumed that people would get what we were doing. We figured out the smartest stuff, a lot of smart people there, and then it was sort of assumed that the public would figure it out. And sometimes, famously, there was people thought we should hide what we're doing so it wouldn't distort behavior. But that wasn't particularly, I think, effective when what you want is people to feel like government is on their side and facing up to challenges they feel a lot of people in the last 10 years have felt that they've fallen through the cracks. Government's not doing anything to help them against China, against big employers, and against whatever, hospital consolidation. So the government, I think, to be democratically responsible, has to be sort of out there. And is that precisely, exactly, describing what you're doing in every merger case? No, but it is, giving, whether it's president, other visible figures, a sense of why we're working for you, so that people don't, and this was important to the president, believe in democracy, believe in voting for people, believe there's some accountability, as opposed to thinking they, have a government that doesn't really care about you, and that's why we need some really strong guy who's going to do what we really want. So there was this background of being concerned about democracy, authoritarianism in the background of some of our efforts to make antitrust big and visible in people's lives. What succeeded, I'm not fully certain, but that is certainly what we thought was very important. And this relates to our conversation a little bit yesterday about what role, non-market factors should have. I mean, I don't know if they should be in individual cases, but in terms of giving people a sense that they're standing up for things. I mean, this is what Theodore Roosevelt did when he started enforcing in 1904. He said, we need to show the people that the government rules this country, not the corporations. And this is what FDR, especially during the Second New Deal, was doing as well, is saying, we need to show people that we're still in charge here, or they're going to want something else. So that, I think, as a background, wasn't necessarily informing individual decisions, but as a background of making it feel like the government is accountable to people and will stand up to power that is greater than them. That the idea of popular sovereignty is that the people can be together stronger than other private or public forces in life. That was a big part of what we were trying to do.
So there's 20 months left on the clock for this administration.
Yeah.
What is the unfinished business? What needs to be accomplished in that time?
It's a good question. Like I said, I think we've done a lot, and I think that, using we, past we, I think we did a lot, and I'm proud of what we did. There is some, as suggested by the question, unfinished business. The Competition Council, which we created, was like many early White House things, sort of thrown together, staffed by the NEC, and effective. But I do think it needs to be staffed in a slightly more institutionalized way. In other words, we have to institutionalize some of the ideas of having a constant oversight, constant pressure on agencies to take seriously the mission of competition and prevent creating barriers to entry or regulatory entrenchment, things like that. That is partially the National Economic Council, partially OMB and OIRA, and partially Council on Economic Advisors, but sort of an institutionalized competition office or presence inside the White House, I think, is very important. We didn't complete the job of seeding agencies to the degree I would have liked. I think we need more. There's people like Andy Green in agriculture who have been terrific, and Jen Howard inside of the Department of Transportation are some of the people who are seated. But I think having ambassadors might be too strong, but people who have some competition expertise, more competition expertise in agencies is important. Healthcare is in competition, as everyone knows, I think, is unfinished business. Obviously, the merger guidelines, which I know are underway, need to get done. Legislatively, we did not succeed in getting tech antitrust laws passed. And, that was something the president wanted to do. That's something we wanted to do. Remains to be seen. I haven't seen a lot. The Republican Party certainly talks good line about their concerns with big tech, but hasn't particularly seemed to be advancing very much. But the president called for, the passage, recently called Wall Street Journal, I guess in January, to pass the major tech antitrust laws, Klobuchar-Grassley being a major example. That's unfinished business, and that ideally get done.
So far as I can tell, the fifth item on your original sort of grand plan list was the judiciary.
Yeah.
And so far as I can tell, the Biden administration has yet to nominate anyone to the federal bench who has any discernible experience on antitrust issues. Why did that fail? Why has this administration not taken that seriously?
I don't think it's true. I guess I challenge the premise. I think that we have appointed people who have backgrounds in plaintiff side antitrust work. I have trouble remembering all of the names, but I know that we did appoint at least one or a few judges with that kind of background. I think it is true that we have not met the Reagan administration's bar, maybe a very hard bar to meet, of appointing Robert Bork, Frank Easterbrook, and Richard Posner to the bench, who obviously came to the position with views on antitrust law and were an enormous influence over the laws in the years to come. So by that measure, we certainly have fallen short. This is going to sound sort of defensive, but there are a lot of people who have a lot of issues that they would like federal judges to be in accord with them on, and that was something we did sometimes run into. But I think we can do better, and I think we have to get more federal judges appointed, period, and that's a big priority. But I do think we can do better to get more antitrust judges with judges that have a track record in antitrust that's in accord with the president's would be something we should do.
You've returned to Twitter since leaving the administration and recently lamented that a paper you wrote in 2016 called Antitrust via Rulemaking never got as much attention as you would have liked. So I'm here to remedy that. And I want you to talk a little bit about the ideas in that paper, which is basically focused on the idea that, we focus so much on enforcement and on, the agencies going after companies, but that there are opportunities for the federal government to create a more competitive marketplace administratively through rulemaking.
Yeah.
Talk a little bit about those opportunities.
Sure, thanks. That does make me sound kind of whiny, doesn't it? I think I was saying that it's surprising which papers become popular and which don't. It's never predictable to academics. But that paper contains the seeds of what ultimately I think is expressed in the Competition Council, the idea that there's considerable work that can be done through rulemaking as opposed to just cases. Now, nothing wrong with cases. Cases are important. But, for a set of reasons well studied in the administrative law literature, there are situations where rules make a lot of sense, where, trying to do everything case by case doesn't always work the way you might think or takes too long. I think personally, I don't second guess the FTC's approach to, I guess I am going to second guess a little bit, approach to pay for delay settlements in the pharmaceutical industry. But, maybe a rule would have settled that question a lot quicker. There were so many of them, it was obvious what the competitive harm was and so forth. So, when you have scattered conduct, a lot of situations call for rules. I think non-competes is another good example where a rulemaking makes a lot more sense in trying to establish something through case-by-case adjudication. I, in that piece, was particularly interested in a certain kind of rule that I think we almost underplay. The best kind of rules, pro-competitive rules, are ones not necessarily that stop in narrow practice we know is anti-competitive, but ones that manage to open an entire new industry that people didn't really realize could exist. These were some in the paper. I think I called them tiebreakers, where there's sort of a tie that people haven't realized. That's an antitrust term, but in some ways, two kinds of businesses or services that have traditionally been tied together, that if you untie can create a big boom. The most famous and maybe obvious example is in telecom, where over the 1970s, the FCC took these steps to try to separate or untie the provision of the phone service and the services over the phone lines. these are sort of the ancestors to net neutrality, technical words, computer inquiries, along with rules that said you could hook up anything that mandated a phone jack. It used to be obviously your telephone came with your telephone service came with a telephone. That was just the way things were. So the FCC, in a sense, broke that tire or made a cut at that point, and so you could plug everything in. At the time, people were like, well, this is going to promote, competition in telephones. You could have a Mickey Mouse telephone or something, and that was true, but that was trivial compared to what it really made possible, which was innovation around that phone jack on top of the phone lines. Things first like answering machines, fax machines, but then the modem. So then when you had the modem, you had the possibility of an industry that provides dial-up service and a bulletin board access and so forth, like CompuServe AOL. Those go on and eventually seed the beginnings of home internet service. Eventually it gets connected to the main internet. You get the internet revolution. You get, billions, maybe trillions of dollars in value. I'm not going to say it's all based on that one little rule, but that starts things. And also the rule that says that AT&T couldn't mess with or even at some point be in the industries over the phone lines. So those kind of creation by breaking these ties can do a great deal. Another example, maybe not as much value created, was the eyeglass rule in the late 70s by the FTC, where they had noticed that the way things were, it was actually consumer protection, but with competition consequences. They had noticed that eye doctors, control the market for eyeglasses. You go in, you have a test, and then, you didn't get a prescription necessarily. So the FTC mandated you give a prescription, made possible third-party eye sales, eventually companies like Warby Parker and so forth. But the possibilities created is these cuts that can create a whole industry. We tried to do that when I was in the White House with the hearing aid rule. Our thinking, frankly, started, to give credit where it's due, it started back in the Obama years as well. In the hearing aid industry is dominated by a couple firms. They sell their products for extraordinarily high prices, and one of the reasons is you needed a prescription. Go in, measure you, and here's your $3,000 a pair hearing aids, internal components, maybe $500, something like that, tight oligopoly, not much innovation. And we hoped, and we'll see how this works out, that if we made it over the counter, certain class of that could be sold, maybe could open that market. Maybe you'll start to see other companies get into it, Apple, speaker companies, just like consumer electronic companies, not medical equipment companies. So that's the kind of stuff I was looking for. And in that paper, and also the kind of stuff I think we should all be looking for. Because you can talk about saving consumers a couple of dollars with by breaking up price fixing rings, and that is important, and I think really important. But the real stakes, the big game hunt, are where you open industries that create trillions of dollars of value. Like the cut on the software, IBM's bundling of software. That wasn't a rulemaking, it was a Justice Department thing, but seeding the beginning of a software industry. What's the value of the software industry? I don't know how you measure it, but and maybe what happened, the United States created for itself a big leap forward and a big jump forward. So in software, which ultimately has arguably become one of America's most important industries. So there's a long-winded way of saying there is, I think, enormous potential in looking for these spots where, for whatever reason, there's an industry that's waiting to be born. And if we can manage to sort of midwife that through government cuts in existing industry ties, you can accomplish a great deal.
I'm going to invite questions from the audience in a couple minutes, but first I want to ask you about the official subject of this conference, which is moving beyond the consumer welfare standard.
Yeah.
Those who were here yesterday heard you describe the consumer welfare standard as basically boiling down to a competition to show whether or not prices are going to increase, and you've argued that we ought to instead focus on what you call the protection of the competitive process. Describe how that would work.
Well, I think we are beginning to move away from a strict consumer welfare sort of approach. It's not ever clear whether we fully adopted it in any case, particularly as Judge Wood said last night, in any case that is Section 2, any case that is not about collusion, but is about keeping companies out of an industry. You have, in most exclusion cases, it's very challenging to see how, and it's always been challenging to see how the test should work. So I think we are moving beyond it. I think one thing I took from yesterday's panel and also Judge Wood and Judge Easterbrook's discussion is a sense that what much of the world is wanting is something more along the something more along the lines of a set of rules or a set of presumptions, at least, that give us more guidance, more of a sense of rule of law, and are not a sort of case-by-case free-for-all. In some sense, I think that almost the more important thing is moving away from the idea that every single case is its own free-for-all and there's nothing predictable about it, as opposed to a sense, which, there is some of this in the law already, that there's a presumption as to certain behavior. And, we've done a lot of thinking in advance as to what those presumptions should be, and they can be adjusted through a common law process. But that we start with a set of rules and presumptions as to illegal conduct. And I think the older standard, the protecting competition, competitive process standard, is an appropriate way to adjust or set up those presumptions or rules. So that's how I would do it. I wrote a post on this to have a little more detail, but I do think we need to get into it. I think Carl Shapiro said, we need to work this through a lot of cases, figure out what we want to do in all these cases. But what I want to guard against, and why I feel the consumer welfare standard is something we shouldn't talk about anymore, is it does have this bad tendency of becoming a price burden on the plaintiff in every single case, even cases where it's utterly unsuitable, where the main concerns are innovation, exclusionary conduct. It just always has this risk of becoming that. And unlike Frank Easterbrook, I do think we have had a problem with under-enforcement over the last 30 or 40 years or so. And I think we need to move on.
One recurring theme that I've heard from the Biden administration and from you in your own working comments is that better economic policy and specifically better competition policy is ultimately necessary to preserve the health of our democracy. Mm-hmm. Is that something that needs to be more explicitly included in the way that we think about competition policy, or is it sufficient for it to remain sort of an implicit benefit?
That's an interesting question. I think my approach is more in the preamble than it is in the test, if that makes sense. Mm-hmm. In other words, I would like the president, when specifying his or her antitrust policy, the enforcers, when they're speaking about what they're doing, to have in mind they're interested in shared prosperity of our citizens, a sense that democracy is responsive. I think it is challenging to say, well, the test of this particular Section 2 case is whether it's going to improve democracy or not. I wouldn't say it's impossible. I think it's maybe in some cases, but I do think, from my perspective, when I think about historically the figures who responded to the challenges of their era, particularly the rise of communist revolutions, anarchy in the early 20th, anarchy as a political philosophy, not just as a disposition, in the early 20th century, were very vocal about what they were doing. They were taking on the power of unelected private corporations who felt that they had the right to govern the economy, but we wanted to show and make it clear to the people that the people are actually in charge. Those kind of thing. But that doesn't mean that's what you have to plead when you go into court. Your Honor, we're proving that people are in charge here, or something like that. It's kind of a ridiculous way to start a case, I think. And so that's kind of the way I think about it. Also in the Second New Deal, during the period of fascist, great fascist periods, or after World War II, there was very, after World War II is a great example. We ran a campaign in Germany to break up most of the German industries that had were overly centralized during the Nazi period, creating an easy command economy. And obviously it was political. Obviously the reason to do that was to prevent a re-rise of Germany. But I don't know what tests they applied exactly. But I don't think, you know what I'm saying? I think the motivation can be different than the precise legal test.
All right, let's take some questions from the audience. I have lots of questions. Start with a nod over here.
Hi, thank you. I have a question for Tim that's kind of on behalf of economists, because I know as an economist that when I was asked about 12 years ago, do I know what rulemaking is, I didn't. And now I do, because I look more closely at, statute versus rules versus cases, all this stuff. And you mentioned also, say, Andy Green in USDA, who I know back from his days in the Senate. And so I wanted to sort of ask you a couple of things. First of all, in terms of this past discussion on democracy and the, merger guidelines and all of that, I was, yesterday, you weren't here at the panel, I was looking at the original language of the Sherman Act, as well as the merger guidelines of 1996, which introduced the word efficiency for the first time into the merger guidelines, saying in particular that the purpose is to ensuring efficient allocation of resources and efficient market outcomes in free market economies, which, that's a very circular thing, because I don't even know what free market even means without rules. So in any case, so I have a couple of part questions. There's one high level and one very detailed. What is the role of agencies and their enforcement powers? Are they all just pushing FTC and DOJ, or and you from the White House or Department of Agriculture? What is it that other departments do about competition, antitrust? Do they have any role, or is it just an advocacy role in their sector, the chicken market or whatever is the market that the U.S. The Agriculture Department is interested in, for example?
Oh, that question. So the agencies, the agencies have their own statutes that give them, in many cases, the authority to promote competition or prevent harms to competition on a more industry-specific basis. Good example is the Department of Agriculture, which has statute known as Packers and Stockyards Act, which has powers that clearly go beyond Sherman Act or Clayton Act for the oversight of the packing and stockyard industries, for the meat processors. And we wanted another example of Federal Communications Commission, which has the Telecom Act of 1996, which obviously has authority and powers to promote competition, which go far beyond. What's that? Patents are another statute with its own set of complications. And the idea of the Competition Council, we had felt that sometimes agencies had been hesitant to use those powers, unfamiliar, lacking expertise, maybe sometimes lacking political will. Often, as everyone in this room knows, when you enforce competition-related measures, you make your industry angry, and they don't want it. They'd like those parts of the authority to kind of go away or be ignored. And part of what we wanted to do was make the heads of the agencies know we had their back, know also the president was going to be seeing them every 6 months on this topic, give them sort of the support. I mean, it sounds a little crazy, but support to take the measures that their statutes were asking for when the industry was not going to want to do that. Sometimes we call it the landmine approach, because sometimes we say to agencies, we think you should start enforcing this. And they're like, oh, no, that'll be standing on a landmine. And I said, we'll stand on the landmine for you, and we'll stand on so many of them that if your industry complains, we can tell them to just get in line. And, your industry might seem very big to you, but let's say alcohol. It's there's an alcohol regulator in Treasury. It's relatively, relative to them, it's a big industry relative to the alcohol regulating industry, but relative to the White House and all of us, we have
people bothering us all the time. So, the big distillery's angry. Well, get in line. There's a lot of people angry. So, we tried the political calculus was part of it. To try to turn it. So that's what we were trying to do in activating those powers. And as I said, I think we got a good job, but we got to keep it going and seek to institutionalize it.
And not just regulation, but in the case of agriculture, you actually funded new meat packers.
That's true.
New entrants into the industry.
Yeah, that was also something we wanted to do. Is not, we have a chance to move beyond. Antitrust is all about what did you do wrong and, how do you break it. So seeding new competition was something that I think agencies can do. We can fund people. We did some of this in broadband, but also in agriculture. Try to fund new entrants. There's some more creativity you can practice with rulemakings and other and spending money.
Yeah, Professor Oppenkamp.
Yeah.
Okay, you spoke very well of using unbundling to free up markets for innovation, but where does tech fit in exactly, right? We usually target markets because they have low innovation rates, fairly rigid market shares, lack of new entry, the things we generally associate with stagnation. Big tech flunks every single one of those tests. They compete rigorously against each other. Economic growth in tech is 3 to 4 times higher than it is in the old economy. There's a lot of new entry at the small level. So why all the resources to regulate, say, Amazon and not Walmart, which is equally big? Aren't we looking in the wrong place with the tech bills?
Well, I guess I'd challenge to some degree the premise of the question. One of the things I think was a thrust at a focus of at least White House Competition Council's efforts was to make the conversation not all about big tech. We had felt that the conditions of competition in agriculture were neglected, cable broadband markets, which is closer to high tech. So I just want to start at the outset that it was a sense that when we talked about antitrust, we didn't want it to be, as sometimes happens, that antitrust and tech are sought as exactly the same conversation and there's nothing beyond it. That said, I think we do think the stakes are big in the tech sphere. We think that they're in some ways more than an industry, but that the platform format makes them the essential industries of the 21st century. And so that small spillovers have much larger effects for competition across the economy. I mean, you mentioned Amazon. Amazon, they're not obviously the only platform, but let's just say the electronic selling platforms in general seem to be, have already become the place where people sell, particularly a lot of small businesses. So if we want to talk about where business happens, it's there. So it starts to get into a sort of a different topic than pure antitrust and more into the question of, what are the basic conditions of competition like over these platforms? And I think that's why it was a particularly important focus. And if you look at the Klobuchar-Grassley bill, it is in some ways an antitrust bill, but in some ways it is more of an old school common carrier style. We need to look at the conditions of competition. It might be like asking, well, in the 19th century, why are you so focused on railroads when they're so much smaller than all these other industries? Because they're the input into everything else. And that's, I think, why they get special attention.
All right, more questions in the far back there. Top row.
How much time do I have, by the way?
5 minutes.
Okay.
Thanks for taking the question. I guess it's just a follow-on to the last question. If you think about breaking these ties where they currently exist, are there a few examples of current ties that you look at and say, gee, that actually could create enormous value if we could actually break it?
That's a good question. I think that's like the ongoing mission of the Competition Council and frankly should be of academia and the people and lawyers who study these areas, is to try to find them. They're not always easy. I mean, by their nature, you don't you don't have an industry that's already there. When I think about software in the late 60s, early 70s, it was kind of a cottage joke industry. And so it's not like you were protecting something that was there. You were with that unbundling of software, you were kind of hoping or betting, or maybe they just got lucky to create something that didn't exist at all. An example where we thought we saw something was in electrical vehicle charging networks. So one of the, this is something I think we've seen, we thought there was, it's not exactly a tie, but we thought that one of the challenges for buyers of electric vehicles or for potential manufacturers was a sense that, well, if you're going to buy it, is there going to be a place to really charge my vehicle out there? So one of the things we did is spend about $8-9 billion on funding a charging network nationwide. But then I think importantly, specified that all those charges had to be non-discriminatory and had to charge anyone who came their direction. And the idea was to create a network that companies would want to build to, and then consumers would be more willing to buy. During that process, Tesla, I don't know if they carried through this. Tesla said they were going to open their network in response to this, partially because they wanted some of the money themselves. So, that's an example, I guess. I don't know if it's exactly a tie, but I just want to encourage, I guess I'll repeat it, looking for these, trying to find them. I feel like as a group, we can do better to look for these kind of things. We're used to looking for cases, bad conduct, but looking for these sort of opportunities to break open parts of the economy that have become locked up is something that we could all spend more time on.
All right, we've got time for one more, I think, there in the back of the white shirt. Yeah.
Hey, Tim. In fact, actually, the two ties that you talked about that both involve medical professionals and products is an example of a whole bunch of other ties that happen in the healthcare sector with electronic health records and wearables, physicians combined with products. That last charge to come up with a whole bunch of ideas, I think I got a whole bunch of ideas. Which relates to the question, one of the most exciting things for me about the executive order was to challenge the non-antitrust agencies to come up with pro-competitive policies. And there is a lodestar of possibilities that all the different agencies in HHS could come up with. Yeah. Susan Athey yesterday said there are lots of things that we don't know about that were happening on that space. And I was wondering if there was a little bit more that you could tell us about that.
Well, I don't think I can.
You can tell something.
I don't know if I know stuff. I don't know if I have any special knowledge of things that are coming down the pipeline. I do feel that, in line with what I said earlier, we have a strong pitch culture in the United States. People pitch cases or they bring them in private litigation. But sort of pitching rulemakings that would be helpful is something that is slightly underdeveloped in our view. I think we wanted more when I was at the White House. People to come in and say, here's what you should suggest that HHS does, or order HHS to do. Now, they might be resistant. Healthcare is big on my list of unfinished business. Maybe it'll always be that way. It is, we'd always have, be like, this is the way things are. And then we'd look at healthcare. I'm like, oh my God, things are, just like on a whole different level. You start with there's no prices. Everyone knows this who's in this area. You start with this, there's no prices. We were talking about junk fees and problems with, fees being added. We're like, well, in healthcare, they don't even have the price to begin with and get the surprise, like just a logarithmic degree worse. So, but anyway, my bottom line is I think first of all, I think White House is open to these pitches. They'd like to hear good ideas. They're hard to come by. You need economic expertise and very good legal expertise and some industry expertise to know what will work. But if you hit the jackpot, the payoff can be really big.
All right. Well, thank you very much.
Thanks. You had Dennis, what was your question? Yeah.
Whatever that means. At least the windows look good. Yeah. Okay, so good morning again, everyone. As you can see, I'm not Rana. So we have a slightly shorter panel. And first of all, I think we need to thank Rana and Howard, who made Herculean efforts to be here today. I think Howard went to the airport twice in DC in a 12-hour period, but we had very serious storms. Apparently, there was even a tornado warning yesterday that no one saw, and so they couldn't make it. So we're going to have an European panel then on the questions of ecosystems and how they challenge traditional antitrust thinking. And A.G. Cantor, who as soon as he retires from the DOJ can become the head marketing person for, I guess, many antitrust conferences, once called ecosystems a whack-a-mole monopolization machine. And I think his notion is that antitrust doesn't know very well what to do with ecosystems. And so we have a really stellar panel again. To my left is Ioannis Lianos, who is the president of the Hellenic Competition Commission and a professor of global competition law and public policy at the University College London. Then we have Sorka O'Carroll, who is the senior director on mergers at the UK Competition and Markets Authority. And then finally, we have Patrick Hey, who is a professor of economics at the University of Toulouse. And I'm Filippo Lancieri. I'm a postdoctor at the ETH Zurich Center for Law and Economics and a research fellow here at the Stigler Center. So we start with some questions directly, then we'll try to have something a bit more engaging as a discussion, and I plan to leave plenty of time for Q&A because we want to hear of all of you in the audience as well. So maybe I'll start with Ioannis. So why are we talking about ecosystems? I think you can situate us in the discussion, especially for people who are not used to it. So why is this so much on the agenda right now?
Well, thank you very much, Filippo and the Stigler Institute for the invitation, and of course, whatever I say today presents only my personal views. So I think, the idea of ecosystem is something, of course, that is an empirical reality. I mean, we have seen the emergence of business environments which are marked by modularity in production, coevolution, and decisional complexity. And to a certain extent, the literature, in particular the business literature, I would say, not so much the economic literature, developed in the 1990s a concept of ecosystem, which has had different types of definitions. I mean, some people actually have defined it in broad terms as a group of interacting firms that depend on each other's activities. Others have focused on the alignment structure that we see basically between these different partners in an ecosystem that need to interact for a focal value proposition to materialize. And of course, there has been a lot of emphasis on the role of ecosystem orchestrator, who basically determines the elements of the value chain that need to be internalized and those that basically will be supported externally so as to capture value. So in a way, there has been a lot of discussion about that in the business literature. And we have seen empirically that, a number of activities, not only the digital area, but also, in the non-digital space, are organized through these ecosystems. And to a certain extent, I mean, competition authorities had to deal with that reality, empirical reality. And somehow we saw an evolution. At the beginning, we have been referring a lot to the concept of platform, but slowly, actually, we're moving towards using more and more the concept of ecosystem rather than that of platform. And in particular, there is this kind of idea that relevant market is not just the only space or the only field where competition is exercised, but also, this is done in the context of these broader ecosystems. Now, because was a learning curve in a way for competition authorities, and at the beginning, because we have been using the concept of relevant market, we have basically been trying to identify a relevant market in which we can find power so as to trigger competition law enforcement. And this is something that somehow makes things more complicated for competition authorities. And to a certain extent, they largely ignored the development of these ecosystems. Now, of course, and we will probably have a discussion later about the different types of competition interaction we can have in this context. So we, more recently, the General Court in the Google Android case recognized the importance of inter-ecosystem competition, and in particular, let's say, the horizontal inter-ecosystem competition that exists. However, I would say there has been less focus by the competition authorities on what I would call a vertical intra-ecosystem competition, which is basically the value captured through joint collaboration between the ecosystem participants and the ecosystem orchestrator. And I would say the vertical intra-ecosystem competition has been a little bit the blind spot of existing competition law, and I think is at the core of contemporary concerns with these platform orchestrators. To a certain extent, looking to the Apple cases or Google cases. Now, of course, this is slightly changing. We have seen in the new EU Commission Market Definition Notice a specific section on digital ecosystems, so they recognize basically this reality. As I mentioned before, the court in the Google Android case as well. And to a certain extent, I think this is somehow recognized by competition authorities. Now, what I think is still contentious as a matter is a little bit how this could change our view about the role of competition law and the normative, basically, implications of that. And in a certain way, we have to recognize that value is actually generated through these various ecosystem participants who somehow contribute to the value created by this organizational value created by the ecosystem. And I think from that perspective, just focusing on the consumers might be quite reductionist in a certain way, because it will only value a specific part of the organization that somehow generates the value, but not necessarily will focus on the other ecosystem participants that I think are quite significant and important. That's, I think, why we have seen the development of specific regulatory tools to protect these ecosystem participants. And of course, the DMA is an example of that.
Thank you so much. This is perfectly on time, even before time, so it's excellent. We have all 7 minutes as before now. I'm enforcing those 7 minutes. So I'll go to Patrick. Patrick, we heard a lot about ecosystems in general, so what is an ecosystem? How do we identify one? And how we say, okay, that's an ecosystem, that is not?
It's nice to start with an easy question. The basic message is actually quite simple. Antitrust enforcement needs to move away from the notion of relevant markets. That's, I think, is the main message. Susan Haiti already yesterday emphasized that the boundaries of those relevant markets may vary from one case to another, depending on the practices and the facts of the case. But we need to go further and recognize that often, and particularly so in the digital era, customers do not choose between suppliers of a given product. What they do is they choose among platforms, as Susan put it, or ecosystems, as we tend to say more often now. Let me start with a preliminary observation about the notions of substitutes and complements. These play a key role in antitrust. We generally agree that collusion among substitutes is a bad thing. Cooperation among complements may be a good thing. The notion of substitution, supply side or demand side substitution, is at the core of the approach towards defining relevant markets. But I would like to stress that this distinction between complement and substitutes is not always very clear. Some products may be complements for some users, substitute for others. Usages may vary over time. But this distinction becomes further blurred when you take into account the fact that customers are often interested in a variety of goods and services, and moreover, value procuring multiple products from the same supplier. And therefore, purchasing decisions are driven by suppliers' assortments, not their relative positions in a given product, but the whole assortment. And they're also driven by the purchasing patterns, such as the value of one-stop shopping versus multi-stop shopping, or single homing versus multi-homing. Now, this is not really brand new. And Ioannis already hinted to the fact that the notion of ecosystem has appeared in business literature, not so much in the econ literature. I think that the economics literature indeed has a bit of a share of responsibility in the current state of affairs. The empirical industrial organization literature often focuses on specific products such as ready-to-eat cereals, mineral water, yogurts, and there has been good work done on those products. But consumers do not necessarily choose their favorite supermarkets by focusing on which yogurts those markets are offering. There is a very nice paper a couple of years ago in the American Economic Review by Thomasson and 3 other co-authors that for once stepped back and did not focus on one product category specifically, but look at covered the main product categories offered by the retail supermarkets in the UK, and also accounted for the fact that different consumers may have different shopping patterns. Some may want to have everything in one go on the Saturday, buy all the groceries on Saturday afternoon. Others are more prone to mixing and matching and getting their favorite cheese here, their favorite wine there, and so on and so on. And one of the key insights from this research is that the main driver of competition among supermarkets in the UK is precisely the competition for those one-stop shoppers, for those consumers who really want to buy everything from one store, for one visit in a given store. So it is really of first importance to take into consideration the entire range of products offered by the various firms rather than focusing on a single product category. Recognizing the role of customers' purchasing patterns, one-stops, multi-stops, single, multi-homing, and so forth, is also important to understand business practices and their impact on competition and society. In a couple of papers with Zijun Chen, we look at the implications of accounting for this heterogeneity in purchasing patterns among customers. And we show that this heterogeneity of purchasing patterns generates complementarities both within firms, but also across firms. Within firms, if one-stop shop benefits, if consumers want to buy everything in the same shop, then if I reduce the price of A, I'm more likely to attract one-stop shoppers to my store, and I can sell them B, C, D, and so forth. But also, if I have a strong strong position in A, and Sorka has a stronger position in B, if I reduce the price of my strong product, that may induce at the margin some consumers to move from one-stop to multi-stop and buy my good product A and then visit her store to buy her product B. And therefore, it means that my A and her B can also be complements. Of course, for one-stop shoppers, the situation would be quite different. So you have this interplay of the way consumers will view different offerings, and the same product may be complements for some types of consumers and substitute for others. And accounting for this can provide rationale for practices such as loss leading, for example, even in the absence of any behavioral or informational problems, as the literature usually assumed in order to provide a rationale for those practices. You can also provide a rationale for cross-subsidization, even in competitive and possibly highly competitive industries, whereas otherwise typically it is presumed that you need market power to have cross-subsidization. When you account for those kind of shopping patterns and so on, you have very different types of insights. So just a couple of examples that show that moving away from focusing on a single product and looking at the entire range of products, can be really key to have a better understanding of what is going on there. And this is all this without accounting for the fact that contrary to supermarkets are simple in that sense. If you look at digital ecosystems, as Ioannis already pointed out, you have a multitude of players, industry players that are involved in various forms of co-opetition. They cooperate on some dimensions and compete on others. So in a nutshell, we need to move from markets to ecosystems, both in academics and in antitrust enforcement circles.
Thank you. Also, perfectly on time. So, Sarka, you're probably the regulator most at the forefront of the ecosystem discussion. It's impressive how much the CMA has been doing. So how do you think about theories of harm involving ecosystems in specific cases? How would you articulate what are you looking for in cases, say this is a bad case versus this is a good case involving an ecosystem?
Thanks, Filippo. And just to note, I'm speaking in my personal capacity as opposed to necessarily reflecting the views of the CMA. So I think, stepping back, fundamentally with merger control, I think it's an exercise of trying to understand how markets operate, how the specific companies that we're looking at operate, and then trying to think about how the transaction might change competition in that market. And when we think about ecosystems, this is a concept that's coming out of how the companies themselves have been developing, and that they see some value in having and developing an ecosystem. In terms of theories of harm, and this, I don't think you can necessarily have an exhaustive approach to this, because I think people are still trying to understand what this means and how it plays out in markets. But I think when we talk about an ecosystem theory of harm, we're typically talking about a concern that a company that has an ecosystem and that has market power is acquiring another company, and that as a result, there may be harms such as raising barriers to entry or raising rivals' costs, and that can have a problematic effect on competition. I think those types of harms are not new or novel in themselves. They're things that we've thought about in the past. And I think in terms of how you might assess an ecosystem theory of harm, I think certainly as a starting point, I would expect that at least one approach is to apply, again, the quite familiar ability incentive effect framework, which is how we would generally approach conglomerate type theories of harm in merger control. In terms of what might be notable or different when we think about some of these ecosystem theories of harm, I think the first point I'd make, and this isn't necessarily new or radical, but I think for competition agencies, having looked back at some of the approaches in digital mergers in the past, there's maybe been an appreciation that agencies hadn't fully understood business strategies and the rationales for mergers and so forth. And there's the Lear ex post review of digital mergers that was done in the UK that talked about the importance of focusing on the company's business models and monetization strategies and really properly getting to grips with those things. And I think that plays through in terms of thinking about what a digital ecosystem theory of harm might look like. I think the second thing I would point to is the time horizon in which you're assessing potential harm from a merger. And I think this goes perhaps to concepts of a potential efficiency offense. And it is entirely possible that a merger could result in some short-term efficiencies, but could also have a longer-term effect on competition that could raise concerns. You might have a short-term efficiency, but if you have increased barriers to entry that reduce competition over time, that overall effect could in fact be harmful to competition and to consumers. And I'd point to the CMA's merger assessment guidelines, which were updated in 2020. And the guidelines do say that the CMA will consider the impact of foreclosure on potential competitors through raising barriers to entry, where the negative impact on customers may take some time to materialize. I think the third thing I point to in terms of what might be notable about these theories of harm is that oftentimes we are talking about these harms or these theories of harm potentially arising in markets where innovation is a key parameter of competition, and markets that may be characterized by existing barriers to entry, such as network effects and so forth. Obviously, that's not unique to thinking about ecosystem theories of harm, but I think those factors may well be present. And so I think that means a number of things. It means that you may be looking at a theory of harm in a market where dynamic competition and the effect of the transaction on future innovation is particularly significant. And I think there is now precedent from the UK Competition Appeal Tribunal in the Facebook Giphy case that's confirmed that a weakening of dynamic competition is capable of being sufficient to amount to a substantial lessening of competition, which is certainly a position that the CMA had held prior to that case. I think another just general characteristic of looking at markets that are evolving and looking at markets where you might be thinking about dynamic competition is that there's a degree of uncertainty. There's always a degree of uncertainty in merger control because it's a forward-looking assessment of markets. That's probably a bit easier when a market has not changed terribly much in the last 5 years and is likely to be relatively similar, but for the transaction going forward. I'd suggest that there is no special evidential burden or standard that applies to these types of markets. And I think also the uncertainty about the outcome of dynamic competition doesn't mean that the loss of such competition cannot be harmful, because with dynamic competition, it's that process of innovation, that threat of potential entry that's often driving the competitive effects, and not necessarily the absolute realization of it, because innovation is inherently uncertain. And I think the final thing, when we are talking about markets that are characterized potentially by existing barriers to entry, that are characterized by innovation as a key parameter of competition, if there's a concern about raising barriers to entry, I think that's a concern that what's going to happen is that you are going to lessen the likelihood of disruptive innovation in that market, lessen the likelihood of new product, services, et cetera, being brought to consumers. And I think that is a significant harm for agencies to consider. That's not to say that ecosystems always lead to bad outcomes. I think ecosystems can lead to good outcomes, but I think there is something for agencies to grapple with in terms of how these do affect markets and how mergers might change those ecosystems or change the competitive dynamics.
Okay, thank you. No, this is terrific. Again, perfectly on time. So what I think about this whole ecosystem discussion is that it's both at the same time very important, but very abstract. So I wanted to start, we were in the morning here, we had a long day yesterday, with a show of hands. So I'm going to give you some names of companies, and you tell me whether you think it's an ecosystem or not. And this applies to the panel, it applies as well to the audience. So please, let's go ahead. So the Apple iOS, who thinks that is an ecosystem? Okay. Google Android. The Apple App Store. No? Okay, so you can have ecosystem within ecosystem. Facebook. No, maybe? Okay. Instagram?
It's part of the ecosystem.
It's part of the ecosystem, but not... Okay. Snapchat, is it related to size or not related to size? No? Yeah, some people, okay.
Remember, you should not focus on a single market, right? Single product.
No, but I'm thinking of the company, that's exactly what I'm asking. So is Uber, does Uber have its own ecosystem or, yeah? Amazon, I guess. And the final one. Is Walmart an ecosystem? Yes, no? Okay, so I think there's a more variation than I would think. So how do we separate an ecosystem from the good old, I think connecting to Patrick's question, just good old one-stop shop, like shopping mall or supermarket? Is it something about the network effects that hold it together? Is it something about necessarily the behavior of consumers, so we cannot have a general theory about an ecosystem? You have always to look at like specific cases. How would you start? And maybe you'll start with you, Johannes, and then we move along.
Yeah, I think it's a very good question. I think I will distinguish ecosystems for, in clusters or industrial clusters. This literature in economics about that, but the fact that these are about non-generic complementarities that are basically created in this context, as opposed to generic complementarities that could possibly be, the characteristic of an industrial cluster. And in terms of the supply chain, I would say that the difference here is that you don't really have an input-output process, clearly defined, in the sense that in the vertical complementarity perspective, because of the reasons that what Patrick mentioned in terms of what is a complement is actually much broader, and of course through the data kind of influence, this idea of complementarity is actually quite broader. So it will not be an classic input-output process as you have in the context of a supply chain, for instance. And of course here, the idea is that in the context of a supply chain, the power of Walmart will be on a specific market in terms of selling products to final consumers. In the context of an ecosystem, power actually comes from the presence in different markets at the same time, and it doesn't necessarily come from resource dependency. It might come from, let's say, the positioning of a specific company in the context of a broader ecosystem. In terms of that, they are able to control the agenda of the ecosystem, in a sense, who does what. They are able to determine, the allocation of tasks in the context of the ecosystem. They are able actually to have information that comes out from the different parts of the ecosystem, sensitive information that enables them to have a important learning kind of effect power, in a sense, from that perspective. So, I would say this probably differentiates, the ecosystem from industrial clusters and then from supply chains, like traditional supply chains.
Okay. Sorka, do you agree, or do you think that ecosystem is just like a pornography, obscenity here in the US? It's just like, I know it when I see it, and you cannot have a general principle for it.
I guess I think there's maybe a danger in trying to put too much weight on what exactly is an ecosystem. I think when we talk about ecosystems, we're trying to think about how particular markets are operating and how we can better understand them. And we're typically, I think at the moment, trying to grapple with the complexity of markets where companies potentially have disparate services or products within a system that are serving a group of customers. I think they're not necessarily, there's maybe a degree of natural interrelationship between groceries in terms that people are saying, I want to go to one place and get my milk and cereal and juice, which I think is a somewhat different dynamic than when we look at a platform that's bringing quite different services together that isn't necessarily responding to quite the same demand pattern from individuals. And I think it's, when we talk about ecosystems in that context, I think it's an effort to try to understand why are these disparate things together? What does it mean to have those operate within a system? How does that affect competition? I think that's a somewhat different dynamic.
Patrick, what do you think? So I think half the room said that Uber was an ecosystem. As far as I understand, Uber delivers two products, which is ride-hailing and food, or actually food delivery. Would you agree that's an ecosystem or not, and why?
I've carefully tried to avoid putting labels or defining labels in my opening statement, and I'll try to stick to this as much as possible. You mentioned Walmart versus Amazon. So in both cases, there are issues the study I mentioned is specifically a study of good old brick and mortar supermarkets in the UK, and there are already some issues that are worth exploring there. Now, if you compare this traditional good old brick and mortar supermarket with Amazon on top of doing what a supermarket does, it acts as a marketplace, so it would be more like a mall in that respect than a supermarket. But at the same time, it also has its own shop within the mall. It has also its private label. So it's if we look at the theory of the firm, it's a good model to try to see the various the ways in which some decisions are sometimes taken by the firm, sometimes delegated to others, and so forth. It provides logistics systems that the third-party suppliers may or may not rely upon. It collects data. It is in a position to determine which suppliers are worthy or not, and can provide short-term financial services to that supplier. So it's a matter of a scale in the breadth of the ranges of goods and services that are provided. So it's more of a matter of scale, I would say, than a matter of inherently the difference in nature.
Okay, and is this something that we define ex ante, the boundaries of the ecosystem? We look at Amazon and say, like, no, or is this something that you're always going to have to go case by case analysis and say, okay,
I'm more interested in the type of issues that that are key in this or that industry. Then I'm putting labels or defining.
No, I understand.
Putting them in boxes.
I mean, I'm trying to play a skeptic role here, and I think that's important. I think my main concern with the ecosystem discussion is that we move from a whack-a-mole monopolization machine where we don't know what we are doing to a, let's say, ultra-differential enforcement machine where we just define, we don't define markets anymore. We just define what an ecosystem is by looking at the case. We don't, we articulate many different theories of harm, and then ultimately regulators have a lot of leeway to decide whether this is a good or bad outcome for a case. So I want to understand. That's why I'm trying to push you guys to articulate a bit more on this.
Is the same risk that you have with the market definition concept? I mean, you can always make the comment that, of course, we don't never do that in the Great Competition Authority, but of a regulator somehow defining a market narrowly. I mean, the aftermarket type of concept could be possibly an example of how you can just go and define very, very narrowly a market if you want. I mean, the tool of the relevant market can also be abused in the same way as the concept of ecosystem or any other concept. So I don't think just by mentioning that there could be some form of abuse, you can criticize the concept itself.
No, I'm not. I think that's fair enough. Yeah, please go ahead.
I mean, I think the way you've posited that question sort of suggests an infinite elasticity to how things operate. And I would come back to, I think market definition, for instance, is a tool. It's an effort, it's something that we can potentially use to better understand competitive dynamics in a market as opposed to sort of an end in itself. And I think with the ecosystem concept, I think that is an effort to try to understand competitive dynamics, but I think you're still coming back to this question of looking at what the evidence tells you about how companies are competing today, how and sometimes when we say competing today, there is a prospective aspect to that because it's dynamic competition, and trying to understand how the merger might change that going forward. And I think trying to understand an ecosystem, in some ways, I think what we're talking about is a conglomerate style concern, which is not, entirely exotic or unheard of in terms of different things coming together. And I think some of the, questions, if you do, for instance, take the ability incentive effect framework, that is not an unfamiliar framework in merger control. As a result of this acquisition, would their ability to foreclose competitors or raise barriers to entry change? Would the incentive to do so change? And what actually would then happen as a result? What would the effect be in the market? I don't think it's straightforward, but I don't think it's completely novel or approach to assessing the transaction.
No, that's fair enough. Patrick, anything to add, or do you want to?
Well, as I said, I'm more interested in trying to understand the issues that arise. To give you two contrasting examples. So there is this debate going on about the so-called tax that Apple or Google or its Android platform is charging to developers. The 30% tax. The parties have argued that competition acts as a discipline device, and therefore they have all the incentives to get it right. Otherwise, they will not be able to attract consumers in the first place. The agencies, including one that is close at the moment, tend to argue instead that competition doesn't seem to be very active. There is little switching among consumers. It doesn't seem to be the case that competition is really particularly strong here. In an ongoing project with Doshin Jeong, coming soon, will be available shortly. We have looked at this, and what we find that actually competition may be the source of the problem rather than the cure. So the question is not whether if the competition is too weak or not. It's that there is competition, and if there is competition, what is the incentive of one platform to encourage the development of apps that will end up being available on the rival platform as well? So it does not really contribute to enhance their relative differentiation, added value. It's interesting to look at the situation in the Chinese market. So you have there, Apple is not in China. You have multiple Chinese manufacturers of smartphones, all mostly on the Android platform, each one with its own app store, and the tax there is not 30%; it's 50%. So you have more competition, and you have even higher commissions. So maybe the approach to this may not be to try to foster competition for consumers, but maybe competition among the app stores themselves, within the platform. That may be a possible way into some form of kind of price regulation, fair pricing or whatever. Maybe, I don't know, like in the DMA, there is a provision going in this direction. That may be a better way. Competition doesn't seem to be the right way out here. It is competition among platforms, within the platform maybe. Contrast this with Amazon has been, the dual role of empire and player has been put forward. So the Amazon acts as a marketplace, but it's also the regulator of this marketplace, and also on this marketplace, it's also present as one of the players among the others. There has been this so-called hold-up policy that has been questioned, or Amazon stepping in when there is a particularly profitable, successful product, copycatting, introducing a Me Too, and so on. Well, if you step back, you can look at this as one way of one more instrument in the private regulator's toolbox of the toolbox of Amazon as a private regulator of its platform. It means that it puts a cap on the profitability of the successful products. It means that there is a transfer from those products to consumers, which will attract consumers, which in turn will benefit to the other sellers on the platform. So the question, maybe a better way of looking or assessing the impact of this type of practice is to see to what extent private regulators' incentive and what would be a public regulator's incentive or objective are the extent to which they are aligned. And as well, we have another project on this with Doshin, which says, the private regulator does a pretty good job. It's not perfectly aligned with what a public regulator would do, but it's not necessarily compared with no private regulation whatsoever. That may not be the right way. So you really have to look at what are the issues that arise.
Yeah, but let me just build and then I get to you. But I think everybody would agree in an antitrust conference that the main question is how do you define competition? But we have tools like relevant market definition and others to try to shape our approach to thinking about these topics. So almost everybody here agreed that Apple iOS and Android are two ecosystems in themselves. But then when you see cases that involve app stores, many times what you see is that regulators exclude these as two competitive matters. So the Dutch, for example, they have a report about Apple app stores where they basically say these are not two competing platforms, they're basically two monopolies that compete at each other at some level. So I think that the question that arises exactly is I'm perfectly fine with abandoning relevant market definition. I don't have any fetish on that. But then how do you articulate these theories of harm in terms of competition? Do ecosystems mostly compete against each other? Do they mostly compete against their own complementors? And if you find some kind of violation, does it mean that you can, in one complementor, just intervene in the whole ecosystem, the ecosystem as a whole? So how would you think about it?
I mean, I think the concept is useful. First, I mean, empirically, I mean, a lot of value is now generated in ecosystems. So from that perspective, there's value generated with these complementarities that are somehow put in place by the first. But I think that's not really the focus here. I would say what is really bringing this new concept, I mean, this concept is this focus on the capture of surplus value, in the sense of distribution, basically, of value. I think that's I think why, from my perspective, this concept is useful. And there, of course, you might have the, intra-ecosystem horizontal competition, in the sense that, the platform can also be a merchant, so they can basically compete horizontally with their complementary, with the complements. But I think the other aspect, which possibly the relevant market concept could not necessarily take into account, is what I call the intra-ecosystem vertical competition. In the sense, what is the fair, basically, allocation of value between the various participants in the ecosystem. And this is not necessarily, a traditional competition concept in the US, where you don't really focus on exploitation. It can definitely be something that, from a European perspective, could be interesting, because we actually are, focusing on exploitation. And to a certain extent, the regulatory tools that we have developed, because to deal with the ecosystems, and in particular the surplus value issue, you cannot necessarily only use a competition tool. I mean, it's a toolkit approach, and this is more or less what the European Union has been promoting. I mean, it's actually a combination of tools. So the competition enforcement, which obviously has a number of issues with regards to the length of time that you need in order to be able to intervene, and what can actually have as an outcome. But at the same time, we have the Digital Markets Act, which is basically sort of utilities-like regulation, not in the sense of entry or tariffs, but in the sense of specific types of conduct that could be problematic if done by the gatekeepers. Okay, and then the Data Act, which actually deals with situations where you don't really have this kind of gatekeepers, but there is some form of unequal bargaining, right, between the platform and the complementers. So, which actually shows that one of the the issues here is about the fairness aspect, and this is why I think the concept of ecosystem could be of interest. So, not necessarily completely agree with Patrick in that perspective. Yeah.
So, do you agree? So, when you look at a case, would you look at what is the fairness of the internal distribution, or?
So, I might just come back first to your initial question, because I think you're asking, what is the market, and is this about ecosystems competing with each other? And I don't think that's typically the question that's being asked. What we're talking about with an ecosystem is actually a firm that has positions in multiple different markets, and what the sum of those positions mean in terms of the potential market power of that firm. And there may be places where actually having positions in multiple markets and bringing those together in itself results in a degree of market power. And I think a few years ago, we looked at a case, Google Looker, and it was a phase 1 clearance. But one comment made in that case was about Google's position in advertising and in some of the data analytics and so forth, and that those things together resulted in a degree of power as a result of its ecosystem position. So this isn't, you could say, when people are buying phones, they're buying into ecosystems, and there's a degree of duality there. But I think what we're talking about here primarily is not that, but rather when someone is present in those multiple markets and they add another likely disparate entity or market or product to that system, what does that mean for the overall system? What does that mean in terms of the ability of someone to enter one of those markets competitively? Does that make it harder in one of those markets? And does that mean as a whole that you're lessening competition. I think realistically, if you've got a company that's present across 8 or 10 different markets and has a degree of market power, the point of entry is probably not going to be someone who jumps into 8 or 10 markets simultaneously and replicates that company. It's going to be probably entry in, one of those markets, or actually entry in a slightly different adjacent space that starts to pull away some of the existing consumers. And that type of disruptive innovation, I think, is what's actually characterized a lot of these markets over time, where people have come in and entered and developed. It's not necessarily been with a duplicate of what's existed already, but rather with a slightly different proposition, potentially in a slightly different market that started to change the overall dynamics. And so I think that is kind of the concept that we're grappling with, and the question that we're asking ourselves as we look at transactions, and also as we look at behavioral and other.
Yeah, I wanted to ask you this. So, you think the rationale is the same if you're looking at a merger, or if you're looking at like a natural expansion to an adjacent market? So, if there's no acquisition, would you look at exactly the same things and have the same theory, or no?
Well, I mean, I think fundamentally, a firm developing something for itself is often a competitive response in a different way that an acquisition of a target is a competitive response. I think, the concern with an acquisition of a target can be that they're preventing competition from developing, or they're preventing others from accessing something, et cetera. When you look at a firm that's developing something new on its own, oftentimes that itself is an output of competition in the market and that firm responding to things. So I think, I don't think as a competition agency, we typically assess someone's innovation as a potential problem. I think once there has been innovation, if a firm has a terribly big position, the innovation isn't the problem. You may look at how that position's being exploited, but that's, something probably a long way down the line and quite different.
Patrick.
First, a brief comment on you refer to the Dutch reports saying there is little competition among those platforms, and so on. In the research conducted with Doshinan, what we found is that the degree of competition, or the degree of substitution between platforms, so the degree to which consumers would be willing to switch from one to another, is not really one of the main drivers of the level of the tax that they would charge to developers. A more important driver would be the extent to which developers develop their apps for multiple platforms as opposed to developing their apps for one particular platform. So the degree of intrinsic multi-homing, in the sense that the decision to develop an app is made on the overall profitability that they can get across all the platforms, that's really what matters. And the more important that dimension is, the more likely you have to have that competition is not going to work, whatever the degree of switching that you may have on the consumer side. On conglomerates, when you enter multiple markets, so again, you may provide some kind of consumption synergies and one-stop-shop benefits, which is good for consumers. So there might be some efficiency benefits. At the same time, it may create some differentiation, some portfolio differentiation between the kind of a portfolio that the conglomerate will be able to offer, as opposed to the standalone firms that are competing more, specializing on given markets. So that may create some market power in that sense by creating this kind of portfolio differentiation. We have another project ongoing with Zijun, and I did not say this one is going to come up shortly, but we are still working on it. Preliminary findings show that as long as you don't have pure bundling, as long as the conglomerate still offers the various products on a standalone basis, this portfolio differentiation is not that too problematic, except if you really have high degree of market power in given some of those individual markets. So the last comment I would like to make is prompted by your last intervention about how do you enter? Well, how would you manage to enter, and so on? It's true, again, and Susan also alluded to this. I'm going back to substitutes, the reliance of substitutes. The typical, if you look at potential entry, usually the good potential entrants are the ones who would be really close to the incumbents because they are the ones who are most likely to impose some effective competitive pressure on the incumbent. If you introduce network effects, as you know, which is often relevant in the context of digital ecosystem, if everyone is already on this social media, if I come up with an alternative social media which is really a replica of what is existing, it's unlikely that I will convince the consumers to switch, all together from the platform where they are currently to my own platform. It's more likely that I will be able to attract some of those consumers if I come up with something that is quite different from what is existing. So, the more away from the existing one, the more likely I may be to start winning some consumers and then start the ball rolling and so on, and maybe eventually I will be able to challenge the incumbent. So, it's when you take this those network effects and scale economies can be another, the role of data may be another important aspect. When you take this into account, you may come up with a different type of views on the scope, what would be the relevant source of potential competition, for example.
Well, what does this mean? Sorry, I'll come to you. What does this mean for theories of harm as well? Because one would think that one of the main sources of efficiency in large digital markets is exactly when the very large platform adopts a product and distributes to 3 billion users at the same time rather than this fringe competitor. So if I understand more or less what you say is that we should be less worried about when platforms are entering very adjacent markets than when they're actually entering more distant markets, which could potentially develop into more meaningful competitor in the long term. Is this what you're meaning or not at all?
What I'm saying is that when you take into account some of the features that are prevalent salient in those industries, like the role of network effects, then you may want to revisit your views about what would be the source, what it would be the role, the nature of an effective potential competition. That's all what I'm.
Yeah. Sorry, you wanted to jump in and I cut you.
I want to say just, of course, inter-ecosystem competition is important, and to a certain extent, it's an empirical issue each time. In the Android case, the court, and I was just reading now. Basically, discussed if there was a competitive pressure between Apple and Google, and basically they said, well, that's not the case because they had these revenue sharing agreements that was conditional on Google search being set as a default on Apple's mobile internet browser, Safari. And as a result of that, there was no incentive to operate on those markets and compete, Google says. So in a way, the inter-ecosystem competition was actually taken into account by the court. Now, it might be, and obviously said that it was not sufficient. It might be that in some situations, it could possibly, be possible to make an argument that there is sufficient inter-ecosystem competition that, to a certain extent, could possibly provide opportunities for switching of, or multi, ecosystem homing to a certain extent. But again, this is an empirical issue depending on the facts of each case in this context.
And which facts would you look for?
Christina wants to come in.
Sorry, Christina has been dying. So
discussion is so confused and confusing. I don't know what the audience is beginning to think. Can I say something?
Of course, let's just wait for a microphone so you can jump in.
I just can look at the faces and everybody's saying, what on earth are they talking about? And I get it because no one has the faintest idea. You're all talking across purposes. And the important thing is the framing here. Okay. In antitrust, and I mean conduct, we have tools that we use. We don't need to just go off into ecosystem theories because when it comes to App Store, when it comes to Amazon, when it comes to these conduct concerns, we have the tools, we know what we're talking about. No one in a serious way is suggesting we should switch to some sort of ethereal ecosystem theories. I know that Yanis, who talks a lot to his strategic management friends, likes to talk about capturing value, value creation. That's stuff in the strategic management literature that no one in antitrust cares about. So that is the point, number one. Number two, the only reason we're talking about this at all, and it's topical, is because of what Sorka says. Because there are deals now in front of the agencies which are deals in which digital platforms are buying an asset or a capability which is not in their main market. And so what the agencies are doing, and what Surka rightly is saying, is, okay, we have theories of harm that are horizontal, vertical, conglomerate. The vertical and conglomerate tend to rely traditionally on leveraging mechanisms, okay? I have a tie, I have a bundle, I have a raising rivals cost, I have a mechanism for raising power from market A to market B. What if I want to go beyond that? And I ask myself, okay, you're big company X, you have a position in cloud, you're very big, you have a position in operating system, you have a position in some sort of storefront, you have a position in something, and you're buying something else. How do I think as a regulator of this collection of assets and capabilities that you control? I'm not suggesting you're going to tie A and B or bundle A and B, but do I need to worry about the fact that you have all these levers that you can pull and you can create bottlenecks and some sort of barriers to entry through the variety of assets that you hold? Q, Microsoft Activision. Q, iRobot, Amazon. These are the deals, and I confess I haven't, of course, I've disclosed, I've advised Microsoft on this. I've got no role in Amazon, so just to be clear. But these are the questions, nothing else relevant. This is why we're discussing this at all, because no one is really out there talking about an ecosystem antitrust conduct theory. It is really about this. And the question is, A, can the IO economists kind of think about a way of developing economics that is actually important and relevant to this? Because what the agencies are saying is, I haven't got a way of articulating this concern about multiple assets. Because rightly or wrongly, the defendant says, sorry, what's your problem? You've got assets, you've got stuff, is not a theory of harm. Kind of, yeah, I get that. You've got stuff is not a theory of harm. So how does this stuff gel and make the souffle rise? This is the question they're grappling with, the FTC is grappling with, and this is what they need an answer to from economists. The strategic management people, frankly, can only talk about value capture, blah. And I don't think the answer is coming from that. Last point, the network economics people are interesting. Watch this space, because they are the only one who are beginning to say, oh, in fact, there are networks of assets and capabilities. A merger isn't buying a product. It's not the market share of product X you're buying. Particularly in these kind of worlds, you are buying a set of assets that you plonk into your own constellation of assets and capabilities, and those combine into something that can be good, can be less good. That's how we find out. How do we find out? This is the only relevant question in all of this, and that's why we're talking about this.
I guess you disagree. So
definitely
if you have more
disagree.
questions,
I mean,
feel free.
It depends on which type of debate. I mean, definitely the competition field, yes, it is a relevant question. But here we don't have to deal only with competition law enforcement intervention. I mean, how can you explain the DMA if you actually, basically say that, fairness is not an issue? I mean, fairness, it is an issue in the DMA. So for competition law enforcement, yes, I agree. I mean, definitely, that might be, although I have to say as well, that we have unfair commercial practices type of possible theories of conduct in the EU competition law, which could possibly be used in this context, and therefore the fairness aspect also comes through that type of theories of harm, which Christina has been mostly focusing on exclusionary type of theories of harm, as far as I understand.
Sarka, what do you think of fairness? This fairness discussion in ecosystem, is it valuable as well, or should only be looking at exclusion?
I mean, I guess I'm coming at this from a merger control perspective, and that is where I would think about ecosystems. And so I don't think that that is about fairness primarily. That is about, this question of what, when we've got a company that has an existing ecosystem and market power, what does the addition of another entity mean? And how is that going to change the dynamic? And is that going to substantially change the competitive power of the company? Is it going to make it harder for people to compete? And I don't think those are fairness considerations. I think those are, to some extent, bog standard competition concerns. Is there a substantial lessening of competition? What's not bog standard is the fact that, it's a different way of trying to look at or conceptualize things, which is not, about the competition agencies inventing something. It's about the competition agencies looking at how these businesses are operating in the markets. And while we may not have, I think to Christina's point, great maths on this so far. I think when you look at companies and how they're operating, when you look at things like internal documents and strategy and so forth, you can see that companies themselves often think that there is value and benefit in these things, and may in fact have said things that indicate that they do think that these ecosystems, create a moat, lessen the likelihood of competition. And I think when a company is engaging in an acquisition in order to build a moat to a competition agency, you start to sit down and think, well, that sounds an awful lot like making it harder for people to enter. And if that's the case, that's potentially something concerning to us. And, that's potentially concerning even if there are some short-term benefits, which, there may be a degree of benefit. And at that point, you're doing an exercise of trying to understand what the overall effect of the transaction is.
If you have any questions, please go ahead. I'll ask something. So you mentioned the LIAR. Oh, sorry, please go ahead, Patrick.
I think that as Johannes mentioned, I think the DMA is interested in other issues than the ones you raised. But you're right that this idea that combining multiple products on the same roof may trigger some questions that have been overlooked at the moment. You can have, again, the fact that consumers may value having everything from one supplier may convey more power to the ones who manage to offer more products to those consumers. The role of data, I'm surprised that it has not been really emphasized so far in the discussion, but if you collect more additional pieces of data, thanks to by offering a different type of products and so on, and you can use this data in other markets on which you are always actually, that also may be something that needs to be accounted for a bit more. So we need more of that I agree.
So you mentioned the LIAR report, which analyzed the Facebook-Instagram mergers. Let's try to discuss a concrete case. And basically, the main conclusion of the report is that the CMA of ecosystem and capabilities and etc. would have. Do you think it would have fundamentally shifted the result of the case? How would be the shift?
I mean, from my perspective, the German Facebook case, which is basically an exploitation case, and this is a little bit also, coming a little bit to the perspective that it's not just about exclusion. What was the remedy in this case? It was basically an ecosystem separation, data separation remedy, but because of this exploitative element. So fairness and exploitation are important elements that we need to take into account, we can do that in the context of the obviously regulatory interventions like the DMA, possibly also in competition enforcement interventions. For instance, even in merger cases. Theoretically, by being able to add a specific type of activity which enables you to collect data and be able to exploit more, either freelancers or users, etc., is possibly a theory of harm that could be used also to block a merger in this context, or preferably actually to impose some form of data ecosystem separation remedy. But that would be an exploitation concern rather than exclusionary concern. Mm-hmm. Only, it could be basically both, what I'm saying, but not only just exclusionary. So
I'm not convinced that you need to start thinking about an ecosystem theory of harm. I think relitigating Facebook, Instagram is always, we all love to do it, but I think trying to go back in time and think about exactly what people understood at that time and would it be different, I think is quite difficult. But when you look at reasons that perhaps Facebook, things that could have been done differently in Facebook. I don't think my starting point would be that the agency should have looked at an ecosystem theory of harm. I think some of the issues that came up there were around perhaps how well digital advertising markets were understood. And when agencies were looking at what it meant to combine Instagram and its potential opportunity to sell digital advertising. Did agencies really understand what was of value there, what was really being monetized, and the extent of what was being brought together in that transaction? perhaps were to somewhat unique assets that would target the same user bases and so forth. And I think that is a more standard type of question on a horizontal. And I don't think you need to get into an ecosystem theory of harm. I think there were also questions around how foreclosure had been assessed. And again, I think it was about how well the business models and the operation in the market were understood, but it wasn't something terribly exotic. It was about I think Instagram was seen, certainly in the OFT, which was our predecessor's decision, largely as a photo sharing app, which I think is probably not quite what we think Instagram is today. But one of the questions was whether that photo sharing capability could be cut off to other social networks, and that would be sort of foreclosure. And I think the assessment at the time was that basically Instagram users like to share with other social networks, so that there wouldn't, that wasn't realistic. And I think some of the criticism there was, whether there had really been an assessment done as to how important the ability to share across networks was to Instagram users, which, if it wasn't terribly important, your ability to engage in foreclosure would be different. And so, I think ecosystem theories of harm are interesting because they potentially allow us to think about something that we're not well able to think about in some of the more traditional approaches we've taken to things. But I don't think that means that you always would want to go to an ecosystem theory of harm, including in a case where the merging party might actually have an ecosystem. Most cases are about horizontals, they're about verticals, they're about theories of harm on that basis. I mean, today, looking at the Facebook sort of how Facebook exists, what we say Instagram is part of an ecosystem, we might say that, but I don't think that means it was necessarily the most salient theory of harm at the time of that acquisition.
Patrick, what do you think? Nothing to?
No, I think that's not my main comparative advantage compared to legal scholars.
That's fair enough. And so, and just to understand, so you think that these are the capabilities that Christina is mentioning in the discussion exactly? It's like the ability to, monetize data, to collect. So how would you see as like key capabilities that you look at in a concrete case as defining features of competition in a given market or in a given ecosystem? So exactly what are capabilities? That's my question. So how would you define what a capability is?
I mean, I think when we're talking about an I don't think that the concept of ecosystem is defined by specific capabilities that exist. I think, it's perhaps hard to come up with wild examples, but, that fundamental idea that positions across multiple markets sum up to create a degree of power, and that has effects across markets. I don't think that's about, necessarily is that because people have exclusive access to particular data, even if we say a lot of ecosystems may actually involve companies that have significant data advantages. I don't think that the things like that are what's defining the ecosystem. I think it's this very basic point about the positions across multiple markets, and are they coming together in a way that's creating market power that, I think Christina's point is fair, that it's not about leveraging in the sort of old school, I have a product, I've got a product in an adjacent market, I'm going to bundle them together, or I'm going to, do a traditional tie. It's looking at sort of less direct interconnections between those positions and the degree of power that's creating.
I wanted to finish the discussion on the questions. I mean, you mentioned the DMA and the DSA and others about this distinction between what can antitrust do versus what regulation should do. And then you mentioned a lot of these questions about anti-discrimination. So how do you see, is the boundary between the Facebook German case, which is ultimately an exploitative case, and what the DMA is trying to do? And for example, in Sorka, it's like the CMA has been trying to get more regulatory powers and has not yet, but maybe we'll get soon, who knows? So how much can you think you can accomplish with today's systems versus what it should be?
I mean, obviously, it's too early to say. Because these regulatory initiatives that just been in the process of being implemented. And I think what is interesting is also to have experimentation going on. I mean, in particular, you have specific countries in Europe, like Germany, that have tried with on Article 19A of the German Competition Act to basically deal with this reality of ecosystem without using the word ecosystem. But of course, it's basically about having some form of provision or expose basically competition enforcement that could deal with abuse of ecosystem power. We in Greece actually tried to do the same. Unfortunately, did not. The Parliament actually did not adopt the proposal that we framed. And of course, you have other tools like the market investigation reference tool, what the UK has and Germany is now adopting, and of course other jurisdictions as well have already, which could deal with these possible theories of harm in the context of ecosystems, both exclusory as well as explorative. So I think there's already quite a elaborate toolkit. It's not entirely clear how this will interact with the competition enforcement, exposed competition enforcement. But again, at least on the European side, I think there is a very, elaborate toolkit approach, which might deal with all possible theories of harm, both exclusionary and explorative, in the context of ecosystem. Now, the question is, are other jurisdictions going to adopt equivalent type of toolkit approaches? I mean, is exploitation going to be a concern in the US, for instance? Because of course, I fully, accept the exclusionary potential and possible theories of harm that from exclusionary perspective. But I think one of the defining features of the European approach is also this emphasis on fairness.
Patrick, you mentioned when you're discussing, the bullet points, you said that antitrust may be too slow and regulation is too rigid. So how do you find the spots for intervention there?
Let's see, in the Intel case started in which year already? Remind me.
Many years ago.
So and it's still ongoing on. And so yes, antitrust can be a bit slow. So recognizing this, we went for the DMA option. So we went for a regulatory approach. My concern with this is that so you have the DMA. So some people will say this is the shopping list of all the cases that the Commission would have loved to be able to do and could not with the usual antitrust enforcement power. But it's a bit, looking at the past. It's based on what has been going on in the and now that we have those rules that are being put in place, there is a concern that once they are there, they will have their life of their own. It would be very difficult to adapt them if the markets and the industry or as the industry evolves. When Pierre Gibaud, the chief economist of DG Comp, asked some of the members of the Economic Advisory Group for Competition Policy to have a look. This was at the beginning before we opted for the DMA. So looking at options, he asked us to look at the experience in the UK experience with the market investigations. Prima facie, I was doubtful because what I had seen of this was the code of conduct for supermarkets and so on, which did not impress me as being very effective. So we look at this. This was with Monica Schnitzer and Greg Crawford. And I must say that we have been very impressed with the track record of this instrument. So this is an instrument which is in between antitrust and regulation, where the agency looks at a particular industry because it has the feeling that there are problems there, identifies the problems and try to determine remedies, which including breakups sometimes, for the London airports, for example, or for the cement industry and so on. And sometimes, other remedies that are really tailored to address the problem that I have identified. And therefore, from one industry to another, the remedies can be very different. And they are each time tailored to whatever. And I think that this is more interactive in a sense. This is quite fast, nothing like the Intel timeline. And I would have loved that if we could have explored this a bit more at the EU level.
Okay. So let me just ask, so how do you see, because the CMA has the tools that Patrick is mentioning, but you're actively asking for more power to do more what Ioannis is trying to get as well. So how do you see this dynamic there?
I think we're talking about a few different things. I think, I think our market study function is a general function. And I think the DMU proposal is responding to particular concerns. I'm not sure that any of them are sort of fundamentally tied to ecosystems. I think one thing with the market study tool, again, this isn't necessarily about ecosystems, but more about digital markets. I do think one of the learnings, and again, I go back to the Lear report, was around, how well do agencies actually understand the operations of these markets broadly? And I think the market study power has been really useful. When you look at something like the digital advertising market study that our teams did a couple years ago, I think it's an opportunity to look at a market broadly and try to understand how competition is working in that market. And I think that's not something you can do in the same way in an individual case. And then obviously at the end of a market study or a market investigation, there can be interventions, but that's something quite specific. I think when we look at the proposals around the digital markets unit, that again, I don't think is specifically tied to concepts of ecosystems. I think that's been about a general review of the digital landscape, the fact that it's been dominated by a small group of players for a long period of time, and looking at the ability to put powers in place to introduce things like a code of conduct or pro-competitive interventions, things like interoperability or data portability, et cetera. And I think that those, when you look at any of those on their own, I think they are addressing problems that have been discussed for a long period of time. I think some of those problems are around network effects, and it's, creates the opportunity for greater competition. But, again, I think while some of the ecosystems we're talking about may be characterized by network effects, I don't think network effects are necessarily an ecosystem problem per se. I think that's, a sort of long established concept. And the DMU proposals are around sort of addressing some general concerns about how markets are operating.
Final remarks.
I just wanted to say, we have been criticizing Antitrust for being long, etc. But of course, we started these investigations at the time when we did not have enough learning on ecosystems or platforms, okay? And I think what is interesting now is to see the experience of the specific tools like Article 19A, all the use by some authorities of existing tools that they have, like abuse of economic dependence, and how quick they are exposed to deal with the issue. Okay, so it might be that we have been criticizing ex post enforcement, antitrust being long, but maybe let's see how long they take. These specific type of new tools, and possibly they're not going to be that long because a market investigation reviews can also be a little bit long as well. You have to do these consultations. So it's not really something you can actually finish in a year. Definitely have at least 1.5 or 2 years to finalize. So now it's a time to compare a little bit the various tools and see, in terms of effectiveness, which is the most effective one in terms of time.
Okay, thank you. So stay tuned for next year. We have panels discussing what the DMA has achieved, or maybe it's going to be too early. But thank you very much, everyone. We're going to have a break now. Thank you.
Good morning, everyone. It's working great. I'm Leah Nyland, Bloomberg's Antitrust reporter. We're going to have a panel discussion about the merger guidelines, but we were a little too optimistic about their release. So we have changed our panel topic to be about one aspect that is expected to be in the guidelines when they're released, which is the intersection of labor and mergers. So we have a great panel of 4 folks. So you can read their bios in the packet that everyone has. And first thing we're going to do, though, is Dennis is going to give a little bit of an overview of sort of where we are right now with the law, and then we're going to start discussions. If you guys have questions at any point in time, feel free to jump in.
Okay, thank you. I thought it'd be useful to present a brief overview of research in labor markets and market power in labor markets from the view of an IO economist. This is a really hot topic, and there's a lot of research going on. People in this room, Iona has done a lot of work in it. There's a recent issue of the Journal of Human Resources that came out last year devoted exclusively to market power in labor markets. So I thought it'd set the stage for some remarks I'll give at the very end of my introductory remarks, as well as maybe for some of the topics we're going to discuss on this panel. There's been a huge change in the views of labor economists about the presence of market power at the level of the individual firm. I would say 20 years ago, the prevailing view was that most firms faced a pretty elastic supply curve for labor, and that there were some exceptions, one-company towns, maybe nurses, teachers, professional athletes, but by and large, the view was most firms were setting wages in a pretty competitive market. Now, the prevailing view is that most firms have some market power in the labor market. It obviously varies from firm to firm, but that the implication is that it's likely that the wage is going to be set below the competitive level. To me, there's a very close analogy in what's happened in the labor literature to what happened in the industrial organization literature, at least starting at least 40 years ago, where it was widely began to be accepted that firms aren't all facing perfectly competitive situation, but have some market power. Obviously, it differs from firm to firm and from industry to industry. Now, what's been the main sources of information that has caused these labor economists to change their views? Well, there are several. First, there have been numerous attempts to estimate the supply curve, the elasticity of the supply curve with respect to the wage rate facing individual firms. And I would say, by and large, a reasonable sort of consensus is that most firms face elasticity of supply that's less than infinite when they're trying to get labor. And the elasticity, the median elasticity, seems to be pretty high from my point of view, somewhere between 5 and 10. But that still means that there is a substantial, what I'll call distortion, of 20%, depends obviously on the particular firm and industry, between the competitive wage and the wage that's being paid. So that's one source of information. What's another source of information? Well, one important source to me comes from the study of mergers. And I think one of the best studies is the study by Prager and Schmidt, where they look at what happens when hospitals merge. And I think they come up with two very important findings. The first finding is that basically nothing happens to anyone's wages unless it's a really big merger. What do I mean by a really big merger? The HHI initially is something like 5,000. The change in the HHI is 3,000. So these are really big mergers. But even there, what they find is that the effect on wages is focused on people who have specific skills, like nurses. Their wages go down, it looks like, by about 7% or so. But for other people who don't have skills specific to the hospital sector, such as cafeteria workers, can't find anything. So I think those are sort of pretty interesting findings. And one of the things I'll say about this paper, they do a very careful job of dealing with what IO economists have known since really Dembsatz pointed it out, which is that concentration is endogenous, and you really got to control for the fact that big firms may be getting bigger and more concentrated because they're more efficient. And it tries to do has very clever ways of trying to control for that. A third set of sort of information that's informed the views of labor economists come from no-poach agreements among independent firms. And I highlight the word independent. I'm going to be somewhat constrained in exactly what I say here because I'm involved in an alleged no-poach case. But Gibson studied a particular case that gathered lots of attention, and that was when a lot of firms, tech firms in Silicon Valley, entered into what are called no-poach agreements, in which they say, I won't get your employees if you don't try and steal mine. And Gibson looked at this and estimated that the effect of this agreement was to depress wages by about 5 to 10%, depending upon what firm you were looking at. But, and this is a big but, and that's why I stressed the word independent before, that they were independent firms. In the settlement with the DOJ recognized, and I think correctly so, that sometimes there can be efficiency reasons for these agreements, and that if firms are in a collaborative relationship, such as a joint venture, you might not want to enter a joint venture without a no-poach agreement. So there was a carve-out. So I think that's important. That's why I stressed the word independent no-poach agreements. The last source of information comes from what are called non-compete agreements. Now, the difference between a no-poach agreement and a non-compete agreement is the following. A non-poach agreement I view as an agreement among independent firms. So it's horizontal. A non-compete is vertical, a firm with its laborers. The person who's done a lot of good work on this is Starr. And here's some of the findings and why they raised issues for labor economists. First, there were a lot of non-competes, 20% of the workforce, it looks like. And here's the puzzling fact. These non-competes, which an economist perhaps can explain as protection of intellectual property, for example, surprisingly were applied to low-wage workers, where you don't think there's a lot of intellectual property. That's kind of surprising. So that's why labor economists say it's probably to affect market power in the labor market. What the empirical evidence shows, and it's mixed, is the following. For doctors and CEOs, it looks like wages go up with non-compete if you have a non-compete agreement. For more general across-the-board workers, which is what Starr was looking at, mixed. Looks like non-competes raise wages. On the other hand, in states where it's very hard or impossible to enforce non-competes, even if it's a contractual agreement, it looks like that causes wages to be be higher, okay, when you can't enforce. The net result, though, of a non-compete seems to be that it looks like it raises wages, which is something that's surprising when you look at low-wage workers. I should mention, and then there are contrasting studies, though, with other results. So in Hawaii, when there was a ban on non-competes, that led to an increase in wages by about 4% among certain high-tech workers. In Oregon, when they banned non-competes, hourly wages went up by 3%. So I'd say the evidence is mixed. I suspect it depends on the circumstances. So let me now tell you what I make of this as an IO economist. First, mergers definitely can adversely affect labor and lower wages. There's no reason to ignore that possibility. Though I stress the evidence, at least from Prager and Schmidt, is that only and also there's someone else, Arnold, who comes to similar conclusions. It's only in limited circumstances, really big mergers, that you're going to see much effect on wages. Second, and this is a point that I'm surprised hasn't been emphasized, if there are distortions in the product market or distortions in the labor market, and all I mean by that is they're neither is perfectly competitive, then the following is true. A merger that expands output matters a real lot, much more than we usually think. Conversely, a merger that reduces output really causes a large loss. That means mistaken antitrust has big consequences for the economy. Third point I would say is labor market power, to the extent it exists in a particular market, does not imply that antitrust is the useful mechanism to intervene. Let me just give you an example. One standard reason why there's market power in the labor market is because employees have reduced mobility. Why is that? Well, one reason is it's sometimes hard to move across state lines because of licensing laws. Well, the solution to that problem is to get rid of the licensing laws. So it's going to depend on what problem you're trying to fix, and I don't think antitrust can fix all problems. Fourth, my observation, this is similar to what other people have said, is that we focus in antitrust actions a lot on short-run price and short-run wage. But a lot of other things that matter to the consumer welfare, whatever you want to call it, to the economy, and that is long-run consequences. Take doctors, for example. Suppose there's a merger of all the medical, all the hospitals in America, and doctors' wages fall. Well, maybe they can get away with that for a while, but sooner or later, people are going to stop being doctors. People are going to stop applying to medical school, or you're going to get different people applying to medical school. The long-run consequences of investments in human capital seem to me something that I've not seen people pay enough attention to. My last two comments are the following. You might ask, how should harms to labor be evaluated? Well, in, say, a merger case. Well, let me just say monopsony is not limited to labor. You can have monopsony in a lot of other things. I just think in general we should pay attention to monopsony, but still the question is, how should you be measuring harms to the extent they exist? I think we know how to do that. And in fact, I think, for example, the Antitrust Division does it all the time when it looks at an airline merger. It looks at different classes of consumers, and it basically aggregates them. You can do the same thing on the factor input side. I'm not sure that poses a new problem. And I'll conclude with a comment which is similar to the comment I made at the end of the session yesterday, and is actually quite similar to what Frank Easterbrook and Diane Wood said yesterday. There are certainly important policy concerns, income distribution, unemployment, losing your job, that are associated with labor, as well as any merger. But those seem to me to raise problems that are better addressed by other instruments. I'm worried that if you start bringing in all these other values, democratic values, the harm to an individual from losing his job, that it's a bad thing. I agree, it's a bad thing. The question is, can antitrust fix that? And if you ask a judge to weigh all these things at the same time, I think you're going to wind up with a mishmash. And antitrust will be set back, and that whatever progress we've made, or we think we've made, in using economic thinking to try and figure out what judges should help judges figure out what they should do, it's going to be completely lost. You'll lose control over the process. And as Frank said, giving discretion to judges to make trade-offs among many different social values is going to lead to simply a policy, an antitrust policy, that will be, I think, in my view, and I think he would agree, is just going to get out of control and not going to promote anyone's welfare, no matter how well defined. Thank you.
Thank you, Dennis. So Sanjukta, you've been one of those folks who has been working on this issue. And for those of you who were not here for the dinner last night, she got a very nice shout out from Judge Diane Wood on some of her articles. So why don't you share a little bit?
So thank you so much for having me, and thank you specifically for having me on this panel on mergers. It's fun for me to think about. Most of my research and work has not been specifically about mergers. It's been about other areas of antitrust, and including their intersection with labor. I think maybe it's worth dwelling on that for a moment, because I feel like we've been talking, and I will talk about mergers, but we've been talking about mergers to almost the exclusion of other antitrust rules. I think there are, when we talk about whether antitrust is an appropriate tool to deal with labor market harms, we shouldn't just be thinking about mergers. We should be thinking about other antitrust rules, notably vertical restraints, which have been, the enforcement of vertical restraints has been, that is the bigger, really the bigger revolution worked by the Chicago School Revolution. And that has direct impacts on labor. I won't talk about this too much, but there was a great New York Times article yesterday by Lydia DePillis, I don't know if I'm saying her name right, on franchising. And it doesn't talk directly about antitrust, but ultimately it is vertical restraints rules that make the sort of control without responsibility of the franchising business model, which labor advocates have targeted for decades now. It makes it an antitrust issue, and it makes it possible, right? The article notes that both the NLRB and the FTC are now interested in thinking seriously about franchising. So I think it's just important that we don't just think about mergers here, but we keep in mind other antitrust rules. I also think the rules on horizontal coordination have an impact on labor in a way that I think will become more clear when I talk further about mergers. Okay, so labor and mergers. I'm gonna suggest that we think about labor and merger policy not just from the perspective of what the effect that a merger or a set of mergers has on market concentration and the effect that has on wages, although that is certainly important, and I think all of the empirical and statistical evidence is very relevant. I think we should also think about the merger rules we adopt in terms of their systemic effects on labor unions, on workers. And so here I suggest a more general shift in maybe our thinking about all of these antitrust rules, that we think about them not just in terms of how we would apply a given set of rules in a given adjudication, but how they function prophylactically to create or to not create the sort of markets we want to see, because this is extremely important, right? And this is not a new idea. This is something that I think a way that antitrust thinkers thought about antitrust rules for many decades. And specifically with respect to mergers, what is the effect of a permissive merger policy versus a quite stringent merger policy on the competitive and business strategies that executives, boards are looking at, and that they may even be compelled into, right? So I'll say a little bit more about that, versus the competitive strategies that are open to them in the context of a not very permissive merger policy. What would happen, I'm just going to ask the question as a thought experiment, if we largely take mergers off the table as a competitive or business strategy, we make them the exception and not the rule. There's still going to be some situations. What would be the implications for markets in general and for labor in particular? So I'm not going to answer those questions exhaustively, but I'm going to suggest that we think about those questions. I also want to take a step back a little bit from this discussion because we've talking about mergers a lot, but we've been having various debates about rules, standards, and goals, and I want to at least agree on the subject matter that we're discussing if there's disagreement about those other things. And I think that part of the subject matter we're discussing when we're discussing about what antitrust rules should be is what kind of markets do we want to have in society? And given in our economy and in our society, and given that law inevitably shapes markets, what sorts of rules and processes should the law adopt? And I want to distinguish here between considerations that may not be appropriate, I would totally agree, for individual judges in individual adjudications. I'm the last one to suggest that we increase the discretion that our federal judges have. I've argued against that in print. I think we should absolutely adopt bright line rules. But we should distinguish between the considerations that are appropriate for individual decision makers, or for that matter, ALJs, to consider in deciding individual cases that arise under the antitrust laws, and the considerations that are appropriate for us at this conference, or as academics, as advocates, as researchers, as legislators, to consider when we are talking about designing our antitrust laws, because those, and our antitrust processes, because those are conceptually two completely separate questions. And if we're not considering those, then I don't know what the point of having a conference like this actually is, or what the point of of legal academic research is. That is our job. I was a lawyer for many years. We're bound by the rules when we're lawyers, when we're a practicing lawyer, but that is not what we're doing here. So we need to think about, we do not have to, entrust a judge to consider some of these bigger impacts that market concentration and permissive merger policy may have on the polity and on society, but it's an appropriate thing for us to consider when we think about what type of rules to adopt. And here, again, coming back to the topic, a permissive or not permissive merger policy is one of these rules that we can think about in this prophylactic way. And also, the empowering and, sort of allowing the FTC to do its job of engaging in competition rulemaking, which I think that the authority is extremely clear from the Supreme Court and the legislative history that they have the authority to do that. I don't think that the arguments and the smoke that's sort of been that has been thrown up in terms of that legal authority has much merit when you actually look at it. And so empowering the FTC to do that, I think, also is another way, a very important way of creating these prophylactic rules. And again, it's different. The reason I'm bringing that up here is that it illustrates the point. What considerations the FTC should take into account when doing competition rulemaking is different from how much discretion we're going to give to individual decision makers. Okay, so I think I've made that point. All right. So what's a merger? A merger is a specific method of expanding the scope of a particular form of economic coordination that has been authorized by law. There's nothing natural about firms in the state of nature. They're not even, people have been innovating and creating in all the context of lots of economic institutions through history, through craft guilds, through mercantile guilds. There's the specific form of the modern firm, shareholder-driven and organized in the particular way that it is, with workers largely divorced from decision making. There's nothing natural about that. I'm not suggesting that we go back to the guild system. I'm asking us to take a step back and think about what a firm is and what we're doing when we say that the presumption should be that firms have the right to combine. And I want to note that the firm is specifically an antitrust exemption. It is a suspension of competition. You can say that it's crazy to think about, not allowing firm-based coordination. There's actually all kinds of ways. I'm not advocating them. I'm asking us to note them conceptually. You could take the output of a firm that you could keep all the operational integration. You could divide that output, control rights over that output among everyone who works for that firm and let them individually price the output. That would be a more competitive outcome and would potentially replicate the level of competition that the modern business firm displaced when you look at sort of the evolution of the modern business firm. We don't do that. I think it's fine that we don't do that, but I think we need to notice what is actually happening here. I'm not the first one to have this insight. Ronald Coase had this insight. He didn't talk about it in terms of antitrust, but he talked about the firm as a suspension of competition. That is what it is. Expanding that suspension of competition, we need to just be very clear about what we are actually doing and how we treat that differently from other suspensions of competition, including labor unions, cooperatives, and yes, even looser horizontal coordination in the form of things like trade associations. I'll come back to that point. Okay, so mergers are an expansion of the scope of what is already the biggest and strongest antitrust exemption we have, the firm. And some of this, the second point that I would make, so that's one thing I want us to notice about mergers. Then when we talk about efficiencies that may be realized by a given merger, I think we need to consider which of them, first of all, actually are efficiencies versus something else. I'll say more about that. And also, we need to consider how alternatively those efficiencies could potentially be achieved. I'm not just, this point about thinking about economic coordination broadly is not just an academic point. What could we do right now, other forms of coordination that could realize some of the putative efficiencies that specific mergers do allege and put forth? So, for instance, could some of those genuine efficiencies, just considering the genuine efficiencies for a moment, could they be achieved through, for instance, industry-wide standards in various situations? Could they be achieved by a trade association? We have trade associations that do marketing for various industries. You've all seen the milk ads, California raisins, right? Is there coordination through those types of mechanisms that could actually preserve more independent decision-making, which is one of the goals? It's settled law, actually, that's still good law. As far as I know, that's, dispersed decision-making is one of the goals of antitrust law. So should we be considering those? And should we, in any new merger guidelines, be considering a safe harbor for some of these alternative forms of coordination, potentially through dispersed coordination through trade associations or industry-wide standards that could achieve some of the genuine efficiencies without the consolidation and specifically the consolidation in the form of the shareholder-driven firm that mergers currently signify. So I think we need to put that on the table and consider it. Then I think thirdly, the other thing I sort of want to, everything I'm sort of suggesting is things that we should notice. I'm not sort of suggesting, actually complete normative conclusions, because I don't think we've had enough inquiry into these questions. I'm suggesting we look at this and not just sort of labor market concentration, effect on wages, that's important, but that these are all aspects of what we should be looking at. So how many of these putative efficiencies are actually intensified forms of extraction versus actual efficiencies? And here, it's important to first get conceptually clear about what we mean by efficiency. Do we mean allocative efficiency? Obviously, that's undermined by a merger. I don't find that concept actually terribly useful, but to the extent that we're adopting it, obviously a merger decreases allocative efficiency. Everyone has said that. Bork, Williamson, in the Williamson diagram, this is part of what it says. So allocative efficiency isn't an efficiency that's contributed by a merger. It has to be a production efficiency. So what type of production, when are there true production efficiencies? Are we truly inquiring into them? And to what extent are those production efficiencies in some cases actually forms of extraction? I'm not saying they all are. I think there's genuine efficiencies. And so I think we should, study this and consider it properly and clearly. But I think that sometimes, specifically when we're looking at price as an index of production efficiency, which is obviously a shorthand we use all the time, and I don't think we should use, because sometimes often low prices are not an indication of production efficiencies. They're an indication of extraction. And I don't mean that in just a normative political way. Let me break it down. What is a production efficiency? A technical efficiency means you get more output for the same input. It is technical innovation where we have seen such technical innovations in history. We live at a time where we're benefiting from much of this. But consider the difference between a machine that allows two workers to produce more at the same quality versus a new institutional or organizational arrangement that pays those two workers less to produce the same amount. Those are not the same thing. The second thing simply is not a technical efficiency. I'm not taking a normative position on that. You can, I suppose, have the position that that's a good thing and that we should drive wages down to subsistence levels. I do not think that. I do not think many people would say that they think that, even if they do. But I want us to notice conceptually there is a difference. And the same thing applies when a merger leads to greater bargaining power with respect to other firms that are input suppliers or distributors or whatever, right? Firms in adjacent markets that you're bargaining with. If you ultimately even get lower prices, which we know we often don't because instead those savings go up to shareholders, or executives or whatever. But even when you do get lower prices, right, to what extent is it coming from superior bargaining power with respect to suppliers, distributors, whatever, right? Because obviously, if you now have we should look at it in individual cases, but often you have more bargaining power if you're now a much bigger firm and you have a much bigger market share, and you're much bigger with respect to your trading partners in adjacent markets. So we need to distinguish between true technical efficiency and extraction, both on the labor side and on the small firm side. And not because we just care about small firms and we romanticize them and it's some nostalgic ideal. Those small firms have workers themselves. So if even the supposed wage premium of large firms, we need to look very carefully at, because to what extent is that a wealth transfer from the workers of other firms to the workers of large firms, to the extent there even is a wage premium, right? So these are all things that I think we need to just take a step back and think about when we think about merger policy and workers. And I suspect I'm over my time, but I also want to include in things that are not efficiencies, the direct transfer that merger policy considered at permissive merger policy at a systemic level entails from essentially productive sectors of or productive arms of the firm, and therefore ultimately from workers to shareholders and deal makers, because that is a systemic, we can sort of talk about it in this individual way that seems like we're pointing fingers, but if we consider it systemically, it's an important element. So I just want to maybe very briefly quote from Josh Mason, an economist that I think that maybe antitrust folks should pay more attention to. And he has this nice essay on, various economists and social scientists have been talking about share buybacks as a form of this type of extraction and wealth transfer from workers and from production in general to the financial sector, right? But thinking about M&A itself as this type of transfer, and he points this out, and he says that when you look systemically at sort of corporate finance, he says that quantitatively acquisitions are especially important. And it's specifically cash out. So we got to look at what the type of deal is, right, as well. Of course, when acquisitions are paid in stock, the total volume of shares doesn't change. But when they're paid in cash, it does. In the aggregate, when publicly traded company A pays $1 billion to acquire publicly traded company B, that is just a payment from the corporate sector to the household sector of $1 billion, just as if the corporation were buying back its own stock, et cetera, et cetera. So we're transferring from producers to savers at a systemic level, and that's what's been, again, you can have different views on that, but that's what's been critiqued with respect to share buybacks, and it is in that sense a wealth transfer. Finally, I just want to very, very briefly note that point I alluded to in the introduction is if we think about mergers and acquisitions in terms of this sense of, and merger policy in terms of this sense of prophylactic rules, what are the competitive strategies and tools that are on the table for a CEO, for a board, right? And sometimes, if you have taught corporations or business associations as I have, then you read all kinds of cases with your students where where the board doesn't want to do the deal. No one who's running the company wants to do this deal. Their hands are tied by the pressure that this set of rules creates, or at least their hands are strongly guided toward doing deals that where maybe, we should reconceptualize their primary job is to be a steward and a manager of certain productive assets. That's the point of the firm. We have a very illustrious exponent of the theory of the firm in the room. The theory of the firm is supposed to be, the firm is supposed to be about making the best use of productive assets. We've decided as a society, giving this over to managers and CEOs and boards is the way we want to do that. So if that's the goal, would it be useful to have prophylactic rules that actually prevent, that channel their activity toward doing precisely that and not being forced to do deals that often do not benefit anyone?
Thank you very much, Sanjuja. Felix.
Yeah, so hi. Thanks a lot for including me in this panel. I'm going to touch upon a couple of ideas that already Dennis and Sanjuja touched upon. So before speaking more about how we could or should kind of include employment into merger enforcement, I'd like to kind of very briefly highlight the key difference between when we think about the welfare effects of mergers on consumers and workers. So I think the potential harm to consumers from a merger is typically going to come from a lessening of competition. And so in that case, if we want to have a policy that kind of prevents consumer harm, if we're going to focus on that lessening of competition, that's going to pretty much get us there. For worker welfare, I think that it's kind of a little bit more complicated because we have some of the harm to workers from a merger that can come from a lessening of competition, but at the same time, it could be that there is, for example, a merger-induced offshoring or perhaps also kind of merger-related efficiencies that relate to employment that might harm workers, but that are not kind of due to a lessening of competition. So as I show in a paper that will be talking about a little bit more in a couple of minutes, even when a product-market merger leads to a substantial decrease in welfare from a lessening of competition, it could be that in this case now that I'll talk about, these other welfare effects kind of are in the different direction and kind of at least as large in terms of magnitude and kind of could plausibly change which decision is better for total domestic surplus. Now, we may not think that this should be part of the mandate of competition enforcers, but people affected by this, they're going to really care about this. So as Timur said this morning, kind of the people in Scranton might not only think about kind of what's coming from the lessening of competition, but kind of the overall welfare effects of a merger. And so if we want to maintain kind of political support for pro-competitive merger policy, I think that we at least need to show that we're trying to address these other issues as well and kind of make sure that in terms of distribution, there aren't kind of very strong losers and very strong winners of a pro-competitive merger policy. Some may argue that kind of the solution is going to be to have more of a total domestic welfare standard. What I would like to do instead is to kind of illustrate in a particular case how competition and non-competition effects of a merger may be in conflict, and then how we could perhaps kind of marginally extend the existing paradigm to still address these things. Okay, so with multinationals, merger-related production relocation decisions can become really important for the effects on workers. Let me give you an example. Let's suppose that we have kind of a firm A and a firm B, and they're both product market rivals, and they both produce exclusively domestically, let's say in the US. And kind of without going into too much detail, let's suppose that we have the choice between two policy options. We have an anti-competitive merger here between firm A and firm B that's going to harm consumers a little bit, harm workers a little bit. And the alternative, let's say in this case, is that they don't merge. Firm A is going to offshore all of its production to abroad, leaving kind of consumers unharmed, but harming domestic workers a lot. So should we prohibit that merger? Well, if our standard is to kind of prevent harm from a lessening of competition, I think it's pretty clear we should prevent that merger. If it's going to be some kind of a total domestic surplus standard, then that answer might be a little bit less clear. Now, to a certain degree, and I want to disclaim that at the beginning. I know very well that that was not the consideration in the case, but to a certain degree, that was kind of the economic trade-off at play in the Whirlpool-Maytag merger. In a recent Stigler Center working paper, I study kind of this case in great detail, and I try to quantify these different forces at play. Now, I know that quite a few people in this room and kind of even on this panel have thought even more about this case than I have, but let me give you kind of like a very quick overview of it. So basically in 2005, Maytag was the #2 clothes washer manufacturer in the US. I mean, they did other appliances too, but I'm going to focus on clothes washers here. And they were kind of looking for an acquirer because they weren't doing that well financially. The Chinese appliance manufacturer Haier, that wasn't active in the US market at the time, had made a bid for Maytag. And kind of rumors have it that their plan was to access the market through buying the brand and the supplier network of Maytag and then kind of offshore production to China. Now, shortly thereafter, Whirlpool, the #1 in the market, kind of made a rival bid for Maytag. And ultimately, the Department of Justice unconditionally cleared that merger, citing kind of potential entry by rivals as being a sufficient constraint on Whirlpool and Maytag and showing that they couldn't harm consumers from that. So what I do in the paper is that I use kind of a lot of data on products, on consumer purchases, on production locations. I model how kind of product quantities map into the jobs in these different production locations with an empirical entry model and a model for the number, these numbers of jobs, and a merger simulation to kind of compare these two acquisitions. As I said, I'm not suggesting that that was the trade-off that anybody had in mind at the time. The point of this is much more to think about, is it potentially conceivable that if the consumer surplus effects go very strongly in one direction, kind of other effects might be equally strong and kind of push that decision in another direction. So what do I find? Whatever I do, this merger turns out to be really bad for consumers. I try to look at the incentives for rivals to launch new products. Those barely moved. I mean, they did enter, but not because of that merger. And it led to very important price increases and consumer harm. Next, what I do is that I try to calculate how the number of US manufacturing jobs, in particular kind of in the clothes washer manufacturing sector, differs in these two scenarios. And what I find is that actually there are kind of more jobs after a Whirlpool acquisition than after a Haier acquisition. And so with these estimates and the estimates on consumer harm, I can kind of try to compare the two. And I try to basically see how much consumer surplus, if we compare these two things, would we be willing up to save a domestic job? And the number that I come up with is something like between 100 and 200,000 US dollars per job per year, which if we think about the literature on what jobs are worth to local labor market isn't completely crazy. So the thing that this shows is that kind of when multinationals are involved and they can choose to move production outside of the jurisdiction and may do this because of a merger decision, including workers into merger control can actually potentially change the total domestic surplus effects of like the two options. In this case, kind of it moved in the one direction. It could have also completely be in the other direction. Now, there's a second difficulty that I want to kind of briefly touch upon, and that was discussed already before. I'd like to talk about merger-related efficiencies. So in many cases, merger-related marginal cost efficiencies are going to come from a more efficient organization of production. And that can entail job losses. So let's suppose that, again, we have firm A and firm B, and that firm B has a production technology that uses fewer workers and more robots. And let's suppose that kind of firm B plans to roll out its production technology to firm A after the merger. Now, let's also suppose that those are kind of product market rivals, and that only because this more efficient reorganization of production, this is actually not going to lead to consumer harm. So then these merger-related efficiencies could make consumers better off, but in this case, at least kind of partially at the expense of workers. Again, the harm here does not come from a lessening of competition, but kind of from other considerations that are at play. So what should we do if we want to consider workers in merger control? And should we kind of continue to kind of narrowly focus on the welfare effects from preventing harm from a lessening of competition and kind of ignore everything else? Should we think about like a total domestic surplus standard? In my opinion, and kind of this is going to be policy conclusion that I draw from the research, but that is not kind of immediately a result of the research. We should aim for we should aim for a standard that continues to prevent welfare losses from substantial lessening in competition, and kind of call it a preventing harm from the lessening of competition plus approach, where we kind of slightly modify this in the sense that, so if we wanted to adapt a sort of total domestic welfare standard, that would actually come with a lot of problems. So one thing that is kind of outside of the model here is that when it comes to workers in offshoring, differently to consumers, there might actually be a trade-off here between foreign and domestic workers, and this could kind of kick off an international spiral of protectionist merger enforcement, and we probably don't want that. When it comes to employment-related cost efficiencies, I think that kind of discounting them only because they also hurt workers might not be the greatest idea, because, I mean, as we heard from Chad yesterday as well, like productivity is kind of important, and if we're going to kind of prevent any type of reallocation just because it could also hurt workers, that might kind of create a problem in the long run. At the same time, completely ignoring everything that's not related to a lessening of competition might be an issue as well, because people are going to care about these effects, in particular kind of workers that are probably individually going to be hurt much more than kind of on average the average consumer. So if we want to have public support for pro-competitive policymaking, we kind of need to take this into account. So what could we do instead? I think there are going to be cases where kind of all of the welfare effects go in one direction, then we can just ignore this and we can just continue going for the pro-competitive decision and do what we know how to do. That includes product market mergers. That obviously also includes labor market mergers where there are changes in monopsony power. Now, in cases where these welfare effects go in different directions, I think that we should still kind of go for the pro-competitive merger decision, but then we should perhaps think about how we can very deliberately target resources to exactly those populations that may be harmed. And so something I thought was very interesting in what Susan Athey described yesterday as coming out of like the executive order, that there's an increased coordination between different branches of government, and perhaps that is something that could be expanded in merger enforcement, that it is clear like from a particular merger and from a particular merger decision that the antitrust authorities think should be taken, there are going to be some people that are going to be hurt. And instead of just saying, well, in theory, we could have compensated them, kind of government tries to use different branches to very deliberately make sure that people are heard here. I also think that the perhaps slightly unpopular branch of empirical industrial organization, at least in this room, like that I count myself part of, can help to quantify the welfare effects of these cases, and can kind of try to help identify in which cases we have other effects that might be important, and where some of these efforts should be directed to. And I think that kind of by fine-tuning our existing approaches, I hope that we can kind of manage to address these very real and important distributional consequences without kind of losing the main target out of sight, which is still to have a merger enforcement policy that tries to go for pro-competitive decisions and create a dynamic and efficient economy out of sight.
Great. So Holly, we've heard a lot now about sort of the research and academic thinking on this. What can you tell us about what the FTC is sort of actually doing in this area?
Yes, thank you, Leah, and thanks very much to the Stigler Center for inviting me to speak. It's a real pleasure to be here. Before I get started, let me just give the standard disclaimer that my remarks are my own and not those of the FTC or any FTC commissioner. So I'll talk about some of the ways, the FTC analyzes labor market effects and mergers. But I'd first like to share our thinking about, why we think it's so important to do so in the first place. and it relates to what Dennis was describing with the studies. We think the stakes are really, really high here. We see too many workers facing concentrated markets for their labor. In addition to the studies that Dennis mentioned, there's also a recent Treasury Department report on the state of labor market competition, and it highlights that local labor markets have become more concentrated since the 1980s, and it points to recent research that reveals how monopsony power wielded by employers leads to wealth transfers from labor to capital, broadening the wealth gap and creating a drag on the economy. More specifically, we think there's evidence suggesting that decades of mergers have been a key driver of labor market consolidation across industries. The one aspect of the report that we find particularly insightful is what Dennis mentioned, the Prager and Schmidt study, looking at post-merger wage levels affected by hospital mergers. And, the findings are really important. They show that wage losses attributable to those mergers in occupations with industry-specific skills were definitely present, and the wage effects were most pronounced where the merger substantially increased employer concentration levels post-merger. And there's additional research that Iona, who's here today, has done that found labor market concentration has wage effects in both low-skilled and high-skilled workers. So this type of research is really critically important to our work. It forms the backbone for our analysis, and it clearly shows that mergers that reduce options for employment mean that employers don't have to compete for workers in terms of their wages and benefits, and it leads to lower pay and lower quality of jobs available. Just as mergers in output markets may reduce competition and lead to higher prices, lower quality or less innovation. And, there's mobility effects. Dennis, you mentioned about, in some instances you might have higher wages from non-competes that can make these, exacerbate wage effects. But, if workers aren't able to move around, that just makes things even worse. So, that's something we really have to be cognizant about. So turning to how we look at labor market effects in mergers, Section 12 of the 2010 Horizontal Merger Guidelines provides some guidance. It spells out that mergers of competing buyers, which would be employers in the labor context, can enhance market power on the buy side of the market in the same manner as mergers of competing sellers enhance market power on the sell side. So the analytical framework's essentially the same as on the sell side. We look to what the relevant product and geographic market are, particularly focusing on the alternatives available to employees in the face of a decrease in wages paid by a hypothetical monopsonist employer. But labor markets have unique characteristics that product markets on the sell side sometimes lack, and our analysis needs to be sensitive to that. Switching costs associated with labor mobility might be higher relative to those associated with consumers when they change a product or service provider. And workers also face two-sided matching costs where they and the employer are both looking for a match. And workers are disadvantaged by information asymmetries unique to labor markets. Moving and mobility costs they face, and it makes labor markets even thinner than typical product markets where only one side is choosing. And so that really exacerbates the market power issues you can have in labor markets relative to product markets. So, another thing, when we look at labor markets in mergers, we don't feel we need to do any cross-market balancing. The labor is really its own market. So we're going to look at whether the merger might harm labor in any market, independent of possible effects in an output market. We don't need to show both harm to labor and a more conventional harm, such as a price increase that impacts consumers. There could be a situation where there's no competitive overlap in an output market, but the merger might nonetheless harm competition in the labor market. And that could happen, particularly in rural labor markets where there be few employers, and they might be, the few employers that are there, they might be making completely different products. So we're definitely very attentive to the special characteristics of markets for labor. But I don't necessarily think it means we're reinventing the wheel. We do largely rely on the same arsenal of concepts, market definition, but their practical application might differ. So it's worth noting that while we're laser focused on labor harms for mergers today, more so than ever, it's not that we've never looked at that. Monopsony concerns generally have motivated our merger challenges at the FTC in the past. Back in 2018, we examined a merger between two blood plasma center collectors, Grifols and this other company, Biotest. And we saw that there were these local markets where they were both competing for blood plasma donors. In fact, it was a merger to monopoly in these local markets, and we saw that the blood donors who were going to these centers to earn a little additional income, they were really affected by this merger. They were going to get lower reimbursements for donating their blood, and services went down. So we required the companies to divest the overlapping blood plasma centers in the markets, and we put the companies under order for that. So that's not exactly a labor case. The blood donors, you wouldn't necessarily consider them to be employees, but the legal framework we looked at, the monopsony, the monopsony harm there was essentially the same. So, that was a good example of how we look at things. And then in 2020, we investigated a proposed merger between two companies that provide home health care and staffing services, Aviana Healthcare and Maxim Healthcare Services. And we had concerns that the transaction would have an anti-competitive impact in multiple local markets across the country for nursing services and private duty nursing care. And we expressed concerns, and the parties abandoned their merger. Basically the concern was that the private duty nurses had fewer options, and the merger was going to have an impact on their wages. So moving forward, we're really increasing our focus all the more on harm in labor markets. We're looking for potential harm to labor in every single merger we investigate, to see whether it undermines competition for workers, in addition to competition on the sell side. We're building our capability to collect and access data related to workers and job opportunities, and the things we would look at when we're investigating these transactions. Another good example of where we looked at this was in a hospital merger challenge we brought, the Lifespan Care in New England transaction in Rhode Island. That hospital merger, we filed suit, and they abandoned it shortly afterwards. On that one, we looked at the potential for the merger to cause harm, not just in the overlapping hospital services market, but also in the labor market, skilled medical professionals. After reviewing our analysis in the Bureau of Competition, our commission voted to challenge the merger over concerns in the hospital services market, but the commissioners split on whether to challenge it on the harm to the labor markets. So, our complaint did not include that. But Commissioner Slaughter and our Chair Khan issued a statement, and they made clear that they were prepared to go forward on the grounds of harm in the labor market in that case. And all four commissioners actually confirmed the notion that a merger that threatens harm in labor, it's a cognizable basis to challenge it under Section 7. I'll also mention that the Rhode Island Attorney General's office, who also sued to challenge the transaction, their administrative opinion paid close attention to the labor effects. So our state attorney general's partners are paying very close attention to labor harms as well. One thing I will acknowledge that's a major limitation affecting our merger review for labor effects is the failure of our HSR forum to require filers to provide any information about their workers. So we're at a significant information disadvantage at the merger screening stage because we don't have sufficient information to determine what kind of workers each party employs and where. It's a known shortcoming with the HSR forum, and we're discussing ways to fill that gap. I also think there's much we can learn from some of our international enforcer counterparts. Some, such as in South Africa, they've been very active in challenging anti-competitive conduct in labor markets. They have a much more humanistic approach to competition law than we do, and it's really refreshing to take a look at how they're doing these things. Let me also mention a couple things about remedies and how the Commission writes orders to address concern about current restrictions on workers. As I've previously said, we're taking a really fresh, skeptical eye towards merger remedies, generally because the evidence shows they don't always work out as planned, and it's the public that bears the risk that an illegal transaction is imperfectly remedied in a way that still leads to higher prices and lower wages and the like. But one thing we are doing that I think is going to help is, for mergers that have, where the companies have non-compete provisions in them that impede talent mobility and exacerbate the labor market harm. Any remedy we take there, we're requiring the companies to eliminate those provisions. We have a couple of examples that we've done. 7-Eleven back in 2021 sought to buy from Marathon Speedway a whole bunch of fuel station outlets, and we required a lot of divestitures, and part of the order required them to drop non-compete provisions they had with the franchisees and employees working and doing business at the gas stations. And then we did something similar in a Utah merger involving kidney dialysis clinics, where we prohibited the acquirer DaVita from entering into or enforcing non-compete agreements and other employee restrictions that they had. Let me also mention some of our other important work outside the merger context that I think has implications for labor. Our Section 5 policy statement issued last year makes clear that employers' conduct that is coercive, exploitative, collusive, abusive, deceptive, or predatory or that involves the use of economic power of a similar nature can constitute an unfair method of competition actionable under Section 5 of the FTC Act. And Spencer Weber Waller, sitting right over there, gets credit for that. We were very grateful to have his assistance. So we've got the statement out, and we've wasted no time exercising it. Exercising our Section 5 authority using that policy statement. We've used it 4 times in enforcement actions since late last year to challenge employers' use of non-compete restrictions, requiring these companies to sign consent agreements prohibiting the use of these non-compete agreements. And we think those consent agreements are just the tip of the iceberg. I think, Dennis, you mentioned how many employees are actually subject to these restrictions. It's really unacceptable, and it suggests that case-by-case enforcement is not an efficient way to go about it. So as I think everyone here knows, we have proposed a rule that would make it illegal for an employer to enter into or attempt to enter into non-compete restrictions with a worker, or maintain a non-compete with a worker, or represent to a worker under certain circumstances that the worker is subject to a non-compete. And it would rescind existing non-compete agreements. The notice of public rulemaking also identifies alternative rules for comment, noting possible differential treatment for senior executives and high-wage workers, and for franchisees with the relationship with the franchisor. The interest in our rulemaking, it's really profound. The window for public comment closed this past Wednesday, and we received over 25,000 public comments, which is just truly amazing. So that was, I do have some sort of miscellaneous reactions to some of what folks said.
Yeah, I was actually going to open it up to anybody. Is there anyone on the panel who sort of wanted to react to something one of the other panelists said? Well, I guess we'll start and then go down.
I had a few reactions. I just wanted to follow up on something Sanjukta said, which I think is an important point. From an economic point of view, the exercise of monopsony power, although it may increase the profits of the firm exercising the monopsony power, that's not an efficiency. Driving down the way classical monopsony works, as probably everybody in this room knows, is you drive down the wage by restricting your labor. And if you do that, you produce less output. And if you produce less output, the price goes up, not down. So whenever a firm comes in and says, I'm really going to slam, my suppliers, including my labor, if it's because of market power in the buying market, that's a harm. That's a deadweight loss. You don't pass it through. I want to distinguish that from another way of thinking wages are set, and that is in a bargaining framework, and in which you're bargaining over the wage and the quantity. That's a more complicated setting. And there it can be the case that output expands. Perhaps wages go down, but maybe you hire more workers. That's more complicated. So I think we have to keep those two separate in our minds. But at the very least, I agree with you. You don't want to have someone claiming the exercise of monopsony power is necessarily an efficiency. The only other thing I would say about looking at labor markets separately, and in some cases that might be justified, but obviously if you're looking at how a merger is affecting, output prices and wages, it seems to me you have to look at them at the same time. I don't know how you can necessarily separate the two. They're so closely related. The only thing I wanted to add about franchisor-franchisee relationships is you got to be a little careful that you understand that there's a margin in terms of a franchisor creating its own franchisor-owned independent firms. And to the extent you get one or the other out of balance, there'll be a swing to the other one. And I think the FTC got involved in the 1980s. There were a series of cases in which state franchise laws gave great power. And typically, there are a lot of franchises, and they have a lot of political power, and they get laws that protect themselves. And that then creates an incentive for independent ownership of for franchisors to develop wholly owned firms. And that actually leads to more efficiency rather than less efficiency. So that just says we don't want inefficient state franchise or laws. But you got to be careful about that margin and their political power.
Sanjukta.
Yeah, thanks. So it was really helpful to hear everyone's comments. I guess maybe one quick response to the response is on the output and efficiency thing. So I think that, right, I mean, this is an important point. I think Steve Salop and others have argued that there's an output decrease in classic monopsony, as you said, or I think that is what the model says, and then elaborated policy solutions on the basis of that. But I think it's important to also take a step back from the model and look at real life and sort of economic and business history, where frequently an output expansion does not mean more employment, actually. It means if you look at American history, if you look at some industries now, right, it means workers working longer hours right? So there's nothing about output expansion that entails, under our current rather weak labor laws, that employers are just going to have workers work 8 hours a day and just hire more workers. And that is exactly what happened in the turn of the century, that you had children. That's again happening again, by the way, child labor. There's been many stories on child labor. I think you have all seen them in the national press. But even aside from that, we have lots of workers working, way more than 8 or 10 hours a day. So we should not assume that an output expansion means increased employment. The other comment that I just briefly was going to make, your comments were very interesting and made me think about it's not really a case, but a case study, the Chrysler-Daimler merger, which is fascinating, I think, to maybe also bring into this conversation because I think we do have to look at corporate law dynamics and antitrust dynamics together in thinking about merger policy. So in that merger, which involved Chrysler, obviously, from my current home state, Michigan, and Daimler, a German company, it turned out when you look at the accounts of this merger, that the fact that the workers of Daimler in Germany had co-determination at the board level, which we haven't talked about yet, labor and mergers, was instrumental in causing the production to locate in Germany. And the fact that, of course, auto workers in Michigan are unionized, but they don't have there's a limitation in labor law where you cannot bargain over fundamental entrepreneurial decisions, right? This is a limitation. But of course, workers who are have that type of influence on corporate decision making in Germany do. So I don't have a big conclusion to draw from that, except that I think is very interesting and directly affected a relocation decision, and I think maybe highlights also that at this, not individual judges, but in thinking about how we're going to design the law, we do have to consider how antitrust law interacts with other areas of law, including our corporate law rules and our labor law rules.
Holly. So on output expansion, meaning workers working longer hours sometimes. I mean, I completely agree with you on that. And I think, that just goes to show why we have to be super aggressive, in analyzing and potentially challenging mergers that harm labor markets. Because, in a situation where a firm is expanding output and the workers are working longer hours, if you have more firms that are offering the same work for those employees, they can go elsewhere and potentially get better wages. So, I think that's very important. And it's also critically important that in markets like that, we make sure that there are no non-compete agreements. Because, then the employers they have, they can't go anywhere. They're prohibited by the non-compete. On your point about the, not having a corporate structure in the first place and just doing away with mergers, that was really fascinating to me. And I had an experience earlier in my career. Although I'd spent the vast bulk of my career at the FTC, I did spend 2 years as in-house counsel for a conglomerate corporation that wanted to turn itself into a pharmaceutical company. I mean, it was a pharmaceutical company. It was American Home Products. And when I was there, they wanted to, the whole mission they had was to transform themselves into a pharma company. And the 2 years I was there, the whole time I spent just doing HSR filing after HSR filing. They were just carving off all these businesses, just selling them off. And I thought, oh my, this is just such an incredible waste of time. I mean, maybe it was bad that they had all those businesses in the first place, but what really got to me was I spent the whole second year working at that company on the American Home Products Monsanto merger, trying to get that through, and a whole year working with agencies all over the world with the filings. And I come to work one day and there's a memo shoved under my door saying the transaction's been canceled, destroy all your files. And so I'm like, okay, that's it. I'm going back. I want to go back to the FTC, which I did. So I don't know what that means. It just got me thinking, though, what you're saying. But I mean, I think for now at the FTC, we're really focused on just protecting competition. We want to be, one of the papers I saw in your packet was talking about, us being referees and calling fouls. And that's really what I feel that we do. And when it comes to labor harm, me personally, I sort of feel a little hampered by the consumer welfare standard, because where's the employee welfare standard? We need an employee welfare standard. So that's...
Okay, great. I wanted to open it up to questions. Steve Salop is the first one I saw. Can you wait till the microphone just so people can hear on the live stream?
I'd like to ask what I consider a bread and butter question that goes directly to what Holly just said. And that is, suppose a merger is predicted to lead to lower consumer prices, but it's going to lead to lower wages because they have monopsony or increased bargaining power in some market. I'll ask this to the whole panel, how do you deal with that, with those facts, with that trade-off? Do the anti-competitive harms to the workers trump the downstream consumer benefits, or do the downstream consumer benefits trump the upstream employee losses, or do you somehow balance?
So I'll start out on this one. Again, this is me speaking in my personal capacity. I think that's very important right now for what I'm about to say. But, we look at them separate. I mean, it's not sort of a balancing thing, You have to look at the labor market. It's a market on its own. And, we're going to hone in on that like a heat-sinking missile. And if it means their whole merger is going to sabotage, well, then, yeah, let's look at what Sanjukta said. Why are they even doing it in the first place?
Does anybody else want to go ahead?
Yes, I actually think this problem has been solved or at least been addressed, not necessarily on the labor side, but think of any merger. Think of any airline merger. And there's an airline merger, and as a result of the airline merger, the merged firm is going to take a plane and move it from route AB to route CD. And that's because there are people who want to fly and can fill up the plane more, so more people will fly. So just the mere fact that the merger is going to lead to a reallocation of capacity within the route system means some consumers are going to be harmed and some are going to be benefited. The Department of Justice, at least my experience has been, does trade those off and aggregate things. And it seems to me that to the extent that there are any either benefits or harms on other sides of the market, you have to aggregate everything together. Now, I understand you could also balance. You could say consumer group one, those AB people, they're really important. Those CD people, I don't really care about those guys. And even though more people are going to fly, I don't really care. I mean, you can do whatever balancing you want, but it seems that to a first approximation, what has been done, and it does seem reasonable to me as a sort of an outcome of just cost-benefit analysis, is that you aggregate everything together.
Okay, so Dennis, so you're happy to undo Philadelphia National Bank and the Penguin case? You're happy to undo Philadelphia National Bank and the Penguin case and the basic welfare standard by adopting a total welfare standard. Is that correct?
Well, I think it's
Dennis
more complicated. Wait, I think it's a little more
I should
complicated.
say for the rest of you, we are generally debating partners, but today he's my student.
So Steve and I frequently have lunch together, and even though the waiter thinks we're having an argument, we're really having fun. What I would say is, if the benefits are inextricably linked to the transaction as they are in an airline merger, I don't know what else to do. And I think what the Department of Justice, or what I would do, which is what they have done, seems pretty reasonable to me. Now, if you're asking me about Philadelphia National Bank, where there are efficiencies outside the market, whatever we mean, well, that's a different question. I think that I can answer easily. No, it's not. So think about output. I make output with labor, okay? I don't know how I can say those aren't linked when I think about them. In the same way as in the American Express decision, even though I disagree with that decision, if markets are closely linked, you have to take them into account. Now, there's a paper I wrote that you've seen, and not every other people, it's in draft form, where I talk about effects in other markets that are complementary, and whether those should be taken into account. As you probably know from me reading the paper, I would say that in adjudication, judges, that would be too hard. But for people at the FTC and the Department of Justice, I think they definitely should look at those and take those into account. And the point I'm making, which is really the second observation I made, is that when markets are distorted, cost-benefit analysis, which is either in the product market or the labor market, cost-benefit analysis knows how to calculate the changes in welfare that result from a policy. And we've ignored that, and as a result, I think, underestimated the importance of getting antitrust correct.
I did want to point out what you were talking about, airline mergers. I think in the past, the Justice Department has definitely done that. If you think about, for example, American U.S. Airways, where they required them to divest a lot of slots and, in their opinion, expanded output. They have made the point in the current Spirit JetBlue merger that one reason why they did not accept the remedy is because they had no guarantees that if things were divested, they would necessarily lead to flights on the same routes.
Yeah, I should say I've worked on a lot of the airline mergers, not that one, not the JetBlue one. I did work on the American one.
Matt, and then Tim.
Thanks. I just wanted to offer a quick comment about Evan Starr's work, which I think doesn't show that non-competes raise wages, but shows that high-wage workers are more likely to have non-competes than low-wage workers. So I just wanted to make it clear
that's fair. It's a correlation.
Yeah, the evidence is pretty solid, not mixed.
Solid correlation, but that's why I said the results are mixed. It's not as clear-cut as, say, Gibson's result on the non-compete, where he said, I look at what happened in Silicon Valley. As a result of getting rid of the non-competes, wages go up.
Okay, just to be clear, that doesn't show a causal factor. It's just correlative.
Tim?
I was sort of expecting a longer question from Matt. So I want to offer a comment, but then I had a question. I feel like this conversation with Steve, this back and forth, it does make me think that just going back to the theme of this conference, the idea of cost-benefit analysis overall governing mergers seems like a bad idea and inconsistent with the statute. I mean, the statute doesn't say anything about cost-benefit analysis. Let's just be clear about that. And I know many minds will go there directly, but it talks about competition or monopolization. And it suggests that maybe we're asking the wrong. Maybe the answer to that, to Steve's question, is to think about, the statutory language, and is there a decrease in competition in these, and what's that look like? And maybe that's related to provable harms, but maybe it's not. But the idea we're just going to come up with two numbers and add them together, and that's why the merger is pro or anti-competitive, is crazy. Or it's nothing to do with the language of the statute, put it that way. So that's my view on that. My question, though, I wonder, just getting outside the sort of narrow merger study of labor markets as markets and harms. A colleague of mine at Columbia doesn't usually do this kind of work. Jeff, he wrote a paper about golden parachutes and their effects on merger activity, and he's interested in the kind of thing that Professor Paul was talking about, which is the kind of mergers that aren't really good for anybody, but happen because of the individualized incentives. And he found a very strong sort of correlation between large golden parachutes and mergers that later on high merger activity or mergers that didn't seem to really help anybody. And I wonder if maybe that's too far away from what we're talking about, but I wonder if there's some way, if anyone has thought about the legal system's ability to think about or conceptualize mergers that really are, harmful and caused by individualized incentives that are involved. It's sort of labor related because as opposed to people losing wages, there's a big payoff involved that's incentivizing the wager. I don't know if anyone's interested in that topic. Jeff Gordon is the guy who wrote the paper.
Yeah.
Well, I do think that the less concentrated the market, the less damage that could be done from that sort of incentive.
I thought you were asking a slightly different question, which is a hard question.
Maybe a better question.
Well, and I think, Vishny and Schleifer did some work on this, which is when they looked at takeovers, and other people have done it too. Oliver, I'm sure, knows this literature better than I do, but my understanding is that some of the takeovers in which then they lowered wages or fired people was a breaking of an implicit contract that they had with workers. And the question is, what is the legally binding requirements of that? And obviously, if it's not a contract and you're at will, you can't do it, but you're destroying a reputation. And the question is, that was this is a literature from about, 30 years ago or something. I don't. Yeah. So that might have been how you were posing the question. And I think what it meant was once you saw all these corporate raiders who could do this, the reputation of a corporation now didn't mean as much as it used to.
So, really brief comment. That's really interesting. I'll look up the paper, but on the general theme of your comment and Dennis's comments as well, I do think it's important to kind of take a step back and consider what's actually happening in these boardrooms and to just be slightly abstract for 1 second. I really like this idea that the economist Gardner Means, who's a very influential New Deal economist, wrote this report called The Structure of the American Economy through the National Resources Committee, I think, in 1939. And he talks about what are we doing when we study the economy? Among other things, we're studying what he called canalizing rules. So I think it's helpful, and canalizing rules, they channel economic activity. They actually channel competition itself into particular directions. Are we competing, on some competition over wages is good, but are we channeling competition to the lowest possible wages, or are we channeling competition toward innovation, R&D? And of course, the argument has been made by many that a tighter merger policy tends to channel economic activity, competition, and investment toward productive activity rather than toward this M&A game. And so, but on the point about sort of individual CEOs and boards, again, a little bit biased by reading the cases that are in your typical corporations casebook, even the friendly deals are, that we then end up classifying as friendly deals, are deals in which many people on the board seem to feel like their hands are tied because there's some shareholder that is looking for a big payout or is looking to mount, or have a takeover bid in the background that's in the shadow of what then gets classified as a friendly deal. So this is a lot of what's happening, and if you look at those cases, what's driving this, as opposed to someone in a boardroom being like, oh, there's going to be all these merger efficiencies if we merge these two routes. I mean, sometimes that's what's going on, but a lot of times that's not what's going on. And so I do think we need to look at the incentives, as you said, and including how the antitrust rules are affecting those incentives.
There certainly can be harm to employees, especially existing employees of the firm, without any increase in monopsony power in the labor market. You can remove duplication that would lead to some employees being firing. You can automate some jobs that were previously performed by workers, either with AI or machines. It seemed like some of the panel mixed these two. I wondered how you think about harm to employees of the firms that are not the result of an increase in labor market power.
On that, one thing I'll say is, thinking about listening, reaching out to labor unions, seeing what they think, how a transaction affects, bargaining that's going on. That I know that's something that we are incorporating in our analysis today. And I think it could potentially pick up some of what you just described.
So how do you think about it? There's harm to employees with no increase in monopsony power. Is that a consideration?
Well, I mean, if they're unionized, we might look at how a merger changes the bargaining dynamics for the union. Does that make sense?
If they're not unionized,
well, that's a different story. I'm not sure, but I don't know. I mean, how would the merger affect their ability to unionize? That's one possibility.
I thought a good question would be, suppose there's unemployment in a region. Should the antitrust authorities take that into account? I would say no, but other people on the panel may disagree. But it seems to me you don't want to confuse macroeconomic policy with antitrust policy. Antitrust policy can only do so much, and what you really want to do is make sure you're promoting efficient production, because eventually that's what's going to win out. That'd be my sense.
I don't completely disagree that. I think production efficiency is important, by the way. I don't think anyone wants to waste our natural or human resources at this point. And I think so, so I think we have to look at, there's simple cases, right? Where, are we running a truck route through northern Wisconsin to get to southeast Michigan? Like, that seems like a total waste. And if we're doing that to preserve employment, that's not a good idea. And certainly we need much stronger macroeconomic policy to support, the Fed has a mandate for full employment. We should maybe I'll be advocating for that as well. I also think there's a lot of connection between the microeconomic and the macroeconomic. For instance, I think that antitrust policy and the forms of coordination more generally that antitrust and labor law promote can have a real effect on price inflation because, again, Gardner-Means showed that a lot of observed price inflation, for example, in the late 1950s, which was another inflationary period, was actually due to administrative inflation, pricing discretion by dominant firms, rather than driven by wages or driven by demand inflation. So I think it's important for antitrust and the macroeconomic, the law and policy that's dealing with the macroeconomy to actually be in conversation. But I would agree that we're not trying to just sort of preserve employment at all costs. But then it, I think, comes into the picture how often are true technical efficiencies actually driving these things? And maybe sometimes they are, but often it seems maybe they're not.
I will give Felix the last comment, and then we're wrapping up.
So perhaps just quickly on that, I think that you could have some mergers between two firms where, let's say you have a multinational, it buys a firm with a plant in, I don't know, somewhere in Michigan or something, and now that firm also has a plant in a low-cost country. That might affect kind of the bargaining going on between the workers and the firm in Michigan, because now you have an outside option where it's easier to kind of relocate production. Even though that's kind of not necessarily kind of monopsony power and overlap in that labor market, that might still be related to the lessening of competition for these workers. And then the other, and so in that sense, perhaps one wants to think about that in in that case. The other kind of automation point and so on, if that's kind of more towards non-competition effects, and that's kind of what I was trying to get at earlier, we probably don't want to completely ignore this because it's going to matter to people, but perhaps other branches of government are kind of more suitable to that and kind of act together.
Okay. We are actually out of time. I apologize, but please join me in thanking our panel.
I ask that you please take your seats. We're about to start. So, good afternoon from Chicago for all of you. Gabriel, are you? Good afternoon from Chicago, and thank you all for joining us online. And of course, thank you to everyone who's here. Today, we're very happy to host our second lunch keynote on rethinking the burden of proof in mergers with Professor Oliver Hartz. Before we begin, please note again that we're on the record and live streaming, and we'll post this on the YouTube channel later. The views of Oliver are his own, not of the Stigler Center at the University of Chicago. And we hope that you join us for more upcoming events, so check our website, check ProMarket, and check the Capitalism podcasts. So now let me please briefly introduce Oliver. So Oliver is the Lewis P. and Linda L. Geiser University Professor at Harvard University, where he has taught since 1993. He's a fellow of the Econometric Society, the American Academy of Arts and Sciences, the British Academy, and the American Finance Association. A member of the National Academy of Sciences, and a distinguished fellow of the American Economic Association, as many other places I could mention. He used to be the president of the American Law and Economics Association and the vice president of the American Economic Association, Law and Economics American Association. And finally, he's a 2016 co-recipient of the Nobel Prize in Economics, a small addendum to it. And so without further ado, I pass it over to Oliver. We're delighted to host you. Thank you very much.
Thank you. Thank you. Thank you, Filippo. I hope people can hear me. So Luigi is a big believer in diversity, and I think he felt that at a conference of antitrust experts, it would be important to hear from someone who knew practically nothing about the topic, and so that's my role. I have, of course, learned a lot in the last couple of days. It's been very enlightening, although I have to say I'm still a little confused about the consumer welfare standard. Okay. So here's a diagram you may be familiar with. I thought we would actually see it before me, but I think Sanjukta mentioned it, but here it is, and we don't have to go through it, except you'll recall that A2, so this is from Williamson, 1968, you'll recall that A2 is the cost saving, A1 is the deadweight loss, and so I have this bullet point, which is probably wrong, given what I've heard, but it sounded from what at least one of the judges said yesterday, I can't remember which one, that perhaps although judges don't consider the possible efficiency gain A2, they focus on A1, that the agencies that are bringing actions may have A2 in mind in deciding whether to go ahead. So my talk is about the size of A2. And we've heard quite a bit in the last session. There was quite a bit about the possible efficiency gains from mergers. People have argued that A2 may be pretty small. There's an interesting paper by Rose and Salat, which makes this point. It's an empirical paper. I'm going to propose a theoretical argument about A2 being small. In essence, I'm going to argue that after nearly 90 years of theoretical work on the benefits of integration, we still do not have widely accepted theories of what they are. And this should give us some pause. And again, I think Sanjukta was making some complementary arguments at the previous session. So let me give you a quick tour d'horizon, which may not really be necessary for this audience. I just don't know how much you think about the theory of the firm. Not everybody does. So nearly 90 years ago, Coase argued that firms could avoid some of the transaction costs associated with markets or contracts by replacing bargaining with authority. Williamson and Klein, Crawford and Alchin expanded on this by arguing that bargaining costs are likely to be particularly large when parties make relationship-specific investments and a relationship is transformed, you can have an ex-ante very competitive situation, then we make these investments, and there's much less competition. They may even be bilateral monopoly. Now, you probably don't need an example of a relationship-specific investment, but just in case, a well-known one, this was studied by Paul Joskow, is a power plant locating next to a coal mine. It's going to use the coal to burn to make electricity, and it saves on the transportation cost of coal. One way to navigate this fundamental transformation is for the parties to write a long-term contract. Indeed, if they could write a perfect, complete, contingent long-term contract, that would solve the problem. Bargaining costs would be eliminated because everything would be sorted out ex ante. But of course, we know it's impossible to write perfect state contingent contracts. It's simply too hard for the parties to anticipate and incorporate all the contingencies that may occur. And if there was any doubt about this, the pandemic is a good reminder of this. I mean, how many parties had pandemic clauses in their contracts? Not many. So it seems that bargaining costs are not so easy to eliminate via contract, but does integration and the authority it yields provide the solution? It would if workers were automata that could be ordered around at will, didn't care about what they were asked to do, and always did what they were told. But of course, none of these things is true. Workers care about what they are doing. They may not always do what they are told, and they can quit, often at a moment's notice. And so the authority that a boss has over an employee is pretty tenuous. So this is a point that was made a long time ago by Elshon and Dempsey. So the whole idea of Cosian authority, people refer to it, but what does it really mean if the employee can quit? I think it's more helpful to think of integration transforming an incomplete contract between two firms into one between a firm and its employees, and that incomplete contract may be just as challenging to navigate. Now, in my own work on this topic with Grossman and Moore, I've suggested that what changes when firm A buys firm B is not that firm A now has authority over firm B's employees, but rather that firm A acquires residual control rights over firm B's non-human assets. According to that line of work, possessing residual control rights protects a party against hold-up when an incomplete contract is renegotiated, because I have more outside options if I have residual control rights. And that's going to encourage me to make non-contractable relationship-specific investments. So that's what that theory is all about. But a problem with that, so it does suggest benefits of integration and also costs of integration. But a problem with this view is that most of the relationship-specific investments that one can think of seem to be contractable. They could be specified in the ex-ante contract. Take the example of the power plant locating next to the coal mine. That seems something that we could contract on. The power plant can make the investment. The coal mine can compensate the power plant for making the investment. At this point, so this is what I think is the theory to date, emphasizing either authority, which it's not really clear how much authority you gain over employees, or integration, avoiding hold-up problems, and stimulating relationship-specific investments. Well, you could deal with those contractually. So I think the theory here is not giving us a clear explanation of what the benefits of integration are. And I think at this point it's worth remarking the most famous case in this literature, the boundaries of the firm literature, is this case where General Motors acquired Fisher Body. General Motors had a contract with Fisher Body to supply car bodies, but then in 1926, GM acquired Fisher Body. And people don't still, there's disagreement about why this happened, with Klein, Benjamin Klein arguing it was because Fisher body had held up General Motors, and General Motors didn't want that to happen again. Coe's pointing out that actually General Motors already had control over Fisher body, and the reason they acquired Fisher body was because they wanted the Fisher brothers, of whom there were many, I can't remember, 7, I think. They wanted them to be on the GM team. So, no agreement about that, and that's nearly 100 years ago. So, okay, all this to me means that there's a bit of quite a big question mark about the benefits of integration. At the same time that people were trying to figure out these benefits, another important development was occurring, I would like to argue, which is that good contracts were and are becoming easier to write. And let me highlight 2 reasons for this. One is technological. Computer technology has made it easier for one party to specify what it wants from another party, and also to monitor what the other party is doing. A very nice example of this is described in a paper by Baker and Hubbard on trucking. So before the 1980s, long-distance truckers often owned the trucks that they operated, and the most likely explanation for this was that this ownership provided an incentive for the trucker to look after the truck, specifically in terms of speed. So a problem could be that a trucker would drive very fast, have a break, a long break, then drive very fast again. That wasn't good for the truck. If they owned the truck, they weren't going to abuse the truck in that way. But then in the 1980s, a new technology became available whereby a trucker's driving behavior could be monitored, sort of a spy in the cab. The result was, this is what Baker and Hubbard show, that ownership of the trucks shifted to the trucking companies away from the drivers, because the trucking companies could write contracts with the drivers saying, you have to drive at a certain speed and we're going to monitor you and see whether you do it. Whenever you talk about technology in this area, people often bring up blockchain. Something like antitrust, I know almost nothing about it. I've never been able to really understand it. But to the extent that I do not think it's going to be useful to improve long-term contractual relationships. So that's a bit of an aside, but I wanted to mention that. Let me turn to a second development that has nothing to do with technology. A long time ago, Macaulay and McNeil argued that contracts alone cannot ensure a successful long-term business relationship. Norms, trust, and the development of social capital also play central roles. And related ideas have been explored by Lisa Bernstein and, of course, in the repeated games literature. And this has led to the notion of relational contracting. In simple terms, the idea is that the parties can do better by combining a contract with the building of a relationship. I've worked recently on this approach together with 2 practitioners, David Friedlinger, a lawyer, and Kate Vitasek, an expert in supply chain management. We suggest that parties can mitigate contractual incompleteness by agreeing in advance to guiding principles they will apply when unanticipated events arise. So 2 of the leading guiding principles are equity and loyalty. Basically, the parties recognize when they enter the relationship that stuff's going to happen that they can't anticipate. They can't put it in the contract. The pandemic would be an example, but of course there are many other examples. War in Ukraine. So they recognize that instead of hiring lawyers to put as much into the contract as they can think of, it's never going to work because there's always going to be stuff left out. Instead, what the parties do is they agree to these principles they will apply to complete an incomplete contract. And these principles, loyalty and equity, as the name suggests, involve each party agreeing to consider the payoff of the other party as well as your own payoff. In agreeing to these, it's not just a matter of writing them down. We have to have lengthy discussions about them, and the approach in practice goes under the name of vested or formal relational contracting. It also involves the parties discussing what they're trying to achieve out of the relationship. So presumably, it's actually something that's very close to the way economists think about it. There's some surplus to be divided, and we're actually going to figure out, how to maximize that and divide it in a reasonable manner. And the only reason I stress this is because this is not the typical lawyer approach, which is often seems to be to treat the whole thing as a zero-sum game. The more I can get from my client, the better, and the less the other person will get, and that's all great. Well, this is looking at it from a rather different point of view. So, okay, what's the takeaway from this? What's the message I want you to hear from this? It is that I think contracts seem an increasingly viable alternative to mergers, including horizontal ones, to achieve any efficiencies. So let me give you an example. If I'd listened to the conference before doing the slides, I would have chosen a different example. I would have chosen hospitals, right? Instead, I'm afraid it's banks. But, it could be hospitals sharing an MRI machine as opposed to what I'm going to say. The principles are the same. So consider two banks that have branches in every community. This may duplicate space and personnel. One facility could serve both banks. So, something you sometimes hear is, okay, we're going to merge in order to take advantage of these cost savings. But the point is the cost savings could also be achieved if the banks agree that a single facility will provide services to each of them. So the facility could be jointly owned by the two banks or by a third party with whom the banks have a long-term contract, maybe even a relational contract. And this, again, this could apply to the MRI machine as opposed to this facility. And technology can also help. Maybe all they really need is an ATM, which they can both access. So that would be an example of how technology could also solve this problem. Okay, in light of the above, here's my tentative suggestion, and this is the title of the talk. Given that contracts can achieve so much, might it be good to reverse the burden of proof for firms that want to merge, at least the ones with a significant market share? Such firms would have to make the case that they're going to be talking about efficiencies. They would have to explain why they cannot achieve those efficiencies in some other way, including by contract. In other words, they would have to convince the antitrust authorities that A2, if you remember back to the Williamson diagram, A2 was the sort of good stuff. A2 merger is significantly bigger than A2 via contract. Now, I should acknowledge that, contractual solutions are not the solution to everything. They can also raise some antitrust concerns. I think that those should be easier to monitor because at least the contracts are visible, or they could be certainly made visible to the antitrust authorities. So I think that might make things easier. So one side benefit from reversing the burden of truth is that we would learn a lot. At the very least, we'd learn a lot. And people like me who work on this, we might find out whether there are benefits of integration after all. So I think it would be a good research experience. That's it. Thank you.
Oliver, as usual, you're way too modest because actually theory of the firm and antitrust are intrinsically related. I was trying to find the exact title of the first book by Oliver Williamson. I think it's Market and the Hierarchies, but underneath as something about what does this mean for antitrust. So the theory of the firm, the boundaries of the firm and antitrust are intrinsically related, and you dedicated your life to theory of the firm. So I think that you know a lot about antitrust, even if maybe you don't know the legal aspects of it. But to this point, I find this idea at the same time super simple, but super revolutionary, because correct me if I'm wrong, but what I understand is basically you see two firms that merge, and if these are two teeny tiny firms, we don't care. But if they're pretty large, we say the burden of the proof is on you to show what you can do by merging that you cannot do with individual contracts, which is not anti-competitive. So, of course, we know that by merging you can fix prices, but that's the reason why we don't want them to merge. We are open to them merging for other reasons other than prices, but now the burden of the proof is on them. And having worked so much in the other firm, what are the chances they come up with an explanation?
Yeah, I have no idea. I mean, it does seem often that what they say is pretty vague about these, these are synergies, sounds good. What is it really? I also think, I mean, maybe the only novelty in what I have said, if there's any, would be, I mean, people have always, I think, asked whether you could achieve the efficiencies in some other way, but often they were thinking about it internally as opposed to contract. I'm not sure contract has been that prominent in the thinking. This is, of course, people know about it, but do they think about that seriously as an alternative mechanism?
But you threw it out there almost like a joke at the end, but I think actually there is a lot of wisdom in what you say at the end by saying, we're going to learn a lot because all the economists will be working and trying to rationalize what you can do with one or the other. So there will be a new literature exploding, and all, of course, we'll be citing you. So I think that's a big thing, no?
Yeah, it may create jobs for economists. I understand that, slight conflict of interest there, but...
One last question, then I open the floor because I'm sure other people are eager to ask a question. We heard a lot yesterday about common ownership. And this is another challenge because take the limit in which two firms have the exactly same three shareholders. We're not there yet, but we're not that far off yet. What are the additional benefits that they get by merging? Because even using your model of property, the property is in the same hands. So what difference does it make to have two merged firms or two firms with the exact same three large shareholders?
Oh, that's a very good question. You didn't tell me you were going to ask that question. I haven't had time to prepare. Okay. In the extreme case, you would say, suppose those shareholders really ran the firms, and so they're separate firms, but they have the same shareholders. Then you could imagine that the firms are already maximizing the sum of profits. In which case, the only difference, I guess, if you had a merger, is that instead of having two people making decisions, it would almost be like joint management or joint control, which, sometimes we know people argue and they disagree, and so maybe sometimes it's better to have one person making the decision, which the merger might achieve. At the same time, I hear what people like Martin Schmaltz are saying. I'm still not sure that I fully believe it. In practice, in other words, you can run the regressions, which he does, and that's nice and important, but I would like to hear the stories of people doing this. I'll just throw I read a column, something about Burt Malkiel in the Wall Street Journal, because of some anniversary of his Efficient Markets book, and I think he was asked about this common ownership stuff, and he's on the board of Vanguard, I think, and he said, I've just never seen anything like that. Now, in contrast, when he was asked about environmental things and shareholder pressure there, he said, oh yeah, that's good for us, because we work on that. That resonated with him as something that was really going on. Now, he may be biased and so on, but I would like to see the smoking gun there.
But would be another argument against allowing mergers, because you already achieved most of what you can achieve in this way. So you have to prove that
well,
need
but
more.
then you would need to perhaps get rid of all these interlocking shareholders. I mean, if that was really going on, that would be, serious.
Okay. Questions? Yes, Steve.
This is a little different. A little off topic, but I think it would be interesting for this group. In terms of your basic model, would it make any difference whether the workers own the firm or whether the shareholders own the firm? How do things change when it's a worker-owned firm hiring the managers than the managers owning the firm and hiring the workers, or the stockholders owning the firm and hiring both the managers and the workers? So in light of the discussion we had in the last panel, that might be an interesting issue to address.
But that's not about mergers, right?
No, it's not about mergers. It's about your other work.
Yeah.
And it's a more basic issue.
Yes, well, I mean, we do have some work and managed firms out there. They don't seem to be terribly dominant. I mean, there's some notable examples, but if you think of the biggest companies, the most powerful companies, they're not. I mean, and I think there's I basically think people should be able to set up companies any way they like. And presumably the reason that they typically allocate votes to shareholders as opposed to workers is because they need to raise finance. I mean, I think that's, in spite of it, I mean, Henry Hansman has a very interesting book on this, but he rather de-emphasizes that, but I've never understood that. I mean, if you want to, raising equity capital is a very efficient way of raising finance, and of course we know that shareholders don't have, what protection do they have? They don't have contracts with the firm, and that basically as a shareholder you get a dividend if the firm feels like paying you a dividend. So you get something else instead, which are votes. So I think there's a reason we see most firms set up with shareholders having votes rather than workers, but not sure that's the answer to your question. But
I guess to follow up, to make it more precise, the workers seem to be lower in the hierarchy. They're not the ones that are controlling, say, relative to the executives, rather than thinking about it as the workers hire the executives. And that I think is a puzzle that a number of people have been thinking about. Why doesn't the baker hire the CEO rather than the CEO hire the baker?
Well, I think of it more as a contract. I'm not sure I find that such a useful distinction because, I hire you or you hire me. It's basically we are in a contractual relationship with each other. It's not clear that one of us is superior to the other. I mean, it may look that way, and I'm sure non-economists definitely think it is that way, but economists tend to think of it as just a contract. We're on the same level. Now, I think the question is who has the residual control rights? And actually, it turns out it'll be neither of us probably. It'll be the shareholders who elect the board, who chooses you as the CEO, and then you contract with me.
Okay, we're going a little bit off the topic. Tommaso.
Tommaso, yes. So thank you very much. I love your idea, and in fact, in the next panel, I would have said the same, so I don't have to participate to the next panel.
I'm glad I went
That's great.
first.
No, I will take questions. That's fantastic. I just wanted to give you an example. You mentioned ATM in the banking sector, but perhaps another example you may want to think about is in mobile phones or cellular telephony, as I think you call it here. There are many mergers constantly. These companies, anytime there is a new generation of technology, 1G, 2G, 3G, 4G, 5G. They say technology is different. We have to do massive investments. We need to consolidate, and because that's going to bring efficiencies. The argument is always the same. We know for some reason, empirically, these mergers, 5 to 4 is kind of okay, but really the threshold is 4 to 3. 4 to 3 are terrible for consumers. Prices always go up in a 4 to 3 merger. Unfortunately, you allowed these kind of mergers to happen in the United States, and prices, surprise, surprise, are higher than anywhere else in the world, and so your bills are kind of expensive. In Europe, though, we took, at face value, the arguments we need to merge for efficiencies, the 4 to 3, said, what kind of efficiencies? We're going to do network sharing. It's called network sharing. So in some remote areas, instead of having duplication of investment in cell, we're going to share them. And then the enforcers in Europe said, okay, if that's what you want, do network sharing. Why the merger? So we have not allowed those mergers. We allowed a contractual arrangement about network sharing. Having a look at those contracts as well, because you don't want those contracts to become anti-competitive. And we preserve the efficiency argument that the parties were bringing, still with some competitive pressure on the prices. And by and large, coverage in Europe is as good as the United States, and prices are half of the United States. So this is just another example of what you had in mind.
Tommaso, you did not allow, but a German telephone company did merge from 4 to 3.
I wasn't there.
Because Angela Merkel made pressure. Speaking of political influence on antitrust, and it says there are rules for everybody, and then there are the rules for the Germans that are different.
So I was just interested in how your proposed criteria would interact with Section 1 of the Sherman Act. So if, yes, I could come up with an agreement, but that agreement would fall afoul of Section 1. Is your view that you'd have to prove that you couldn't do it with an agreement that didn't fall afoul of Section 1? Or would you concede that just because of the nature of contracting, there are circumstances under which the only way I could do it by contract would be a contract that would be questionable under Section 1. So in a weird way, it's that fact that makes the merger actually the right way to do it? Or is it just clear that what you need to show is that there is an agreement that clearly does not violate Section 1 before you would allow the merger?
Okay, my ignorance. So Section 1, is that about price fixing?
No, Section 1 is just about any agreement. So in the Sherman Act there are two provisions. One violates agreements that restrain, that hurt competition, and the other one is monopolization. That's Section 2. And then Clayton 7 is the one that deals with M&A. So okay. The criteria, again, depending on what the precedent are, they're not exactly congruent.
Well, I would say that so I'm not in favor of agreements that lead to monopolization, anti-competitive agreements. I think one of the advantages of contracts is the authorities can look at them and decide. So I think the question would be, can you come up with a contract which is not anti-competitive that achieves the efficiencies? At the same time, and if you can't do that, that suggests the merger is also about monopolization. So I would think in that case, you certainly wouldn't approve the merger either.
In a sense, your very question, when you said, it's easier to do it with a merger, you are recognizing that many mergers are happening precisely to go foul of anti-competitive rules, or pro-competitive rules. So I think that, Matt.
So I'm thinking about a particular merger, which was the AT&T Time Warner merger in 2017. That was a fairly significant, it was a big merger, and it was just something of a disaster. There was potentially an attempt at monopolization or not. The judge in the case didn't agree. but the merger essentially was unwound a few years later because it didn't work out. And the goal was, well, AT&T has this distribution network through largely mobile phones, and Time Warner has all this content. What if we put the two together? That will be very exciting, and they can compete with Google and Facebook and online platforms. And it didn't work out from a logistical perspective. And I wonder if you think that being forced to do the disciplinary act of writing a contract, saying here's how we're going to benefit, Time Warner and AT&T, you have distribution network, we have content, might have mitigated that immense waste from that merger. And if writ more broadly, you do see immense waste in the form of mergers, and that focusing on doing things through contract might be a way of mitigating this kind of mess.
Yeah, I like that. I would agree with that. I also think, one of the reasons, this came up at the previous panel, that who is the merger benefiting? Maybe only the people at the top, and maybe they're doing it, and it could be not for monetary reasons. They could be empire building. I think that's one of the reasons that, there's a lot of evidence that these mergers often don't yield much or negative. And I think, so empire building mergers are less, if you're doing it by contract, you're not empire building. So that might also be good.
There's one party that always benefit are the investment bankers. I remember many years ago, I was at a meeting of investment bankers with some students, etc. And I said, why don't we get a contra pay on the announcement effect of a merger? You get a fee that is positive and a function of the announcement effect of a merger. The investment bankers were not happy with that. Eric.
There are actually a lot of cases where courts reject mergers because the parties are unable to show that the efficiencies are merger specific. It's the term used. And in fact, the court will hold you can obtain these efficiencies through a contract. But the cases are hard to understand because the courts are never very clear about the test that they're using for distinguishing between a merger, an efficiency that can be obtained through contract versus only through a merger. And one senses it has something to do with economies of scale, but you could obtain economies of scale through a contract, so that can't be it. And I thought what you were going to do is use your earlier work to propose a test, because your earlier work provides, does provide a model for explaining the conditions under which firms would more efficiently merge versus enter into a contract. And I wonder whether you could, maybe I missed it, but I thought that where you were going to go would be a test would be very useful, so that a court could just, if it could be simplified, could just take the party's argument about the efficiencies and then rule whether the defendants make a plausible argument that they can obtain these efficiencies only through a merger. So is there something using, your Grossman-Hart model? Could you propose a test for merger-specific efficiencies?
Well, I think what I'm suggesting, Eric, is very different from what, you're saying that they need to convince a court or whoever that the efficiencies cannot be achieved by contract, right? The only thing I guess part of this talk is saying that I'm not as convinced by the earlier work, including my own, as having really identified what these efficiencies are. So I gave you the example. Relationship-specific investments. The big ones are contractable, I think. We're left with sort of rather vague, non-contractable things. I don't know whether these are first-order importance anymore. I don't know anymore. So I don't know whether that's the answer. It's, yes, I'm trashing myself to some unquestionably, but also those who came before me.
We can just cross out. I'm tempted to call on Carl. Can I do that, Luigi?
Yes, please.
Thank you. I think following up, I'd love to hear, and I suspect I'm not alone, if you could say a little more, Oliver. You said now the big investments are contractable. And could you say more about why you think that's true? And maybe I'll just give another example that I like AT&T, Time Warner, just fine that, but let's go with T-Mobile, Sprint. So that's your 4-3 merger in mobile telephony. So they had this same, we're building out 5G and we're going to be much more efficient by sharing towers. And let's tell a little version of the story where they say, well, it's going to take place over the next 5 years and we're going to consolidate our networks. And we can't write down a contract right now about what that's all going to look like, but we'll have to work it out over time. It depends on how technology changes. So how would you tell whether that was contractable or not, whether that claimed efficiency should be counted as only achievable through a merger? And share spectrum, thank you, Steve. Share spectrum as well.
Sorry, what?
They were also building towers and sharing spectrum rather than each using it for their own operations.
Is building towers not contractable? I mean, I think about, so the co-authors that I've worked with, the practitioners in recent times, so they describe outsourcing contracts, which are complicated. I outsource my software or something like that, and IT. I outsource my IT. There may be many investments involved in that. The parties have to make investments. They talk about what they're going to do, who's going to pay for what. It doesn't seem to be impossible.
Is it important that they be able to sign the contract at the same time that they would do the merger, or is you saying contractable, we'll work out a series of contracts over a number of years, and that's a good alternative to a merger? Is that what you have in mind, a series of contracts over time?
No, not a series, a long-term contract.
But there are lots of uncertainties then.
There's a lot of so then the question is,
a lot of contingencies and so forth.
Yes, absolutely. Coming back to, I don't want to say that this approach that my co-authors and I have worked on is the solution to everything, but you might want to look at it. If you go to my website, you'll see the paper. And
that's the answer to everything, I know.
Using these guiding principles to resolve disagreement seems to work pretty well. This is what these practitioners have found. So I think I'm talking about a relational contract. Yes, we know that stuff is, of course we can't contract on everything. That's also true inside the firm. It's not as if, this comes back to my bullet point, maybe it went a little fast, about, when you put in a new technology, this can, some of the workers who are used to working with the old technology can be quite upset about that. I mean, that's a thing, that's a real thing. That's, again, an incomplete contract. We have contracts with workers, they acquire skills, then we change direction. Or the example that was given, Dennis was talking about, some implicit contract with workers and then it's breached by the new boss. So these are issues also inside the firm. I don't think that doing it inside the firm solves all these problems. So maybe the best way to deal with both inside the firm contractual incompleteness and outside the firm contractual incompleteness is to have some guiding principles about how you're going to complete the contract ex post. I don't see a huge difference between them. One is clearly superior to the other.
At the cost of boring everybody, this is actually a topic in which I know something because I was on the board of Telecom Italia, and at some point they actually decided to sell the towers outside. And so there was the reason was stupid because they were thinking that they will save on the cost of capital, but let's keep that aside. But there was an interesting discussion about whether this was a convenient, not convenient thing to do. So on the one hand, if I want to be on the other side, I said, at the end of the day, they did it. So it is possible to sell the towers. And so if it is possible to sell the towers, a fortiori it's possible to write a long-term contract to manage the tower together. They sell to a third party. Okay, some people inside the board were saying, actually, the risk of selling the towers is what happened when a new technology come about that changes for example, how much space you need in the tower. And then you have to renegotiate. And I guess that your answer is you have an equity principle, you negotiate in fairness. But I see that in that situation, there is a tension. So that's the part that makes it challenging.
There is a tension, and the question is, how can we find ways to get over the tension? And I mean, just, the example of Chrysler and Daimler came up earlier. I mean, I think that was an example of a cultural clash. The different groups had different ways of doing things. And I mean, there are many examples of mergers which fail because the corporate cultures are not the same. That's an example. I just mentioned that because it's an example of how problems arise inside firms. Again, it's not as if you can just order everybody around and get what you want.
Yes.
I think this is interesting, but I wonder if by suggesting placing more emphasis on the ability of firms to identify efficiencies that might justify a merger, if you would expand the categories of efficiencies that the agencies should consider. You focused on efficiencies and whether they can be contracted for or not. One area of efficiencies that I've seen in practice on both sides, in government and outside government, is an effort to move the assets from weak management to stronger management, entrepreneurial management. And I'll give you an example. Near the end of the Trump administration, the FTC blocked 2 mergers involving shaving products. Large firm wanted to buy, Harry's. And one of the arguments the parties made was, the folks who started Harry's were just superior managers to the folks running Edgewell. And the agency almost uniformly discounts those arguments. It's sort of easy to say Edgewell could just hire the better management. But often that entrepreneurial manager does not want to leave the assets. So if you're going to, expand the importance of efficiencies, would you expand the category of efficiencies? And would you, in some sense, lower the threshold for the agencies accepting those types of, efficiencies that cannot be easily contracted for?
Yeah, that's an interesting example. Actually, I think it ties in with the empirical work that Chad did with Hortex and Atelier. This paper, which was actually quite a challenge to people working on the theory of the firm, boundaries of the firm, because what they found was that companies that buy other companies, they don't typically then buy the product from them. So they looked at concrete. Well, what an example would be concrete companies that buy cement companies, right? I know cement is used to make concrete. Is that right?
Yeah, I think so.
I'm never quite sure I got it the right way around. But so you would think that, they're doing this because they want, to be confident about their input. They're going to buy cement from the company they just bought. Turns out, no, they don't. They continue to buy cement from other companies. So why on earth are they doing it? Chad et al. Argue, at least in my interpretation, I think they say this, is that if you're in the concrete business, you may also know how to run cement companies. You may feel, this company's not being very well run, and I'm going to run it better. I don't need their input. And I agree that in cases like that, a contractual solution is probably not going to work. Why do I think that? If you push me, I would say it's probably the case that egos are involved. So that if instead of buying your cement company, I said to you, you know what, I think I know a way to run your company better. I just need a profit share, and I'm going to make suggestions to you. and you'll see how brilliant they are, and you'll implement them, and we'll both win. I suspect that won't work because you will actually reject my suggestions because, you know, you have your own ideas and you're not going. It's just it's an ego thing, I think, and therefore I actually need control. I don't want to just feed suggestions to you. I want to be able to implement my efficiency enhancing suggestions. So there's long answer. I do think in cases like that, control is important. So you are asking what happens if, I mean, a lot of those cases, there probably wouldn't be antitrust concerns.
Well, there are some, right? What I'm basically asking, if you're going to place more emphasis on efficiencies, you know, should the agencies be more accepting of efficiencies that are less,
that
less
kind of
hard?
Efficiency,
I mean, this is, I think of this as, I mean, Tim Yaris gave a speech, 20 years ago, new institutional economics, transactions cost economics, sort of thinking about some of these questions in that way. And that's, a number of the people you've referenced yourself thinking that way. And this is not a criticism, the staff at the agencies just don't have a good way to get comfortable, that individual managers are not, homogeneous goods, basically, and they become they're dismissive of those arguments, and
I think one would have to take that kind of argument more seriously. I think another question though would be whether somebody else could, we have a takeover market, so another way to replace inefficient management is not to have someone in the same industry buy the company, but to have someone make it, an outsider make a takeover bid. So I think that would have to be considered. But yes, I would consider that.
Thank you.
Just 1 second.
Great, thank you. And this actually follows on from the last question. So part of this is informational. I wonder what set of mergers your proposal will affect, because there already is a presumption for horizontal mergers that increase concentration substantially. We already shift the burden of proof. There would be other mergers where there's not any antitrust question. So then the residual mergers would be, there's some antitrust question, but it's not what we call the Philadelphia the national bank set. That's horizontal, increases concentration, and you shift the burden of proof. So I assume in the set that you would be looking at, the defendants can always come forward and say it's not anti-competitive, and they can win if they can prove it. And for those where you do shift the burden of proof, here I want to bring in the last question. Efficiencies are usually not a defense. Efficiencies are taken into account in thinking about what is anti-competitive. But if the merger is anti-competitive, and let's say price raising to make it clearer, it is not a defense or an offset that the merger is efficient. So right now we have a pretty narrow area where defendants have an opportunity to prove efficiencies, and in the United States it's really narrow because it's really the area where they're proving that because of efficiencies the merger is not anti-competitive. It's not like Canada and some jurisdictions where the merger can be anti-competitive and the firms can come in with an efficiency defense. So I would be very concerned if, I think your last answer was, you might want to expand the purview for efficiencies in thinking about what's contractable. Was that clear or not? Was that?
Yeah, I think it was. It was clear, but yes, let me think about the writer. Well, you're saying that, I guess my sense was that people, although
well, two things. I was saying, how much does this change?
Yes, how much
Anything.
does it change? Well, to the extent that right now people are not looking at efficiencies at all in the US, which is that what you're saying? Then,
except for a few hospital mergers where courts have allowed the efficiencies to come in, they're hearing, they're listening to all the claims of efficiencies, but they're listening to them in terms of, will this make the firm more competitive? Will it make consumers better off? It's not listening to it in terms of, oh yeah, we know prices are going to go up, but it's an offset.
okay, but suppose the efficiency defense, but suppose they're saying we're going to have such great efficiencies that prices will come down.
Then the merger is usually not anti-competitive, and it's
but
very, very rare.
But I would think that argument, instead, then the authorities should come back and say, well, why can't you get those efficiencies some other way by contract? And then we wouldn't be worried about, the increased market power you would have. So it would be a win-win.
So actually, to the extent that efficiencies are provable, it has to be efficiencies that could not be achieved in any other way, which would include by contract.
Well, if that's the status quo, then I didn't need to give the talk, but I get the
no, you needed
which is quite possible. But I got the impression that at least somebody in this decision-making process, it could be the FTC or the Justice Department, I don't know. Maybe it's not the courts, but somebody is thinking about efficiencies and maybe deciding whether to bring a case based on that. And I think if that's true, then what I'm saying is still relevant.
Right. So it's absolutely relevant, even though it sort of comes in background in the conversation, but it focuses on contracts it really puts much more on a pedestal that there were no cognizable efficiencies because contract would have done it.
Yes. I mean, let me just put it this way. I think, in a way, I was saying I'm sort of attacking my earlier work and that of other people. Because I've been working on this for decades, and I assumed all along, of course, there must be benefits of integration and costs of integration. So because we see firms merging, we see firms demerging, something important must be going on there. But I guess, having thought a lot more about what can be achieved by contract, I guess my current view would be maybe it's 6 of one and half a dozen of the other. Yes, we see people doing it. Some people do it this way, they do it through a merger, some people do it by a contract. It's not clear that there's really a huge difference between those. So that's just a change in thinking. If you accept that, I think you probably will think about some of these antitrust issues a little differently.
There was one last question there that has been waiting for a long time. This is really the last, and hopefully short.
I can give it real short, and this is wonderful. I'm struck at how much of the analysis relies on assumptions or characterizations of the behavior of individuals. And I'm thinking in particular your exchange with Carl. Are you resisting the opportunism assumption that is embedded in so much of Williamson's work? And I guess relatedly, we in law school, should we not be telling our students to always look out for their clients in a very risk-adverse way?
Well, it's not that I don't think there's opportunism, but the question is, can we do something about it? So opportunism doesn't disappear if my company acquires your company. I'm not saying it stays exactly the same, but now you're a worker. You were an independent firm I had a contract with. I could be opportunistic to you before. Now you're a worker. You're the manager of the division. I can be opportunistic again to you now in a different way. You can be opportunistic to me. I think the challenge is, can we mitigate opportunism? I've suggested these guiding principles as a way to do it. There may be other ways to do it, but I think that may be the thing to think about as opposed to integration as being a sort of solution.
Okay, on this magic board, thank you very much, Oliver.
I guess one more minute. Okay, so hopefully this mic works. Hi, everyone. I want to start by thanking the organizers. I'm truly delighted to be here. I'm Elettra Bietti, a former European antitrust lawyer and soon-to-be law professor at Northeastern School of Law in Boston. And today I'll be moderating not one, but 2 panels on the consumer welfare standard. So get ready. So lots of economies of scale or network effects. So both panels are about trying to bridge beyond the consumer welfare standard, thinking about new ideas. And you've already heard a lot about the consumer welfare standard, so I'm not gonna say more myself, and I'll let the speakers kind of introduce their ideas. But first, because I'm a bit of a strange animal at this conference, I'm not formally trained in economics. I'm potentially, strictly not even an antitrust lawyer. So my research is primarily in law and technology. And so I want to start and open this panel with a reaction or a provocation, a reaction to the idea that antitrust needs to be grounded in a unitary, clear, and coherent standard or principle or test, and that we, as people interested in antitrust lawyers, economists, need to strive for legal certainty and predictability in this discipline. So in March, I was struck to see some remarks that I heard about some remarks that Chair Khan had given, where she had said that antitrust enforcers should not wait for the most perfect, immaculate facts before starting cases, but instead that, maybe there was value in experimentalism, maybe there was value in starting cases even where one is not exactly sure about the facts they're dealing with. And that, suggestion was met on social media with a lot of backlash and pushback. And that really made me think about the idea of certainty, of facticity, of coherence being really ingrained in the minds of lawyers and economists. And so I see a lot of the papers in this panel or in the next panel as really about a common quest for a unitary principle or goal for antitrust law. And so the question is, if the consumer welfare standard doesn't work, or we're not satisfied with it, or it's not coherent enough, then what alternative but equally or more coherent principle can we replace it with to set antitrust law on a better path? But if we stop for a second, we realize that the consumer welfare standard is not perfect, and yet antitrust law has evolved for more than a century. And so the question really is, why search for one principle? Why not leave antitrust to be grounded in more ideas and values? Why can we not leave antitrust law more open? And so maybe we should accept that antitrust is a set of statutes that could do all sorts of different things, could be repurposed in many different ways to pursue many different ends and goals. And so, in short, what I'm suggesting is the potential for more pluralism or experimentalism in antitrust. And I'm probably going to leave this here, but I'm very happy to engage more with the speakers. And generally, I don't think the Consumer Welfare Center is something to be rejected or sidelined necessarily, but it's something to be thought about in dialogue with other values and norms. So with this said, hopefully I've provoked you enough, and I will set us on a more constructive and concrete path. And I want to introduce the first of our 3 speakers, who's here on my left, Herbert Hovenkamp, James G. Dinan Professor of law at Penn Law School and also at the Wharton School. I'm not going to say more. You can look at his bio. He's one of the most prolific and influential antitrust law scholars in the United States.
Thank you. Thanks, Beata. Thank you. Okay, I'm going to talk a little more positively than normatively for a little bit, looking mainly at the way the idea of consumer welfare has developed in antitrust history. First of all, the courts did not use the term until the 1970s. It appeared in Ryder versus Sonotone. I believe it was discussed yesterday in a case that granted standing to end users. And in the same decade, in a dissent by Justice Brennan from the court's approval of a merger. So the first two uses were actually pro-enforcement. Up till that time, the courts got along fine by stating the goal of the antitrust laws in terms of output and price. That is, the goal of the antitrust laws was to reach and address restraints that tended to reduce output or to reduce market output or increase price. They drew that in part. We owe a lot of the early development to Judge Taft's opinion in Addison Pipe. They drew a lot of this from common law decisions. One of them, Morris, run on the slide, says what a lot of common law courts said, that cartels were efforts to limit the supply in order to enhance the price. A number of courts spoke in those terms. The early courts were fighting with it, Addison Pipe in particular. Both of the railroad cartel cases in the 1890s, Alcoa, which is misplaced here as a Section 1 case, spoke in terms of restriction of production. Moving forward then, Indiana dentists, reduction of output, the first NCAA case, price fixing and output limitation. And then the last two Supreme Court cases to speak about the issue, the last two Supreme Court cases, Amex, reduced output, increased prices, or decreased quality. And then Alston versus NCAA just 2 years ago, the capacity to reduce output and increase price. That usage has been consistent. Not every single court has made these claims. They don't always use exactly the same words. Many of them use both output and price. A few use only one or only the other. Let me just suggest that output is a better metric for most of them because it enables us to avoid getting tripped up by the thinking that consumer welfare is all about price. Output is measured by quantity, quality, or innovation. Any one of the three, and the courts have made clear that a restriction on any one of the three can be actionable. I would be fine with dropping the term consumer welfare. I'm not fine with dropping the idea that antitrust fundamental concern is with restraints that tend to limit output, market output, or increase price. I'm trying to cut back on my slides here, but Justice Brandeis was of the same mind. Justice Brandeis was a consumer welfarist on this ground. He had two big joint venture antitrust decisions in his career on the court. Chicago Board of Trade is the one that's reprinted in pretty much every antitrust case book, so pretty much every law student learns it. Begins his discussion by noting that the government made no attempt to show that the challenged rule was designed or had the effect of limiting the amount of grain shipped. And then he goes off on this thing that is both the most quoted statement in the antitrust lexicon and I think one of the most damaging, where he says, well, in order to figure this out, you have to look at the history of the industry, the description of it before and after the restraint came into existence. You all know what it says, and it basically launched a century-long period of very, very complicated, long antitrust records in order to figure out what was going on. I think Brandeis's best statement of the rule of reason came in 1931 in the Standard Oil of Indiana case. Now, that case involved a joint venture technology transfer agreement among a group of firms who had developed the technology for cracking, which was a large-scale mechanism for refining crude oil into gasoline. It involved a lot of cross-licensing of patents. In dismissing the government's complaint, these were both dismissals of government complaints, Brandeis simply observed that no monopoly or restriction of competition has been proved, and then he gives a much, much more forceful and practical, brief, almost brilliant encapsulation of the rule of reason. He says, okay, they didn't restrict output. They had a market share of 26%. The gasoline that was produced was identical to the gasoline produced by others with the old technology. Under that set of constraints, Brandeis says, the defendants could not have reduced output even if they had wanted to. And so with that, he dismissed the complaint. So you get in and out of the rule of reason in about 3 sentences in Standard Oil as opposed to a half a page in the Chicago Board of Trade. Consistently through the Sherman Act, the Clayton Act, all sections, both before and after the Feller-Kefauver amendments in 1950 and right up to the present, the courts have stated the goals in terms of restraints that limit market output or that increase market price. We've had 2 episodes. Go back here. Sorry, Professor Hart, I'm using your figure again. Except this is the one that comes from Bork's book, not the one that comes from Ollie Williamson. So this one's from 1978. We've had 2 episodes in which the courts have sanctioned the reverse. That is, Brown Shoe produced, condemned an output increasing merger. District Court was pretty clear about that. That the merger had the effect of producing better shoes for the same price or higher quality shoes. Better shoes at a lower price or higher quality shoes at the same price, and then launched into what was actually a fairly brief episode, about 10 years of mergers that condemned output increasing transactions as illegal. The other place that we see pushback on high output is in Bork and also in Williamson. This figure is a photocopy of Bork's book, all except for the badly drawn red ellipsis at the bottom in red. That's my doodling. In the Bork figure, output drops by what appears to be roughly 1/2. In the figure that Professor Hart put up at lunchtime, that's Williamson's figure, it drops by about 1/3. But the one thing I want to point out is Williamson was firmly of the position that efficiencies could not be proven. But what he never addressed is how is it that this firm, this is a single firm in his story, how is it that this firm could reduce output by half and simultaneously with that achieve such extraordinary efficiencies? Now, the efficiencies in this figure are an absolute black box, or 2 horizontal lines before and after. They don't discriminate between fixed and variable costs. All I can say is this firm must not have had very high fixed costs, because fixed costs go up when output goes down. So if that was the case, what was the source of the monopoly? But nevertheless, in Bork's picture, while efficiencies are, while output is going down by half, costs are going down as well. I think it's time we put Bork to rest and return to a standard of increased output, but by the same token, I think it's time to put brown shoe to rest. They are both abominations to the history of well-managed antitrust policy with the welfare of consumers and incidentally of labor in mind. That is, as markets expand, consumers benefit, but labor benefits too, and that's where we should be with the so-called consumer welfare test. Thank you.
Okay, so our next speaker also needs no introduction. He has more positions at various universities that I can mention, but he's a professor of economics and also the head of the Department of Economics and Public Policy at Imperial College in London, and was the chief competition economist at EU's DG Comp until 2019. Tommaso Valletti, please.
I'll stay here. Thank you. Thank you, Elettra. I should update my CV because currently I have one position and that's it at Imperial College in London, and that's about it. So great to be here. You started by asking a question, why do we need a unifying principle? So I haven't thought enough, but maybe it's an imperfect analogy. But if I ask you or even myself, I mean, what do I need to do on my job? You would probably say, well, I need to do good research and deliver good teaching. This is the unifying principle of what we have to do. Then we can go in a discussion, how do you measure good teaching? Is it the evaluation of the students? Is it this number of students who pass the exam? Or is it the learning journey they get? So what about research? Do you have the curse of the top 5 like we have in economics? Or is it about impact? So in the same fashion, it's useful for organizations and individuals and firms, including antitrust, to have a unifying principle. What do you do? And then we want to make sure that competition policy, make sure that competition works in the interest of society. I mean, that's what it wants. I mean, it's a simple principle, and I think it's fine. So we don't need to be too open either, because otherwise it can go all over the place. And in a sense, we're also doing a little bit of empiricism. As people who know me know that I'm very dissatisfied with the status quo, and we need a change. So we need to experiment with alternatives, and it's going to be exactly what I will propose now. But we need to stay focused on competition, right? So which is fine. So my proposal, and it's not a theoretical, it's not an abstract one, is guided a little bit by the challenge of Luigi to do something which is practical, actionable. And my starting point is that we talk a lot, we don't do much, and the world changes. Okay? So I'm dissatisfied with the present state of affairs, and I think we need to change. Because that's very vague, but I will be precise. You may completely disagree with me. You may be super happy with the status quo, and then of course you just are going to disagree with everything that follows. But this is where I am. And I'm going to concentrate on mergers only. Mergers are kind of boring. For economists, it's more fun to do abuse cases because it's more complex, it's more articulate. But I think that mergers are super important. I mean, before you try to undo the abuses of market power, you may try to prevent market power from arising. And market power often arises through concentration. So I think that mergers are practically very relevant. Let me give you some numbers also. We talk a lot, we do a little, yet when the world is changing. So I'm not going to give you my views about general trends of the economy, but just bear in mind that 20, 30 years ago, the DOJ was challenging a certain number of mergers every year, which were in the range of 3 figures. Now they're challenging, in the last decade or 20 years, about 50 to 60. So they are litigating this kind of, so these are 2 figures. But also ask yourself, how many mergers happen in the US every year? Because you have to put things in context. Otherwise, numbers are just too vague. And the answer is about 20,000. Okay, so I'm not saying that most are fine, but this is the order of magnitude: 20,000 mergers, of which 50 may have some legal challenge in front of the DOJ. So that's where the magnitude of. And in the meantime, we had trends going all over the place in terms of concentration, labor market share, margins, profitability, etc. So my proposal, which it's not a proposal, it's something which has been lingering around in many forms in this room over the past couple of days, it's called in a very boring jargon, it's called rebuttable structural presumption. Rebuttable structural presumption. So it's actually our proposal because I had fun to write a little piece with Filippo last week for the purpose of this conference. So the idea of a rebuttable structural presumption is that size matters, structure of an industry matters, and the proposal is very simple. So it's going to say, if you're big, there will be a presumption that further growth via an acquisition has a potential of having a great damage on society. Okay? You cannot buy another firm. You cannot. Unless, this is the rebuttable component, you can prove that you really need the merger, which was the previous talk by Oliver. There's no alternative to the merger to achieve something that is going to give a positive impact on whatever your welfare metric is, on society. But you can also reduce it to consumers, citizens, it's workers, it's fine. So this is a proposal that plays around with two things. One is the burden of proof, but also with the standard of proof. And this is for legal people, legal-oriented people, you know what I'm talking about. And there are two components to it, the burden and the standard of proof. Obviously, if you're a journalist in the room, rebuttable structural presumption is not going to make the headlines. So if you want a headline, the proposal is this. If you're big, make, don't buy. Okay? That's the proposal. Make, don't buy. So it's a very pro-competitive proposal. Big firms have the resources, the ability to do their own investment. It's not something which is banning firms from expanding organic growth, going into other markets, but make rather than buy. Okay? Make rather than buy. So let me elaborate a little bit on this in a couple of minutes. We think that this proposal is based on economics and something that is, I wouldn't say it's lost, but it's a useful reminder. And the reminder coming from economics is that in the absence of efficiencies, okay, that's the starting point, every merger is bad for consumer. Let's not forget that. In the absence of efficiencies, any horizontal merger is bad for consumers. So this is a starting point coming from economics. We concentrate on the big firms because this is where there is a greater probability of significant consumer harm. Okay? And again, it makes a lot of sense. If you're big, if you have anti-competitive, the effect on prices, on output will be magnified. And the idea, again, based on economics, is typically the overall effect depends on the reactions by the non-merging firms that would compensate for the market power acquired by the merging parties. But if there are very few outsiders, because the market is concentrated, this possibility to react is diminished. Okay? So that's why there is a significant consumer harm. It's also based on economics from another point of view, which is asymmetric information. So enforcers don't know the business plans of the firms. The firms know about what they want to do, okay? So it just shifts. That's a burden of proof. You tell me, you know what you want to do with it, okay? If you think you have an efficiency motivation which is cogent, show it to me. So the debate is, again, from an economist point of view, is efficient to do so. It is predictable, because if you are a big firm, and I'll get back to what I mean by big, you cannot buy another firm. More predictable than this, it's difficult to argue. It also, we express in our little piece with Filippo, it takes into account real-world limitations. You may want to call it a resource-based view of agencies. So this is part of my dissatisfaction in my stint as an enforcer to see how much time and resources were wasted on the wrong stuff, like market definition, proving that super dominant firms are dominant, going to this delineation, super narrow markets, having all sorts of discussions going on. That was a waste of time, but it was burning resources. I mean, very important resources. In the end, it's not that the DOJ cannot, I mean, they can fight a few battles at a time only. They cannot do everything. So instead, because you start with a presumption, avoids entirely this first step, or to a large extent. So this would solve that too. So in terms of our modest proposal, indicators for size, well, we have 3 types of indicators. You don't need to have a single one. You can have an array. Again, everything is on the website, as we heard earlier as well. Also, this is on the website. But indicators can be firm-level indicators about size, turnover. By the way, they are being used in Europe in the context of digital, but it is not about digital for the DMA. So they've been looking at monthly active users or something like this. So there is a series of indicators that, which in that context was for the designation of which are the platforms to be regulated in certain ways. But you can do that. I would add to this firm level data also margins that Europe didn't consider. I'm aware that Eric has a proposal in that sense in the later panel. Then there is transaction level indicators that can be used. Fantastic, useful information is in the purchasing price. So we almost never use that, okay? And there are some practical proposals. There is Massimo Motta with Chiara Fumagalli and Emanuele Tarantino have a proposal. It's a theory and empirical model on how to do that using some empirical data. There is another proposal to use I'll tell you. Yeah, it's called the economic goodwill test, which is looking at net tangible assets of a transaction. A third category of indicators can be industry level. I say industry rather than market because I am aware that otherwise you fall back into the trap of this very narrow delineation of markets. I think this is useful information to look at industries rather than very narrowly delineated markets. I've done some work with European data if you're interested. But these are indicators that, the thresholds, of course, there will be a political decision on how to put those thresholds, which is fine, but those will delineate which ones are the firms which are subject to this kind of provision. Okay? This is telling also that I see a change in the type of economics we can do in cases. Ultimately, I'm an economist. I think some enforcers are already going there, but some not yet. So more industry studies, to have an industry unit that collects this systematic evidence, multiple indicators to delineate who tell us who's going to be these guys which are subject to the structural presumption. So more of this type of work about industries using statisticians, but also economists, industry experts. That is very important. The academic works, which has been presented also at this conference, Felix or Thomas or Martin or Florian, this is great work. Keep doing that. But also be aware, if you're an academic, this work is not actionable for cases because you don't have the time. You will have a month to decide. So you cannot do that. But this work is super important to inform the discussion of whether we want to have the structural presumption, where do we set the threshold, what kind of distribution of firms we have in an economy. So that is great work to inform the policy debate rather than running cases. On running cases, there's going to be a different type of work, in my opinion, also for the consultants. Okay, despite some of my views towards the consultants, I think that currently the economics that the consultant do is not very useful in the sense as too often is there's little models which look sophisticated for the lawyers but are not very sophisticated from an economics point of view. Just because there are a few Greek letters and a few regressions, it doesn't make it sophisticated in economics, in economic terms. However, too often that line of work is a discussion about, the model itself, whether the model has any predictive power on what happens. Anytime, too rarely, but we've done some exposed assessments of our surgical models, we found out that prices went up. The remedies that we imposed to eliminate overlaps, well, assets disappeared from the industries, and ultimately consumers were worse off. So it's they haven't worked very, very well. We have to acknowledge those models. There's a whole industry around it. Don't work very well. Okay, so they're useful to think, to frame trade-offs. But if we think we can use those models to measure those trade-offs, I'm sorry, I've changed my my mind. So instead, the consultants, the economists, will still have a lot to do, but working, getting their hands dirty on the case itself, on the efficiencies, on the motivation for the business. And I'm sure there will still be a thriving industry of consultants bombarding the enforcers on the benefits of the mergers, but at least the discussion will be on some real meat rather than some abstract discussion about is the relevant market. So earlier we were talking about Instagram, Facebook, it was online camera apps. I mean, you shouldn't even get there. You shouldn't even get there, in my view. Of course, there is the elephant in the room for some of you, which is efficiencies, but I will probably comment on what I think about efficiencies later on. Thank you very much.
Thank you so much. So our third speaker is Stavros Makris. He's a lecturer in competition law at the University of Glasgow in the UK. Before that, he was a teaching fellow at LSE, as well as he got a PhD in competition law from the EUI in Florence. Go ahead.
Thanks a lot. Thanks a lot for having me. It's a great pleasure and an honor. And in 7 minutes, I will be pitching an alternative to the consumer welfare standard, a pretty daunting task, especially since I'm sharing a panel with one of the most prominent advocates of the consumer welfare standard and one of my personal antitrust heroes. Anyway, so let me start with the three reasons in my mind, the three main challenges in my mind that competition law will be or is already facing in the 21st century. First, we have climate change, sluggish growth, inclusion problems and structural inequalities, contesting the direction and quality of growth. So perhaps we need to rethink these two issues, the direction and quality of growth, in order to ensure social cohesion without transgressing our planet's ecological ceiling. Second, we are all aware about it, digital markets are a game changer. We have new business models, they change the playbook, we have new methods and ways of value extraction and value creation. And third, we are witnessing things and issues and concerns that have been actually extramural so far to antitrust, concerns related to privacy, sustainability, inequality or democracy, claiming a seat at the antitrust table. So against this background, we need to ask, and this is what we are actually doing, is the consumer welfare standard satisfactory? So the consumer welfare standard actually is pretty well defined. It's consumer surplus, right? So the difference between the reservation price and the price consumers are actually paying. So it's clear to a certain extent. Second, it has a compelling message. Competition is there to reduce prices and maximize output. And it also has a concrete metrics. Higher output is better. However, in my understanding, consumer welfare, despite its strengths, suffers from certain perhaps fatal shortcomings. Yesterday, we discussed why sometimes what we measure might not be interesting. And especially in digital markets, we have non-price effects. We might have also competition relevant also in other markets, sustainability concerns or privacy concerns. So somehow the terrain of competition has moved. So in this context, I pitched this idea of the effective competitive constraint standard, which actually redefines or recalibrates, in a sense, the notion of harmed competition. In a nutshell, removing or suppressing effective competitive constraints without any offsetting benefits is a harmed competition. We don't need to prove actual or potential consumer harm. There is a fundamental assumption there. Also, in terms of burden shifting exercise, the plaintiff will have to demonstrate that there is a suppression or a removal of an effective competitive constraint, and we will use different legal tests to define what is this kind of effective competitive constraint, and then the defendant will have the opportunity to offer pro-competitive effects or benefits as a defense. As a standard, it's pragmatic. It doesn't require an abstract or idealistic inquiry. enforcers or courts need to compare competition in the market with and without the practice. This is a well-known counterfactual, and it asks for a scrutiny at 3 different levels: at the market context, not necessarily the relevant market, at the features of the different market participants, they might be relevant, and also at the form of the conduct. And the underlying idea behind this standard is something that we already discussed yesterday. Professor Fox mentioned that we have antitrust, we have competition law because we value competition. We might all have different underlying values or ultimate ends to protect competition and wanting to have antitrust, but the core mission of the law is to protect effective competitive structures. Then the overriding reasons or the underlying values that we might have can inform our analysis. How can this happen? For instance, if you have a look at the recent commission decisions, Dow, DuPont, and Bayer Monsanto, the commission, without looking at price effects, and Professor Valletti did a lot of work in this regard, took into consideration the impact of the merger on innovation competition. So their innovation plays a role. It informs how we understand the competitive process. So now 2 words about the relationship between the consumer welfare standard and the alternative. So both standards converge when it comes to agreements that have collusive effects. They are bad. But the effective competitive constraint standard is stricter, let's say, towards different forms of vertical control. Why? Because different types of vertical restraints can be used as a vehicle for eliminating effective competitive constraints, for instance, by raising their costs. When it comes to monopolization cases, both standards converge to the as efficient competitor test. So exclusion of an as efficient competitor is problematic, but this is not enough, if you ask me, because the test is quite underwhelming, the as efficient competitor test. So the effective competitive constraint standard goes a step forward. So naked restrictions that do not have any other plausible explanation than the restriction of an effective competitive constraint will be presumptively unlawful. Exclusion of less efficient but important competitors that exercise some significant competitive pressure, will be also presumptively unlawful. Practices like raising rivals' costs, same. And also something that we are witnessing in digital markets, platform using new kind of strategies that cannot directly be translated in price effects. For instance, the weaponization of interoperability or the copycat strategy, or using default settings to steer demand away from key rivals. Also, these kind of practices could be under specific tests, qualify as prohibited. And lastly, when it comes to merger control, again, the 2 standards converge when we talk about horizontal mergers or vertical mergers that have non-coordinated or coordinated effects, problematic. But on top of this, under the ECC standard, conglomerate mergers that lead to portfolio power or portfolio effects, and also nascent or killer acquisitions because they suppress or hurt an effective competitive constraint, will be presumptively unlawful. And what is the way forward? There is an institutional way to move forward. Competition authorities can come up with guidelines explaining their standards, setting up performance benchmarks, then running some cases, and then revisiting their performance to find out whether they got it right or wrong, or whether the remedy worked or not. Okay, this is it. I'll stop here.
Thank you so much. Okay, so I have a couple of questions, and then I'll open it up to the audience. I guess my first question was directed at Tommaso, but it seems like he already partly answered my question. So I will direct it at any panelist that wants to answer. And so I was struck in the paper that Tommaso and Filippo wrote, I was struck by kind of the introductory portion, which really emphasizes this idea of a general standard that is specific, predictable, and accountable. And I guess I'm gonna just ask this question again. What do we mean by a specific, predictable, and accountable standard or test? Are we talking about a metric? Are we talking about a rule? Are we talking about a presumption? earlier today, Professor Wu, I don't know if he's in this room, struck me as somehow, so he was commenting on yesterday's panels. I wasn't there yesterday, but he mentioned, or he kind of, in my view, conflated the idea of emphasizing the importance of structure and ex-ante rules with the question of clarity of goals and principles. So these two things seem to me very distinct. You could have very clear ex-ante norms or rules, or legislation setting the rules of the game, but at the same time leaving the principles or goals of an area of law like antitrust open-ended. So I just, if any of you has thoughts on what you think, a clear metric or principle can do, that would be helpful.
Take a shot at that. Number one, courts can rarely measure welfare. Under very simple assumptions, they can, but under most realistic assumptions, they cannot. Number two, they frequently cannot measure changes in output cardinally. That is, how much a price went up or how much output went down, although there are almost no cases that require a cardinal measurement. That is to say, it wasn't necessary in Alston to show how much wages were suppressed. It's never necessary in a cartel case to show how much prices are increased or decreased. What you need to know is the general direction. So you need to be able to do an ordinal measurement. And I think courts can do that with some help from experts in the great majority of cases. So if the question is, does output tend to go down as a result of this restraint or merger or prices up, saying output, in my view, is usually the better metric. That is within their reach. It can be hard. It can be hard in particular if output has to be measured by things like innovation. It can be easy if all we're doing is counting bolts and nuts or something like that. Then that leaves the only question, is there a significant divergence between changes in output and changes in welfare? And I think the right answer to that is that it's much closer to never than it is to frequently. That is to say, output and welfare are not perfectly correlated, but in the great majority of cases, they go in the same direction. There is no U.S. case that I know of that has made a finding of increased output but decreased welfare or vice versa. So for my money, ordinal changes in market output, not individual output, market output is the best measure, and it's probably the measure that's closest to being within reach of the courts.
So this is where I probably disagree with Herb, in the sense that Herb said courts know how to measure changes in output. I disagree. So we have a set of methods that we can discuss what the methods is predicting. However, we need to revise our priors in light of what's happened in the past. So we have used for 20 years those methods, which are merger simulation methods, and systematically we have approved mergers with or without remedies, and the remedies were meant to eliminate any anti-competitive concern. And then, empirically speaking, we see that those prices go up. Yes, the world is complicated, sure, but at least they should be. Sometimes let's look at how have we performed in practice, and we haven't performed well at all. So to say that we have this belief that we can measure, sure, we can measure, but what do we measure? So this is also my personal journey. I thought that antitrust was very narrow in looking at price effects. I thought we could measure them, and then I thought, but in economics, our utility function is a big concept. We can include choice and quality and investment. And I try, and so we can do better with economics. In theory, yes. In practice, this is my experience with the Bayer Monsanto, the innovation theory of harm. You mentioned the Dow DuPont. we made even a bigger mess because there is an endogenous response as expected from a political economy point of view. When there are big interests at stake, billions of dollars out there, and you try to bring in something which is well-motivated, well-intentioned, based on economics, and then you have a whole industry that will react to it and throw doubt and make it even more difficult. And then in the end, the discussion is about how does a little model perform. Useful to think about trade-offs. Useful to, do we know how to measure that? No. So the clarity which I try to bring is in the structural presumption. In the structural presumption, this is the clarity. This is the clarity, okay? And that's is actionable. The structural presumption is that size matters. It's based on economics, on first principle. Do we need to measure that? We are gonna still measure, based on facts and empiricism. Do we need to run a regression? Do we need to run a merger simulation model? It's complicated to the n power to take into account. No. We don't need that.
Yeah. So just one comment about output. So take, for instance, a private sustainability initiative among different washing machine manufacturers that together they decide, because otherwise they would be suffering from a collective action problem, to withdraw an energy inefficient washing machine. This is a reduction of output, but simultaneously it might have countervailing benefits. And I'm saying that because output is very important. I agree it features also in the case law, and it's a very good way to think about competition law, but I have my doubts on whether it can be the only metric or whether it should be the only metric. And to connect with your initial question, letter that I find fantastic, actually competition law is normatively open, relatively, because it uses an elastic vocabulary and it has a fuzzy mandate, and also it relies on positive and normative economics inevitably, and also it regulates capitalism, which is a system in constant evolution. So it is open, but we don't want it to be too open. Why? Because we care also about the integrity of the system. It's a law, and it's to be applied. It's to provide practical solutions to practical problems. So I very much agree with the approach that says, let's look at specific benchmarks and metrics. Is output the only one? I had doubt on this. So maybe we can have a standard and then use economics and the development of the law through courts to devise particular standards, for instance, for particular industries or specific problems.
Let me just add something about the structural presumption. And the question is a pretty fundamental one. Is the structural presumption contingent or absolute? That is to say, do we use market structure in merger analysis because we think there is a link between a concentrated market structure and performance measured by price or output? There are those pure structuralists who would say, no, structure is bad for its own sake. That's not the position we have generally taken in merger law in the US for a long, long time. It's not even the position that was articulated in the 1968 guidelines, and certainly not in the 2010 guidelines. No, structural presumptions are mechanisms for making judgments about the effects of mergers on output or price. They are hard, and there's lots of qualifications. They're difficult to measure, but when we use them correctly, they are mechanisms for measuring how consumers, workers, and others will be affected, and not simply for their own sake.
So to clarify, structural presumptions, but I think we agree there. So in order not to have any misunderstanding, this is not punishing size. This is not saying that you're big, hence you're bad. We're not saying that. So organic growth can happen. Internal investment can happen. We are simply saying, once you reach a certain size, these are the biggest firms, that's where the greatest harm can happen. You're not allowed to grow any further via acquiring a rival. That's what it says, okay? It's not about, it's fine. You may be big because you're efficient. That's fine. There's nothing wrong with that. I'm not saying I'm going to break you up because if there was a structural presumption that big is bad, I will go a step further. This is simply applied to mergers. You cannot buy another firm, and then I throw the ball into your camp. unless you prove it to me. And then I can apply a high standard of proof, a low standard of proof. That's a discussion. I would personally think that the bigger you are, the bigger the potential harm, the higher the standard of proof that you have to follow in order to prove those efficiencies.
So I just want to add one little footnote to this exchange, which is that I think it's interesting to think of structure in terms of the effects on outputs and prices, but I also think that some antitrust scholars are thinking about structure in terms of democratic governance, for example. So structure affects the ways in which companies participate in politics, the kind of power they have, the kind of leverage they have on the political and kind of social and economic sphere.
How are you going to apply it in an antitrust case? I mean, antitrust is complicated, even if you have to focus on output effects and price effects. And as soon as you have to start adding in something like what's the impact on democratic values, you know, as noted earlier, there are roughly 20,000 mergers per year in the U.S. I think roughly 2,000 are reported under HSR. I could be wrong about that, but 2,000 or 2,500. And then the agencies have the monumental job of shifting through those. I'm always aghast and impressed at the size of that task. And I don't know how you would do that if you have to start taking into account other kinds of values like democratic principles.
Well, Herbert, again, I think there is a fundamental misunderstanding there. We are not arguing that you should necessarily, in a case, look at the impact on. Yesterday, Luigi was asking about lobbying. However, to the extent that we have empirical evidence that the biggest firms in the economy are those that lobby the most. Sorry to make a plug-in for this recent work I'm doing with Andrea Pratt and Bo Cowgill. We do find that every year, because of merger in the United States, about $3 billion extra dollars a year are being spent on lobbying. So all this useful information can feed into the discussion about the structural presumption, not about how you would run a case, but where do you put the thresholds for those firms to stop growing even further?
Most of the lobbying in the U.S. is from trade associations, not from single large firms. By a pretty wide margin.
Have you read our
those
paper?
trade associations are typically made up of an array of firms, many of which are fairly
you're
small.
moving around the discussion, because I was saying that kind of information feeds into, through a democratic process, through the agencies, in understanding, through the academic collective work which is being produced, into understanding whether or not we want to introduce a structural presumption. And it's very clear what the structural presumption says. It doesn't say, then after that, you will have to look into how the merger will contribute to further lobbying. I didn't say that.
Okay, so I have a long list of questions that I could ask, but I really want to hear from the audience. So I'll take some questions. I don't know. Maybe I'll start there. Yeah.
Okay. So I applaud the ambition and the ideas and how you're thinking about this. Would you comment a bit on how you see this new principle of antitrust fitting within an administrative state where you have sector-specific agencies, and how you think whether it fits in or it conflicts? I think from the perspective of the companies, that they feel like they're serving a variety of agencies, and then so could you imagine this new antitrust principle could take the place of the sector-specific agencies, or does it need to fit with it? And the example I'm thinking of is UK, which you know obviously very well, Tommaso. Since Brexit, there's a huge shift in the ministries and the agencies. And so, maybe it's not the best example because there's a shifting of all the companies and then even the government policy. So how does how would your principle fit in within that kind of framework? Because from the company's perspective, they need to be able to fulfill the requirements of their sector-specific regulator as well as the competition authority. Does your principle just work there, or could it be a cleaner sense that you could just work with the competition law and then get rid of the sector-specific part, or they go together?
To the extent that I understood the question, I think it would be a general principle. It would be a general principle that would apply across industries. Of course, if then the evidence is going to tell us that some industries are completely different from others, you can start adapting it. But distinguishing, discriminating among industries is not easy to implement. So I think, talking about actionability, whether or not it is actionable, I think a single unifying principles on the structural presumption would be applicable across the economy. Of course, if there are specificities about regulated industries, those can be taken into account by the sectoral regulators, which do exist. But in general, I would apply to pharma, to telecoms, to everywhere, cement, whatever it is.
And the U.S., both the antitrust agencies have the authority to enforce Clayton Section 7. So it's the same substantive law. And that's why we wish and hope all the time that the two agencies get together and issue guidelines in common. And most of the time they do. Where we get some problems is like if something involves the transfer of a broadcast license, then the FCC has to approve a merger under a public interest standard. And it keeps its own counsel on that. And then frequently you have two different agencies that need to approve. I don't think that's ideal, but it's just a fact of administrative life.
Eric Postner.
Question for Herb. The merger cases you have up there, I agree, that they talk about output and price and all that. But my impression from reading the cases is that there's no way a court would approve a 2-to-1 merger or a 3-to-2 merger that resulted in greater output and lower price. How do you reconcile that with the consumer welfare standard?
I think in most cases there won't be a conflict.
Imagine there's a case in which costs go down so much that prices would go down. What would the court do there? Am I wrong in thinking that the court would block the merger? And if that's so, isn't that inconsistent with the consumer welfare standard?
I don't know how a court would come out. I mean, I don't think there's ever been a case where you've had a merger that clearly increased output, promised to increase output and reduce costs, but because it concentrated structures so much. I can think of some possibilities. One of which is, it's actually one that arose a lot in the early 20th century, where the equilibrium in a market is one firm. There's a big debate about whether Uber and Lyft in equilibrium should be a single firm.
Sure, a natural monopoly.
A natural monopoly.
Right.
And so suppose two firms in a natural monopoly should merge together. I'd be inclined to let them do it, but I've got no precedent to say that.
Okay. Sanjukta has a question.
Okay, yeah, thank you.
I think the mic.
Mike. Oh, I'm sorry.
I can talk loudly.
I can hear you.
Yeah. So I guess I wanted to ask about how predictable the consumer welfare standard actually is. And I am a lawyer, not an economist. But I'm very interested in understanding the economic theory. And so here is my question about that. We say, first of all, we've heard different things, in the last couple of days, that it's lower prices most of the time, it's output. But my question is, in a given case where we have to look at real world markets, right, not just looking at the model, what's the normative benchmark against which actual prices are to be compared, especially once we consider that, as everyone agrees, most markets aren't perfectly competitive. And specifically, we've heard many times in the last couple of days that, monopsony is a concern. So we know that monopsony depresses, according to the model, that it depresses prices below the competitive level. My worry, it's just a pure theoretical worry, is how do we know? I mean, we can measure and come up with numbers, but isn't there a circularity in figuring out whether there is pre-existing, we can't simply just compare it to real world prices, because those prices could always potentially be depressed artificially, right? And I think the more general version of this worry is that if most markets are imperfectly competitive, how do we actually figure out is it actually so obvious within economic theory what the second best solution that moves us closer to the perfect competition benchmark is? Because it's not quite obvious to me. And then obviously the ultimate payoff of asking this inquiry is that, so wouldn't it actually be better to come up with bright line rules based on a set of considerations, such as the structural presumption, also other rules that the FTC can come up with? So, but really the theoretical question is the question I have.
I mean, if the question is, there are a lot of hard cases. There are. Output can be very difficult to measure. We don't have to have a benchmark. We don't have to come up with the perfect solution. What a court needs to do is look at the particular transaction or restraint in front of it and ask whether the effect of the restraint tends to reduce output measured ordinally. We need to know the direction, not the amount. That's exactly what Justice Brandeis did in the Standard Oil case. Can we always answer that question? No, probably not. But with inferences drawn from market share of a relatively well-defined market, or, for example, if we're doing unilateral effects mergers of residual demand, we can come up with tools that will enable us to do it. Cartels usually, particularly single product cartels, are pretty easy because typically the cartel raises the price. And that's pretty much all we need to know. We don't need to know how much they increased the price. We don't even have to know whether they were successful. But so the cases can range from reasonably easy to very difficult. But only a few of them, I think, are beyond our capacity to measure.
But this is, again, the casual empiricism that we cannot avoid scrutinizing somehow. So we have methods. So the answer, from an economics point of view, you do merger simulations. There's a counterfactual. That's going to be the alternative to the merger, and you're going to assess it. Fine, in theory. In practice, these models that we did have, that's my view, have not performed well, didn't have any predictive power on the actual behavior of prices post-mergers, by and large, and we cannot avoid confronting ourselves with that. We cannot, okay, in the context of antitrust. And then there are, two possibilities, okay? If you are dissatisfied, as I am, with the status quo. I mean, if you're happy, then forget, let's go for coffee, not beer, perhaps. So there are two ways. Either we make those models even more complex, which in theory, yes, but in practice, given the asymmetry of the incentives, resources, etc., is not gonna be conducing ourselves to a good place. That's my belief. Or we are gonna make it simpler based on economics, based on things, bright lines, etc., etc. That's where I stand. So I don't know where Herbert or Stavros stands, but I have an idea, of course. But.
Can I weigh in? Yeah, so I agree that to a certain extent the standard is elusive because in the end, if you think about who is the consumer, the EU and US, both systems disagree because in the EU, both final and intermediary consumer customers count as consumers. So this is a very different take on who is the actual consumer. And the second thing, when it comes to the measurability of consumers' welfare is what are we supposed to do when, for instance, a merger brings out certain innovation gains, but also simultaneously leads to static inefficiency? How are we supposed to deal with this kind of balancing exercise?
Okay, we have a lot of questions. Maybe I'll try to collect at least two. So there's one question here.
Thanks. I kind of want to question the premise of whether we need a standard, and I'm kind of anti-create a new standard, and because I think the consumer welfare standard or other forms of standards are conflate and cause a distortion to the law. So we already have a principle or a series of principles. It's called the Sherman Act. We have another one. It's called the Clayton Act. We have another one. It's called the Robinson-Patton Act. These are different laws. They say different things. And by saying, well, we need a standard for antitrust, you're collapsing all those laws into one. And that seems both undemocratic and imprecise. We have other standards in other laws, like the Federal Communications Commission, DOT, like there's banking. Congress writes standards. That's what it does. That's what these laws are. So it causes overwriting of the law. Robinson patent, don't enforce it anymore. And yeah, parts of it include the word competition, but parts of it don't. 2C doesn't. And we just decided, because of a standard, not to enforce. And that strikes me as deeply problematic. Another problem with trying to create a standard is it causes an overwriting of the evidence. So Mark Zuckerberg wrote in an email, "It is better to buy than to compete." How is that not attempted monopolization? Like if you say, "I did the crime," it seems like that's a confession. I think we have to ask the question, why do you have to prove the crime in theory when somebody wrote down that they were doing the crime in email? You see this, like there's this company called Equality Ventures, and they literally say, "We invest in monopolization." I mean, it seems like that's a problem for the law. And then the last thing is by sort of administratively rewriting the law, which is what is happening when you create a standard, you're confusing judges, and you're saying you have to guess the future, as opposed to a structural presumption or rules that Congress made very clear. We are trying to protect small businesses. We're trying to address corporate concentration, which you can tell at the time whether they're doing it or not. A lot of these tools and techniques rely on knowing what the future is. And I think judges are getting frustrated with that. I know the judge in the T-Mobile Sprint case called it dueling crystal balls. People are really, everybody last night, the two judges both said, we want things to be simple. And you can't predict the future. And that's just a problem with an output-derived standard. So I just want to kind of like be I'm not anti-standard. I'm just pro the standard that Congress wrote, as opposed to what a bunch of other people with no democratic legitimacy just kind of made up.
Well, that mixes a fair number of evidentiary issues with issues of what the standard should be. The Clayton Act, for example, Zuckerberg.
Can we collect another question and then you can all give
okay.
your
Let me
final
just finish one
remarks.
sentence. The Clayton Act has an express effects test in it. It doesn't matter whether Zuckerberg acquired Instagram because he didn't want to compete under Clayton 7. Now, the FTC didn't bring it under Clayton 7, but under Clayton 7, you have to show what the effect of the merger is, not what the intention behind it was.
Okay, so there's a question there from, okay, there are so many questions, okay.
Did I get it? Did I win? I won the microphone lottery.
Sorry if we can't.
So
take all
I'll do this quick. I'm with Matt. You
There's
can't.
two other panels on this. So. No, go ahead.
Me. Okay. I'm with Matt. You can't predict the future, so let's not. So here's the thought experiment, and I'll call it Schrodinger's merger. And the idea is they walk in and they say, Time Warner is a perfectly fine example, the firm that can't stay bought. AOL, Time Warner, 2000, divorce 2009. AT&T, Time Warner, divorce. Okay. They walk in and say, we think this is a good idea, but we don't have the evidence to prove that. We won't meet your presumption test. Let us run the experiment. A year or two, we'll open the box. We'll see if the cat's alive or dead. Cat's dead, we'll hire more investment bankers, we'll sell it off. If the cat's alive, now let's go down that path. One path is you bring a Section 2 case. Different path is we design some sort of golden share mechanism to give the government to say, we looked at it, we know you want to keep it, you have to get rid of it. All right, I'll stop.
Okay, so the last, you have the opportunity to respond to two questions and also offer closing remarks.
So on Schrodinger's cat, let me even flip this example and say, but in principle, something even simpler, which is, two parties want to merge, very simple case. We commit not to increase prices next year, okay? And if next year prices are going to go up, you're going to undo the merger. I mean, this has been proposed multiple times, but in a word of incomplete contrast, because the word is complicated, you will have, armies of lawyers that will say we had to increase because there was Ukraine, there was a pandemic, something. So it's unfortunate. It's not going to work. So a contractual solution like that. So in principle, yes. In practice, I heard Oliver at light. In the practice, I'm going to tell you, well, this is really the standard of proof. I will block it. I will say AT&T, Time Warner, don't do it until you give me evidence. If you don't have that evidence, bad luck. Come back next year if you want.
Okay, so a response to your points. So for me, to have any standard is better than having no standards. Why? Because first of all, the language of the Sherman Act is open textured. So what is a restraint of trade, or what is a monopolization, or an attempt to monopolize? We need an interpretative principle. Call it a standard, call it a principle, but we need a guiding idea. And second, why we need that is because when, for instance, we have interpretative theories or proposals, for instance, for a structural presumption or whatnot, on the basis of this principle, we can assess, we can falsify or not whether this proposal or another proposal or doing nothing makes some sense or not against the interpretative principle that we distilled from the text of the law. And your second point about the subjective will of Zuckerberg, there, my competition law response would be we care about effects, not about subjective will. So we occasionally hear trash talk or this doesn't incriminate anybody. So I don't see the crime there, the antitrust crime.
We need a standard, but it has to be one that tribunals are capable of administering, or at least reasonably capable.
Thank you so much to our distinguished panelists. Stay tuned for 2 more panels with new ideas.
Great job.
Okay, I think we should start.
But we'll resolve it by the end of the day.
The prisoner's dilemma part is really interesting.
Steve and I have been agreeing a lot recently.
I've moved over.
Okay, we should start. We should start. There will be time for questions after the panelists introduce themselves and present. So because this is the second panel that I'm moderating, I will not offer introductory remarks at risk of repeating myself. I think there are lots of issues already on the table. And as you'll see, we may be moving slightly from more theoretical first principles questions to the more particular applications, perhaps, or some kind of trade-offs in practice of how different proposals and different standards might come head-to-head against one another. The first panelist that I will introduce today is Eric Posner. He's a professor here at the University of Chicago and also a fellow at the American Academy of Arts and Sciences. And you can refer to the bios please go ahead.
Okay, thank you. My claim here, I'm going to make two claims. Claim number one is that the consumer welfare standard has no foundation in merger law. I'm going to focus on merger law just because I know it better than other areas of antitrust law. What is this based on? Well, it's based on the language of the statute. The statute says that mergers are forbidden if they substantially lessen competition or tend to create a monopoly. That says nothing about consumer welfare. I realize that Herb disagrees with this. I just learned that a few minutes ago. But to take the extreme example, a merger to monopoly, two firms merging to one, who, because let's say it's a natural monopoly, results, and there's a high level of efficiencies, results in a lower price. I'm pretty confident that no court would approve that merger. If anybody has any evidence to the contrary, I'd love to hear that. But that would satisfy the consumer welfare standard. So the question is, why do people think that that merger law reflects that the consumer welfare standard characterizes merger law? And I'd say the same thing about a 3-to-2 merger, or really any merger. Okay. Nor is it the case that the courts have changed the law. So a lot of people have gotten angry with the Supreme Court for, changing antitrust law over the last few decades, but it hasn't said anything about merger law since the 1960s and early 1970s. And in its famous merger cases, it more or less just parrots the language of Section 7 with various elaborations and says pretty clearly that a merger that results in lower prices will not necessarily be approved. Nor have the lower courts endorsed a consumer welfare standard for mergers, although the lower courts are a lot less clear than the Supreme Court. And I'll come back to that point in a moment. Also, the consumer welfare standard is not the same as what I'll call the competition standard, as other people have, the standard that's actually in Section 7. However, there are, in some of these unclear judicial opinions, some hints that they are actually the same. That, in fact, as one court puts it, the so-called economic conception of competition embodies the consumer welfare standard. So I don't think that makes any sense. There is an economic conception of consumer welfare, which is just the consumer surplus. And there are various economic models that are used to try to understand competition. And they're obviously not the same thing. So we have a mystery here, which is why do so many people claim that the correct standard for evaluating mergers is consumer welfare? So I think most people here more or less know the answer, but I've spent a long time, way too long, trying to get to the bottom of this. And the place to start is, of course, with Williamson, and I'll spare you the diagram. I don't actually have any slides, but so Williamson's article has been cited at least 2,000 times, according to Google. I doubt it's ever been read. I mean, maybe it was read, 50 years ago. The actual trade-off, that what he calls the naive trade-off, and he meant naive. He was being self-conscious about this. That is 2 pages long, and then there's a very much longer section of the article, which is about 10 pages long, which is called qualifications. Now, the naive trade-off model is just efficiency. So, as he says in various publications, he was in the Justice Department at the time. Like Socrates, he goes around asking these lawyers, what are you doing? How do you decide whether to challenge a merger? Like Socrates' interlocutors, the lawyers say, "Oh, we don't know." And so Williamson says, "Well, I'm an economist, so let me think about this." And he says, "Oh, well, you should challenge a merger if it's inefficient, if the deadweight loss is greater than the cost savings." And that's his naive model. But then he actually acknowledges that that's not what the law is. And he goes on and he talks about all the reasons why the law is different. And he points out that Congress, in enacting and reenacting Section 7 of the Clayton Act, was concerned about all kinds of things: corporate power, the distribution of wealth, what Williamson calls social discontent, which, in the 19th century meant things like, corporations hiring people to beat up workers, and today means, pick your example. Okay. So people, the public, people don't like big corporations. I mean, they like, the cheap goods and high quality goods, but they are uncomfortable frequently with large corporations. We all understand this. And Williamson, in this qualification section, talks about how there are all kinds of ways that could be legitimate, all kinds of methods that could be legitimately used to address these problems. And he just says, look, this is not part of my efficiency test, but he doesn't say there's anything illegitimate about them. In fact, he says at one point that maybe the top 100 firms in the country just shouldn't be allowed to merge at all, period, because of the political implications of those mergers. Okay. Interestingly, by the way, in the IO literature, which I've skimmed a little bit, Williamson's efficiency test, which is not the consumer welfare test, that's what the economists use in their models of mergers and industrial organization generally, because that's what economists think about. That's efficiency is their normative benchmark. When you look at the qualifications, the thing that jumps out at you, and what Williamson understood as well as anybody, what people don't like about big corporations is not just that they raise prices sometimes if they have market power, but they hurt people who are not actually their customers, right? This is the non-consumer welfare effect of corporate power. So it could be political, it could be social. Those are the qualifications. Okay, second stage is our friend Bork. Bork, as everybody knows, as Herb has pointed out, Bork makes 2 contributions. He just takes Williamson's efficiency test and mislabels it a consumer welfare standard. The other thing he does is he dismisses all of the qualifications. He says they don't matter. He says in the antitrust paradox, if they matter, Congress can pass legislation to address them, ignoring the fact that Congress actually did pass legislation to address them. That was Section 7 of the Clayton Act. And so after Bork, everybody ignores the qualifications. Okay. At some point over the next 20 years, 30 years, all of this enters into agency practice. And you see it become more and more a part of the merger guidelines. And you can see it in various agency documents, including, there are lots of, for example, for those of you who don't know, like summaries that agencies publish of what they do. At some point, the falsely labeled consumer welfare standard becomes a real consumer welfare standard. I'd like to know how exactly this happened, but I think it must be that lawyers at some point, or maybe the economists and the agencies, realized that you couldn't just use an efficiency test, And so the producer surplus was dropped, and only consumer surplus is used. Otherwise, you would be allowing all kinds of mergers that resulted in a greater concentration. I think the real, changes occur in the 1997 merger guideline revisions, and especially the 2010 merger guidelines. So what happens is, especially in the 2010 merger guidelines, you can see this in language throughout the guidelines. All of the guidelines have talk about market power as being the unifying theme, as they put it. But by the 2010 merger guidelines, market power is defined to mean, or understood to mean, basically price, the impact on consumers. Whereas market power, as you know, is a broader term than that. So for example, as I was talking about with Herb, it's possible for a merger to result in a higher market power but a lower price. So there's this wedge that's introduced. The efficiency defense or rebuttal becomes more and more robust as the guidelines proceed. And by the time of the 2010 guidelines, it's made clear that the agencies are not going to challenge mergers that produce efficiencies such that the price will go down. And there are, I found, documents in which the agencies say that the FTC, for example, at least in one case, declined to challenge a merger to monopoly because it believed that it would result in a lower price. So it's really basically not enforcing the law, in my view. Okay, finally, the courts. So what are the courts doing? I think the courts are basically confused. But the best evidence I can think of, from my view, is the Anthem case. Because in the Anthem case, the dissenting judge, then Judge Kavanaugh, now Justice Kavanaugh, quite clearly adopted a consumer surplus or price test, as I like to put it. He said, look, the merger is going to lower prices, put the monopsony stuff to the side, so therefore it should be approved. And the majority says, well, the merger is anti-competitive, so it should not be approved. The problem is the majority didn't really explain what it meant by anti-competitive, and it starts talking about the kind of consumer effects, and it just kind of peters out into a word salad. So this is characteristic of the cases where the focus is often on prices, maybe almost uniformly on prices, but the courts speak in terms of competition. So it's a little unclear what's actually going on in a lot of these cases. Okay, let me just conclude now because I'm out of time. The main objection to the consumer welfare standard is that it ignores the impact of market power or declining competition on everybody, that is, except for the consumers. And the intention of Congress is clearly embodied in the statute, was to go after declining competition caused by mergers because of the general social and political effects, which have been a huge part of American history since the very beginning. There's no basis for abandoning Congress's goal, especially because even if maybe it doesn't make sense to some economists, it's reasonably plausible, and it's something that people are concerned about today. The remedy that now I would propose, it's partly it's going back to the structural presumption and the HHI tests, but I do think that it's a little naive to think that the courts are going to accept that, partly because so much of the economic literature expresses hostility to market definition in general and the HHI tests, and because economists, as I read the literature, seem to be very skeptical about assumptions that markets are homogeneous. So if we're moving toward upward pricing pressure and structural models, if that's really what's going to happen, and I expect it will continue to happen because courts have gotten used to them, then the proper statistic is not price, but margin, which is a better reflection of market power. And with that, I will stop. Thank you for indulging me.
Thank you. So we're now moving to the panelists directly on my left, Stephen Salop. He is an economist and a lawyer, professor emeritus. Okay, well, a professor emeritus at Georgetown University's Law Center. In the past, he's been an associate director in the Bureau of Economics of the FTC, as well as an economist at the Civil Aeronautics Board and at the Federal Reserve. So the floor is yours.
Thank you very much. Following Christina, I want to start with my credentials. I've been deep in the anti-pork trenches at least since 1980. This included organizing the FTC's conference on strategy, predation, and antitrust in 1980 that began to create the post-Chicago approach to law and economics. Indeed, my Republican colleague at the time of that conference, a guy named Jim DeLong, Brad's father, to let you know how long ago this was. As Jim DeLong said, boy, Steve, this work really is an answer to Bork. You should pursue it. And so we did. The goal, so that's kind of my credentials. Where am I today? The goal of my work today is to find the happy medium between the Neo-Brandeisians and the post-Chicagoans. I'm not going to try to do the happy medium between Chicago and the rest of the world. That's impossible, as we learned from Frank Easterbrook last night. So what I'm going to focus on just a narrow piece, which is a big issue for the Neo-Brandeisians, that might be called vertical coercion. Okay, so vertical coercion is powerful dominating firms using that power to exercise power over smaller counterparties, whether the counterparties are workers, whether the counterparties are small input suppliers, or whether the counterparties are downstream firms. So this has been a real animating force for the Neo-Brandeisians, and really for me in my own Raising Rivals costs work has all been about powerful firms exercising market power. Now, for those who are asking what I mean by powerful dominating firms, as we're going to see in the next slide if I get to it, is there are firms with either classical monopsony or classical substantial market power, monopsony power, market power, substantial bargaining power. Let me start over. Either monopsony, substantial market power, what we call monopoly power, or dominating bargaining power. So I'm going to later on embed this in a Nash bargaining model. So the idea is that to build standards to benefit workers and small firms, but while not harming downstream consumers. Okay, so some people are rolling their eyes at this point, Neo-Brandeisians. Note that while the consumer welfare standard may be dead, we should still count consumer welfare. I mean, consumers still count, even if they're not going to be the overwhelming or sole purpose. So for what it's worth, I've named my standard the Reasonable Competitive Conduct Standard, RCC. That both follows the spirit of the Sherman Act, which is all about reasonable conduct, and it also is just another permutation of R, C, and C. So we have a couple more permutations to go. Fiona Scott Morton has the CRR standard, contracts that reference rivals. So we're slowly getting to all the permutations of RR and C. So I'm not thrilled, except for the initials, I'm not thrilled with the name of my standard. I mean, the names of all the standards are not self-defining. They're more like slogans than really standards. The real work is defining the legal standards for specific categories of conduct. That's what we really need to do. And a lot of people have been saying that in this conference, and Judge Wood said it, Eleanor Fox said it yesterday, Carl Shapiro said it yesterday. That's what we need to be looking at. So it's not the mushy slogan of protecting competition or competitive process or whatever. It's all about, well, what are the standards going to be when the rubber hits the road? And so that's what I've tried to do with respect to the conduct of these powerful dominating firms. So the first three prongs up there, They skew post-Chicago, and they can all be reached within the context of current antitrust law, just by tightening up current antitrust law. The fourth one skews neo-Brandeisian, and I think for that one you need to have an antitrust exemption. You can't do it under current antitrust law. That's why I've put it in red, just to flag it. So the last one's also the newest, and so hopefully I'll have enough time to talk about it in this first. So let me quickly talk about these others. So first, I reject cross-market balancing. You cannot offset harm within the relevant market by saying there are benefits outside the relevant market. And that is in merger law in Philadelphia National Bank. That is the law in merger law. It's a little less clear in other areas of the law. That's what Legion does. I think that's what the ancillary restraints doctrine does, really. You may have remembered, I asked Judge Wood and Judge Easterbrook last night whether they thought that out-of-market benefits should be allowed to trump within market competitive harms. Not surprising to me, Judge Wood agreed, but somewhat surprising to me, Judge Easterbrook also agreed. I would have thought he's a diehard aggregate efficiency guy. He would certainly be willing to sell out workers for the benefit of consumers. So second point is my concern with domination, with dominating firms, leads me to recommend more interventionist standards for exclusionary conduct. So this is basically raising rivals' costs. So exclusivity with input suppliers, conditional rebates, MFNs, so on and so forth. So this is conduct that, in the simplest case of input foreclosure, raises the cost of rivals and gives the firm power downstream, what I call power over price. But it's really gross consumer welfare harm from increased market power. So what I would propose there is greater use of anti-competitive presumptions, lower burden of proof on the plaintiff, and higher rebuttal burden on the defendant. Okay. At the same time, I would not say exclusive should be per se illegal, rather just a strong anti-competitive presumption if a firm with a lot of market power does exclusivity. But not exclusivity with some single small firm. It's going to have to be exclusivity with a number of firms so that you can reasonably draw a presumption that it's likely to harm consumers. Okay. I require harm to consumers. Now you could say, geez, if rivals' costs are sufficiently raised, we can maybe infer harm to consumers. Well, if you could certainly draw an inference in the sense of a high likelihood, but I'm not willing to draw an automatic inference. I think a prong of the test is that you also have to show consumer harm. Efficiencies in principle could offset the consumer harm, and I'd allow a rebuttal there, but it's going to be a heavy rebuttal. Okay, so I'm not protecting the small firms automatically here, but I'm making harder for the dominant firm to harm the small rivals. And we can talk about whether I'm being too weak on that. Third, I favor more interventionist merger standards. I'd actually like to see a return to something like Philadelphia National Bank. Philadelphia National Bank, once the plaintiff showed that market shares and concentration to satisfy the structural presumption, the burden shifted to the merging parties to make a clear showing that the merger would not harm competition. Not a burden of production, but a burden of proof, and a high burden of proof. And that's Supreme Court law, opinion written by Eric's father, I would add, when he was a clerk. And it was, however, weakened in the Baker Hughes decision by now Justice Thomas when he was on the D.C. Circuit. So I'd like to see a return to To that, I'd like to see stronger anti-competitive presumptions. Fiona Scott Morton and I have suggested reducing the HHI threshold back to the 1992 level, having an explicit presumption based on guppies, an explicit presumption based on acquisition of a maverick, and I think I got one other. That's enough for now. I would not recommend explicitly saying we should protect inefficient competitors. I don't think that would benefit democracy, frankly. I mean, if you do not permit mergers that benefit consumers, that's not good for democracy either. I mean, the rise of populism today is partly from the fact that people are not making as much money and they're upset about it. So I would rather benefit weak competitors by subsidizing them directly. So I think that post-Chicagoans would agree with these three. The last one they may have they would have more problems with, and of course the Sherman Act's got more problems with. So the fourth one is I would like to see an anti-competitive exemption allowing small participants to form associations, what I call joint negotiation entities, to collectively bargain with powerful dominating firms. And what I do is I want to limit them to only have moderate bargaining power, have some bright lines to make it impossible for them to get real monopoly power, give them only moderate bargaining power. And what I can show in my Nash bargaining model is when you do that, it not only benefits the workers or the small input suppliers, but it also benefits downstream consumers. There's no conflict between downstream consumers and the input suppliers. The way it works is as follows. So if you start with the firm monopsony point, suppose you believe that the firm has got total bargaining power. In a Nash bargaining model, and think about this as workers against the firm, if the employer's got total bargaining power in the Nash bargaining model and the worker supply curve is upward sloping, the outcome is the classical monopsony point. By contrast, if the workers had total bargaining power, the outcome would be the monopoly point. But if you start with monopsony and just give the workers a moderate amount of bargaining power, you're going to move up the supply curve. So my bargaining models, they just negotiate over the wage, and then the level of employment is set by market forces. So the wage goes up. The firm would like to hire a lot more workers. It would like to be on its demand curve if it weren't worried about monopsony. But a few more workers would be willing to work at the higher wage. So you move up the labor supply curve. That means the output of the firm typically goes up. If the output goes up, typically the downstream price will go down. Hence, downstream consumers will benefit. So this, as long as you keep the level of bargaining power below dominance by the joint negotiating entity, output's going to rise and downstream consumers are going to benefit. And so that's why I want to keep it at moderate. So let me just show you one. This is this technical picture. This is on my website, as we say. As the bargaining power of the J&E goes up, the wage rate or the input price goes up to the competitive level. It sits there for a while as bargaining power goes up. It's because the utility, the utility frontier of the two firms has got a kink at the competitive level. One more minute. And then it goes up some more. But the more important thing is look what happens to sales. That's what happens to employment. It goes up and then stays at the competitive level for a while, and then it starts to fall. And so what you want to do is make sure you don't get into that high-end region, because that's where consumers are going to be downstream consumers are going to be happy. But before you get to that point, the powerful counterparty is upset, but everybody else gains. Okay, so to be continued. Thank you.
Great, thanks so much. Okay, so now two co-authors, and we're slightly running out of time, so I would recommend going fast if possible. So Bennett Capers is the John Feerick Research Professor of Law and Director of the Center on Race, Law, and Justice at Fordham Law School. Works on antitrust and many other things. And Greg Day is an assistant professor at the Terry College of Business at the University of Georgia. He also has an appointment at the law school and is a visiting fellow at the Information Society Project at Yale, like me. I let you speak now.
Great. Thank you so much. So I guess in the sake of time, I'll try to imitate a podcast that you turned on to double the speed, and I'll speak as fast as I can. Just so for starters, and we're going to split our time, so I'll try to keep this within 3.5 minutes or so. But so we proposed a community welfare standard, which I want to start just highlighting it's restrained, I think, because I mean, we're definitely trying to stay inside the bounds of the Sherman Act, where we talk about, where the Sherman Act is limited to trade and commerce and competition. And so that's ultimately our goal. The only place that we're really trying to unravel a little bit is just this assumption about how communities experience anti-competitive effects in sort of the same way. And there's a very logical assumption that if say the price of Coke monopolized the market and doubles prices, I mean, there's a logical assumption that we'd all suddenly be paying twice as much, as a sort of a broad-based consumer base. And just same, if Coke said, well, now we have a monopoly, we don't have to worry about quality anymore, and there'd be a logical assumption that quality would go down for absolutely everyone. So a lot of our goal is actually to highlight the areas where that assumption doesn't really hold any longer, where there's disproportional effects, but not even just randomly distributed, but oftentimes levied disproportionately on communities of color or more vulnerable communities. And so the goal is not, say, to make antitrust into a unique sort of anti-discriminatory regime, but just to highlight how anti-competitive effects do levy disproportional effects on communities that really the antitrust regime is currently ill-equipped to understand or has refused to understand. I think so. A great example is Christopher Leslie wrote a really good article just last year in the California Law Review that highlights food deserts. And a big part of that was saying that mergers amongst grocery stores, have in a lot of areas increased efficiency, but they've also rendered food deserts. And as you probably know, food deserts are not just randomly distributed across the United States, but they are disproportionately and exclusively, essentially, located in poor urban areas. And as grocery stores flee due to mergers, as research has found, it's left us with dollar stores and left these certain communities more likely to buy the prepackaged, less nutritious foods. And similar, in the same vein, Jeremy Kress wrote a really good article in the Duke Law Journal last year that talked about banking antitrust. And in a big facet of that he found was through banking mergers that when banks have retrenched, a lot of times it's not randomly distributed. Oftentimes you could even find efficiencies in more affluent areas, but at the same time, you're seeing banking deserts where more vulnerable communities are relying upon check cashing stores and title ponds. And in fact, even when a lot of people in disadvantaged communities do have bank accounts, they have to travel, take a bus, 30 minutes away to get a bank account, then they have to use high fee ATM machines in like bodegas and gas stations as their singular source. And so when it comes to things like a lot of these mergers, for instance, there is the proposed merger between Albertson and Kroger, which I have not investigated it, so I can't tell you whether it's actually good or bad. But it promises a lot of efficiencies. It would create one of the largest. But a lot of experts are sounding alarms that this will increase the rate of food deserts. So the question is like, how do a lot of these anti-competitive effects disperse amongst different communities different ways? And we should jettison this idea that like we will all pay the same high prices when prices go up, instead of understanding how efficiencies and inefficiencies are spread out. And there's a lot of other ways that other examples, like healthcare is a similar one. where we even show things like where we talk about like things like switching costs are generally higher. But sometimes if you are more an affluent patient, and even if rates go up a bit, a lot of times your insurance will cover it or will get passed on. But if you're an uninsured person from a more vulnerable community, you're more likely to self-medicate. And an extreme amount of people in the United States every year go without healthcare because of prices. And so you see that there's a natural higher switching cost across communities. So in our proposal, the goal isn't to be sort of the last word on what should occur, but we really just wanted to propose community welfare standard as a way of just sort of starting a new discussion about disaggregating consumers and understanding how different consumers can experience effects differently, and whether the current standards is too much of a numbers game where sort of like majorities take precedent over sort of minority numbers.
So I come to this as the odd man out at this conference. I don't teach antitrust. I've never practiced antitrust. I've never taken an antitrust course. And it was kind of a luxury to sort of say I write in the area of antitrust. Literally, I've co-authored one article with Greg. And he was the antitrust person. I was sort of bringing a critical race theory perspective to antitrust. But I think one benefit is it allowed me sort of an outsider's perspective. So it was very easy for me to look at sort of the consumer welfare standard, at least as it's commonly understood, and sort of its connection to Robert Bork, and just think like, wow, that's kind of weird that that's what you guys sort of latch onto. So obviously, as Greg pointed out, much of our concern in our article, right here, is about racial effects and inequality, especially when you think about consumers writ large, which by definition is going to be indifferent to how people of color and poor people might be differently situated and might have higher switching costs, for example. So what I want to do in my time, since we're pressed for time, is actually sort of switch from talking about race to just talking about the consumer welfare standard more generally. Because it seems to me that beyond race, it sort of at least strikes me, and I think maybe us, strikes me as weird to reduce consumer welfare to consumer economic welfare. Two words to me stand out. First, consumer. Like, even if we add labor, as several speakers mentioned yesterday and obviously today, that still seems limited. It seems like we only care about people as consumers or people as laborers, but not people as people. So I'm assuming the houseless persons I passed by on my way to the hotel last night are neither really consumers nor laborers, but I care about them. And it seems strange to have a standard that writes them out of the picture entirely. Second, the word welfare, since for the most part, the standard seems to use welfare as a proxy for economic welfare. But isn't that too limiting as well? Like, if a transaction results in most or even all consumers paying, a few pennies less, but also results in blight or houselessness or weakens democratic power or any other non-price harm, shouldn't that count in the welfare analysis as well? So that's why we advocate for community welfare standard, which sort of seems capacious enough to take into account how differently situated people, such as people of color and minorities, might be impacted by a transaction, but also capacious enough to take into account, what I think should be the goal of almost every law, which is making society better off, not just some members of society. So I think I'm going to end there. I think the only other thing I'll say, if I have 30 seconds, is since I'm an outsider and this is my first antitrust conference, hopefully not my last, I've been having a blast. This is so much fun. So, it really is a big tent. Thank you.
Thank you to all four panelists. So I think what I'll do, because we're running out of time, is I'll ask one question of all of our panelists, and then I will open it up for questions from the audience. So I guess my question is, since you're not all lawyers, but you all have appointments in law schools, I'm going to ask you to put your advocate hat on and somehow argue for your proposal and against each other's, or at least one of the others' proposals.
Alexa, this feels like a game show.
And it's also allowed to comment on the prior panel's proposals as well. So you are free to comment on any alternatives, but you have to defend your own. Okay. And one more rule is, if possible, concrete examples that show that your standard is better than an alternative would be great. And maybe we should start with Stephen Salop.
Well, I want to start with what I agree with about their paper. I mean, if a merger of supermarkets creates a food desert, you should be going after the FTC, not after the consumer welfare standard, because the supermarket market definitions are normally drawn very narrowly, and the consumers living in that narrow area constitute a relevant market under standard antitrust, and that merger should not have been permitted. And if it is, that's a problem with conventional antitrust, not with anything very complicated. Beyond that, I don't think Eric and I disagree that much, except that he wants to use margin, which is the wrong measure, instead of price. But all the rest, I believe that's a detail. I believe that's a detail. I think we mainly agree. Who I disagree with is perhaps Tommaso, who I think is trying to create conclusive presumptions instead of he's making it a little too hard with his presumptions. But otherwise, I pretty much agree with him as well.
I think the emphasis on switching costs is very important, and something I've also been thinking about in thinking about labor markets also, where switching costs are much higher typically than for consumers, and in this idea of disaggregating different types of people. I think that's very important. I do think actually it does fit within the general methods that are used in antitrust law, but hasn't been the focus of either plaintiffs or government agencies, at least as much as it should be. So I don't know whether you need a different standard for that, at least for that aspect of your proposal. I think Steve and I disagree, and that Tommaso and I agree, I think. But so that, to put my advocate hat on, so, the statute says lessen competition or tend to create a monopoly. That's all I need. It's the statute. And then these various courts that have looked at the statute interpret the statute that talks about competition as meaning competition. So I think I've pretty good legal basis for my view. And one of the points I'm trying to make is that I think that economists, and I mean this, I don't want to attack economists, because I think that Williamson, I don't know about Bork, but I think Williamson and the economic literature that has followed him have been operating in completely good faith and trying to understand what is the proper normative approach to evaluating mergers. But I don't think it's the approach that Congress adopted and incorporated into the statute. And I think courts have understood this, but I think the agencies have been influenced more by the economic approach than and have lost sight of what the statute, I should say modern courts, lower courts, have lost sight of what the statute says, what Congress was trying to accomplish, and what Congress was trying to accomplish. And I think that what Congress was trying to accomplish was reasonable, based on a long history of concern about corporate power in this country. So that would be my argument for the margin standard. I do want to acknowledge, because I've gotten a lot of hostile emails from economists, that that under my standard you would block mergers at lower prices, okay? These are mergers that would lower prices but would raise margins, meaning that they increase competition. Reduce competition. So it would be a stricter standard, and fewer mergers would be permitted.
So I know a lot of antitrust law is about promoting competition, but I think I'm going to resist the idea of us competing. And it's sort of like I like a lot of these ideas, so I'll just leave it at that.
Well, I think for me, I think Stephen brings up a great point about sort of our proposal, where sometimes I feel like we propose something very radical, but at the same time, I think he makes a great point that it's not that at all. I mean, under just a very classical view of like output means welfare. I mean, our model fits that in many places where we say, look at these desperate effects. At the same time, are like output reducing and could fit just like a typical sort of antitrust analysis. So I think that's both a strength and maybe a weakness. But and in terms of agreeing, so one idea that I've always really enjoyed, and I'm glad that was brought up, was also the idea of allowing, in a lot of times, like people to bargain, collect, like allowing small maybe buyers to bargain collectively. I've actually previously advocated for that in a lot of times the patent realm, where I've thought that if there's maybe like a standard essential patent, and there's a threat of like a holdup, I've said that the licensees of patents should have power to come together and bargain if there is like a holdup game being used against them when they need to use this patent, or otherwise they can't exist in the market. I think and if you look at legislatively how like labor has been allowed to do so, shows that I think that's a great way to almost like self-order, sort of like effective competition. In the sense that you don't need to go to court to do it, you just allow people to bargain together. I think so I really enjoy that proposal, and my only regret and Ryan hear about this is just almost cabining it to sort of just patents and not even thinking about that in a greater sphere.
Look, I think that these J&Es can be used as a merger remedy, or they can just be used on their own. I mean, the other thing the agencies can do about harm to vulnerable consumers is they can do it with case selection. Mm-hmm. The FTC should be bringing supermarket cases, gasoline cases, banking cases, not trying to stop yacht mergers. I mean, it's and John Baker and I proposed that in an article some time ago. As for you, Eric, this criticism of economists, you can criticize Williamson, okay? But, in 19, at the time I started in this game, the economic attack on Bork was the only game in town. The people that were saying, oh, you shouldn't count economics, they were already neutralized. And the leaders, Potofsky, Blake and Jones, Eleanor Fox, they didn't want to reject economics. They wanted to take economics into account along with everything else.
Yeah, I don't want to reject economics.
I
just want to reject the consumer welfare standard. And the problem with you guys is you adopted the consumer welfare standard.
Well, I'm telling you, okay, yes, we got suckered. I agree, we got suckered.
That's all I'm saying.
Bork mislabeled Williamson. It outraged us. Bob Land pointed out that it's about wealth transfer. I have an article, 2007, something like that, called The True Consumer Welfare Standard. And so we reified using economics. But I'm telling you, it was the only game in town. If there was no other grounds on which to fight. So I've got no apologies. And if you look at my article, along with the Dylan songs, there's like 50 citations to post-Chicago literature, pushing back against your colleagues at Chicago and Bork and so on. I mean, don't blame us, blame the lawyers, blame the judges. I mean, the heavy in this game is Clarence Thomas. Okay, I mean, we had Philadelphia National Bank. Philadelphia National Bank was really solid. And if you look at the cases in the 80s, Hospital Corporation of America says, I'm going to defer to the FTC. Elders Grain says all doubts held against the transaction. And then, out of whole cloth, 1990, Clarence Thomas says, oh, the Supreme Court, well, they never said it explicitly, they've lightened the load. And so he lowered the standard from clear showing to more likely than not. He changed burden of proof to burden of production. And that's all she wrote. That's where it happened. It's not.
Let's hear from these.
Okay. So I actually wanted to use my moderator's privilege to ask 2 lightning questions, and then we'll open it up. So just one question to Eric. I'm wondering if you could tell us a little bit more about how you would measure profit margins, because in some contexts it might be difficult to do so. And connected to that, I'm interested in how you relate your proposal to Herbert Hovenkamp's proposal on outputs. And in particular, I think it's really helpful. Your proposal seems to solve some problems in the labor context. At least it overcomes some of the remarks that were made this morning in the labor mergers panel regarding the fact that you could have more outputs and yet wages remaining low. And so that might lead to higher profit margins, and maybe your proposal solves that, but how do you calculate profit margins? And then a question to the 2 co-authors is simply, why is your paper about antitrust? And so this is really a devil's advocate question because I'm very sympathetic to your proposal, but why is your proposal not something that should be dealt with through consumer law or discrimination law or some other branch of law?
Okay, very quickly. So it's very hard to measure margins, and I'm happy to use the structural presumption when it's possible to use the structural presumption. But what I have in mind are cases where economists don't trust the structural presumption and think that another method like Guppy or structural models should be used in order to make price predictions. And as I understand it, in those cases, they are already using margins because they need to in order to make price predictions. And so those would be situations where you should use margins rather than prices. You have that information anyway. I mean, merger prediction is hard because data's, there's often not enough data, and that's just a generic problem with merger analysis. I'm embarrassed to say that I overslept this morning and I missed the labor panel, so I'll have to say just this. And actually, I understand this better because of Sanjukta's work. And also Steve explained this to me and a few other people. The cases are very clear that if workers are harmed as a result of anti-competitive behavior, there's an antitrust violation. And it doesn't matter, as Steve again, whether output goes up or down or what the effect is on the other side of the market. And I think that's correct because after all, if you had it the other way around where anti-competitive behavior harms consumers, it wouldn't matter. No one would care if the firm shared its rents with workers and wages went up. So that's just the way antitrust law works. It focuses analysis on just one market. And you don't have to worry about margins. I mean, this is assuming we're sticking to prices or wages. So I don't think you need to use margins or to think about that to address that particular problem.
Yeah, thank you. So, I mean, I think it's a really good question, and I think that one of the easy answers is saying, well, because you're not depriving the other areas of law, you're just adding one. But I think also more importantly, how I would see it. So a lot of times the actual, so we can view it both from the terms of consumers and competitors. I think one thing that made me really think more about this topic this way is so much of the times where you actually see, sort of an intentional discrimination against things like undocumented immigrants or even recent immigrants is based upon the ideas of competition. I mean, there's dating back to actually when antitrust or competition law, sprung out of England hundreds of years ago. I mean, a lot of it was based upon the idea of foreign merchants or foreign traders were oftentimes excluded because there were concerns about whether they pose unfair kinds of competition. For instance, oftentimes, like a lot of times, state action immunity it allows municipalities or states to impose restrictions on things like on food vendors, and there's oftentimes there's a thought that they pose unfair types of competition, and a lot of the restrictions that we're talking about is competition, and it stems from competition. So in a lot of aspects, I think it was fun for us to highlight just the nature of how these issues aren't just tangentially related to competition and antitrust, but they actually strike very much at the heart of it.
Okay, great. So we're opening it up. Maybe we should take 2 questions at a time. So let's take the 2 here.
So this is comment and a quick question for Eric. So I think the vast majority, almost all merger analysis takes place setting aside efficiencies and then looking at effects, in which case there's no difference between your standard of price margin and looking at prices. There's no change in cost. So until one gets to some showing of efficiencies, there's no difference. I see you're nodding. Thank you. So then I want to ask, suppose there is that rather tough showing for efficiencies. Again, this rarely happens, but we're in that little world. And let's say it's a 6-to-5 merger. There's 2 companies, maybe it's like a 10 and an 8% companies merged, and they show that they'll have these efficiencies that will lead to lower costs and lower prices, but they're not fully passing on the cost, so their margin goes up. Consumers benefit. The merging companies are happy they got the efficiencies. The rivals don't like it. That you would say that's illegal, even though I would say as an economist, that's more competition is caused by the merger. But you're going to say that's illegal under a statute because it substantially lessens competition, even though it led to more competition. Am I understanding you right, or am I mischaracterizing?
Yes.
I'm getting you right. Okay, that's an interesting interpretation
So
of the
would
statute.
you say that like Herb about a 2-to-1, if it was a 2-to-1 merger?
What? No, 2-to-1 merger, you got a monopoly. How could that obviously lessens
A
competition.
2-to-1 merger that lowers prices, or a 3-to-2 merger. Why is there the cliff, when you go from a 2-to-1 to a 3-to-2 or to a 4-to-3? Why does everything change?
In my example, there was an increase in competition. You can't have an increase in competition when there's a monopoly. That doesn't make any sense.
All right, so for a 3-to-2 merger and price goes down, you would say there's an increase in competition?
I would be tempted to say that because but I understand put it this way, we both have a challenge on both sides.
I think
of
just you do.
No.
Okay, but all right, let me.
I would say yes for 3-to-2. But I think 2-to-1.
I think we understand. I think everybody understands. Just two things. The first thing is it's extremely rare in the courts. It's not at all extremely rare in the agencies. Like the agencies, I don't know. Maybe the agencies think about efficiencies all the time in the enforcement.
I'm sorry to hear you guys have strayed that way. It wasn't true in the Obama administration. Maybe it's true for the Biden administration.
You never did. Okay. I don't know. Maybe somebody, like at a higher rank than I was can correct me. But anyway, that's what I. The second point, though, is that the only point I want to make is that the first point is that I do believe that the agencies talk about efficiencies all the time. Forget about your experience and my experience. If you read, for example, I think it's the Review of Industrial Organization, where people, I don't know whether it's you, but certainly frequently the former heads of the Bureau of Economics or so forth talk about the mergers they worked on over the previous years. It's efficiency, efficiency, efficiency. We didn't challenge this merger. By the way, there's a lot of this stuff. I quoted in the paper I sent to you. The second point is that when you say it's weird, it's because you're just focusing on the effect on customers, on the consumers. And the point I'm trying to make
I'm not.
No, you are, because you're saying, look, the customers are paying a lower price. How could we possibly block this merger? And I'm saying the merger is increasing market power. In your hypothesis, that could have a negative effect on other people, non-customers. the people who are affected by
Can't we
the
just go back to
enhanced
the
political
statute? You're the
influence
guy who
of
wants to go back to the statute.
Pardon me?
Lessen competition or increase in competition. I just said
Pardon
increased competition. I'm not talking about
But that's
consumers.
just definitional.
got
You're
to
saying it's increased
where you two disagree is on what competition is.
market power. Market power. That's my definition.
Okay.
You're defining competition as lower price, which it, well, no, you're not. Anyway,
Okay.
this is the nub of the disagreement.
To be continued. Okay, next question.
I was going to ask this to the previous session, but I think there's a theme through many of the sessions we've had where we each have our own favorite non-competition related policy goal, which we find desirable. These things included lobbying, climate, forms of equity, democracy, which I'm happy to promote. I endorse many of these goals, but it doesn't seem to me that the regulator has the authority, or should in a democratic society be allowed to make these choices. So again, within the most recent presentation, I understand there's a range here. Some of it really is direct how competition affects different groups, but some of it seemed to stray from that a little bit. So should we be recommending that a regulator take considerations that the legislature did not include in the law?
And if anyone else has a question, happy to take another one now. Oh, actually, can we take Ioannis, because he already had his hand up before.
It's also the last point, but also the fact of not basically taking into account these other values is also a policy choice. I mean, what actually makes Yeah, exactly. But the fact of pursuing, for instance, only efficiency, is also a policy choice. I mean, why should the regulator make that choice instead of the legislator who basically, look into the different status, in particular, Robinson-Patman Act or Clayton Act or Sherman Act may have had other perspectives on just promoting efficiency. So, I mean,
Very possible, but it's unlikely that they had climate in mind as one of the goals that competition policy should aim to protect. It might be a desirable policy, but it's not likely in my mind that the legislature wanted to include that.
Okay, so we have a final round of conclusion remarks, answers, thoughts, anything. Starting here.
I hope you all liked my neo-Brandeisian proposal to allow small participants to form joint negotiation entities to collectively bargain in order to countervail the market power of large dominating firms. I think that is something that it's just a proposal at this point. It's just a draft, but I think it's something that's worthy of consideration in this Gilded Age. What it amounts to is adopting an abuse of dominance prong for the Sherman Act. And, that's not so crazy. Europe's got it, South Africa's got it, Canada's got it. So maybe we should consider it as well.
Australia has collective bargaining for all small and medium-sized businesses below a certain level.
Well, they don't have to be so small either.
Okay, I like it, Steve, because I mentioned it to you.
Same.
But I want to
Plus
give you an
one
answer.
margin.
I want to give you an answer to your question. The statute's actually pretty clear. It refers to substantial lessening of competition. The statute does not authorize the Justice Department to make policy. There are lots of statutes that do authorize agencies to make policy. This is not one of them. So all that the Justice Department can do is enforce a statute that blocks mergers that substantially lessen competition. A policy judgment that the Justice Department has made is not to enforce the statute when it results in harm to consumer surplus. So if you object to agencies making policy, you should object to the consumer welfare standard.
Interesting.
So just again, I'm the outsider, and I just have to say I've been enjoying these conversations so much. But one conversation I sort of haven't heard is how do we make these ideas actually happen? Like how do we implement? So hopefully that can be part of the next conversation.
Joanna, we'll implement.
I guess to finish off, and I also want to agree with a comment that Stephen just made that I think is very important. He said, so much of this is about what cases does the DOJ or FTC bring. And I think that one thing that's cool is I think you are seeing a little movement there. I think it was 2 years ago, and again, these are just off the top of my head, wasn't there a criminal price fixing case for like canned tuna fish like a couple years ago? But in that, the judge kind of cited this idea that's like, I think this is particularly bad, because I mean, this is something that is the people who are eating canned tuna fish, is not, like lofty law professors oftentimes, but it can, yeah. And so I think that is important. And also part of, like, we've mentioned the case like Legion, many times. It's incredibly important, like antitrust case, but ultimately that's a case about like fancy artisan belts, and then so many of like the cases that we talk about that are really important antitrust cases are just a really insignificant parts of the market. So I am sort of maybe enjoying the fact that antitrust might be going more in the direction of like, yeah, let's look at canned tuna fish. That's a really important market to a lot of people versus like yachts and fancy artisan belts. And I think only Texas, I want to say, it was.
Well, for some reason it hasn't been mentioned over the conference, but the jockeys in Puerto Rico who faced a monopoly racetrack went on strike. They got sued under the per se rule for price fixing. Damages were levied against them. They took an appeal to the First Circuit saying the Clayton Act, Section 6 of the Clayton Act, exempts workers, even if they're not unionized, even if they're independent contractors, and they won. So that's a really important case in terms of small participants bargaining together, if it survives the sinful six.
Okay, so please join me in thanking all of the panelists. There's an important announcement. We're gonna basically move directly to the other panel.
Right? What's the time? Shall we start? I think we do. So good evening, good afternoon, good evening, everyone. I am the same Cristina Caffara as yesterday. Having watched myself on the website, I have decided I'm going to spend the day sitting on my hands because the amount of hand fluttering in that video was disconcerting. But you can't take Italy out of the Italian, so I literally sit on my hands right now. So I will omit the disclosure. Steve, it was a disclosure, not a credential brag. But I will, because I did it yesterday. So this is the last panel of the day. Let's try and keep it lively. Of course, we heard already a number of ideas and points, and I'm looking forward to hearing what the panelists have got to say. I have to say also that using my prerogative as chair, I've also kind of couldn't resist putting my own thoughts in writing, and I've sent them around to a few people ahead of this day, but they've not made it to the website. They will be there next week if Brooke can bear to edit it, but there it'll be. So what I intend to do is simply to pass the ball along the table without making lengthy presentations because they're boring, and you know who everybody is. I will then ask a few questions, but I'd also like to ask the panelists, if they may, to, in their presentation already, just take into account some of the things they heard in the previous panels, and if you feel like it, to comment on them or bring them in, because we won't have that much time for discussion at the end. My other instruction is please, please, please do not come up with the kind of comment we heard repeatedly many times, which I think is getting to be a bit grating, which is the idea that, oh, if you have these other goals, the legislator cannot take them in, no, the regulator or the agency or the judge cannot take them into account because they're outside of antitrust. I think the whole idea, and I will push it further in the panel, when you're thinking about a presumption like Tommaso does, is that ab initio, the setting of that presumption takes into account a concentration, incorporates certain concern, and in setting that presumption, the legislator or who may be will opine on where that threshold should be set. So I keep hearing this throughout the day, and we push it back and it comes back, and so it's not what anyone, I think, is really saying. But with that, I want to start with Andrew. Andrew, please, of course, Howard University, we've seen your paper, but please give us the main points.
Okay. Thank you. Thank you to the organizers. It's a pleasure to be here. And thank you for those of you who have stayed. It's quite exciting for us. We thought we'd have a 1-to-1 ratio at this hour. My paper is called Locating Competitive Process Claims in the Consumer Welfare Debate. The focus is on non-merger conduct. And this paper has been posted on ProMarket. So I'm just going to summarize some of the key points in the paper. The first one is that we ought not allow the debate about terminology and standards to obscure what I think is a well-established line of authority that could be used to build out the law of what I am labeling competitive process claims. So I'm not using competition and or competitive process. I'm focusing on competitive process claims. Second, to illustrate that, I focus on one form of competitive process claim. It's especially well developed in the case law, restraints on the free flow of marketplace information. There's a very good, well-established line of cases that shows that in these cases, harm to competition is highly likely. In other words, impairment of the competitive process was the anti-competitive mechanism of competitive harm. It's not some alternative to showing competitive harm. Third, in many of these cases, the immediately harmed parties were trading partners, not end consumers. I think the discussion about consumer welfare has created a caricature that it only cares about consumers in some kind of end consumer retail model. Not true in some of these cases. They involve trading partners. I'll talk about very briefly National Society of Professional Engineers. You and I generally don't purchase engineering services. People who are funding buildings and making other projects do. Are they consumers? The point is that the law has been far more adaptable than that kind of critique imagines. Fourth, and importantly, These decisions have relied on reasonable inferences, assessments of probability, and presumptions. Neither market definition nor evidence of actual effects is typically required or demanded, and the restraints have arisen in both Section 1 and Section 2 cases because they facilitated collusion, resulted in exclusion, or some combination of both. They're not limited to horizontal conduct. And finally, these information-focused claims likely do not exhaust the possible range of valid competitive process claims. Rather, my hope is that by bringing them into greater focus, they'll invite further consideration of conduct with similar anti-competitive tendencies that might also warrant reliance on stronger presumptions of competitive harm. In the interest of time, I won't go through the cases. They're all described in the post. I talk about National Society of Professional Engineers, Indiana Federation of Dentists, but then later cases that build on them, Polygram Holding, Real Comp, which I think is a case worthy of more attention than it gets. In the unilateral conduct area, the Microsoft claim that focused on deception in connection with Java development. And finally, there's an allegation still pending in the Epic versus Apple case about Apple's process, their practice of limiting access to information about alternative payment methods. In all of these cases, what you're going to find is that the anti-competitive conduct was directed at limiting information that facilitated competition. And in limiting that information, the probability of harm to competition was highly likely because it distorted competition, diverted business, or otherwise was likely to harm competition, not only about price, but often about innovation, knowledge of new business models, and access to new forms of competition, which eventually impedes innovation as well. That's
Just a quick follow-up question. This is taking up a particular aspect of what you think is problematic in conduct. How do you relate this to the kind of exam question, which is what should we replace consumer welfare with?
Well, as I start the paper, I say that it's an interesting debate about linguistics, but I don't really think that the choice of standard would change these cases. These are not... And again, honestly, Christina, I think it's because consumer welfare has been created into a caricature. That's not really what it is. These are very straight up cases in terms of impact on competition. They are not debating whether consumers are harmed. They're not debating is price going to go up. They are based on conduct that keeps competition from happening. That should not matter depending upon this debate about standards.
So your point is really that it's not really what the standard is, but you are interested in the tools.
I'm interested in the tools and not making easy cases hard. And the choice of standard can take an easy case, and I think this is, as a group, easy cases and make them hard.
Great. Let me move on. Barak, what would you like to tell us?
So the title of my piece is It's Okay to Ask for Help. I think the three of us have one commonality, which is we're all talking to antitrust judges like they're in kindergarten. We're trying to keep things very simple. The premise of my piece is that there are a number of cases. It doesn't matter how you define the consumer welfare standard, or it doesn't even matter what kind of economics you're talking about. There are just some very profound mistakes that are made by judges that I argue could have been avoided if judges enlisted some help from economists. So the subtitle of the article is called The Antitrust Rooney Rule. The idea is to encourage or maybe require judges at least to interview an economist if they're going to appear or if they're going to hear an antitrust case. And the idea really is to try to encourage some kind of economic systematic thinking into judicial opinions, which too often we don't see really any of it at all. To the degree that there's anything that to be said about how I came to this, most of my antitrust work is in the healthcare space, where there is an extraordinary wealth of really bad antitrust opinions. A lot of the bad antitrust opinions are reflected in certain presumptions, factually incorrect presumptions about how the healthcare markets work, in particular the motivations and the business models behind healthcare providers. Most of these mistakes take place at the judicial level, the level of the district court. And to the degree that I'm trying to figure out how to come up with a least restrictive solution or intervention into the problem, it would be simply to try to enhance the capacity of the individual judges. I think maybe to some degree, this reflects a little bit of inductive thinking. I tend to be an inductive thinker. I actually think that the best thinking in healthcare competition policy is inductive, trying to really understand the complexity of the marketplace and understand exactly what's going on. In many ways, I think that that certain presumptive models or even ideological models tend to offer a lot of confusion. And what this is trying to do is, at the very least, incorporate a mechanism where there can be a little bit more systematic thinking on the part of the judge, where the judge can be at least open to, very much with the spirit of the Rooney Rule. I'm not sure the actual Rooney Rule is working, but never mind that. Just trying to encourage an alternative framework to understanding the facts in front of the judge.
So you're advocating education for the judge by essentially appointing an economist to support him. Who appoints that economist? How does he choose him if he has no idea what economists are about? And second, we have examples in Europe, jurisdictions where the judge ultimately has a helper. It's not often that you find great results from that. But I mean, I will not resist the suggestion that a bit more economics with the judge is probably good.
Yeah, so two quick responses to that. One question that I got yesterday at the cocktail hour was, what kind of economist are you looking for? And my answer is really any economist. I think that the baseline is pretty low, to be honest. And it's, again, the key here, the mistake that we're trying to avoid is not a misinterpretation of a certain parameter in a regression. The mistake we're trying to avoid is fundamentally uneconomic thinking in these cases. And I have a couple examples in the piece. And I think that these examples are kind of, sadly, the norm in at least a lot of healthcare cases, especially hospital cases. And it's worth also saying that mistaken judicial opinions in hospital merger cases set back antitrust policy in the healthcare space about 20 years. The harm is really significant in these handful of mistakes, and the mistakes have been somewhat systematic.
Okay, let me move over to Bill. Bill, take it away.
Thank you, Christina, and thanks, Filippo and Luigi, for the great honor of being here. I'm going to take up Professor Caper's challenge to talk about how to do it. I'm going to speak about how an agency might go about applying a chosen set of goals. I'm not going to talk so much about what those ought to do, but I have views about how they should actually be applied in practice. And the key to effective implementation, in my mind, to make the choice of goals legitimate and accountable is meaningful disclosure by the agency. Here are the elements of what I regard to be good process in laying out goals and applying them. I think good practice dictates you begin the year with a clear statement of what your goals are, along with the strategy that you intend to use and the programs you have in mind to achieve them. The CMA in the United Kingdom has a good process for this. They have such a document. They begin with public consultations. So there is a debate at the very beginning of the year for the agency to identify what those goals are, who are the audiences, legislators, firms, NGOs, the larger public, all designed to identify what the prospective program is, the aims that motivate it, and to have a debate about that, and then to say, this is what we will do for the year ahead. The second element is to have a project selection process that, again, clearly identifies what the aims are and links specific programs to the accomplishment of those aims. The CMA, for example, has a category of priority called vulnerable consumers, vulnerable citizens, which uses the broad framework available to address the concerns of the economically disadvantaged, the socially disadvantaged. A good deal of the program is framed around that. And this selection of priorities should be accompanied by an imagined identification of what you're going to get if it works. That is, imagine that your program worked. How will it advance the objectives that you've identified before that you're pursuing? Is that a speculative exercise? I suppose so in some ways, but it wouldn't hurt to have at the beginning of the project a clear statement by the agency as if things work, this is how our project will advance the goals that we've identified, again, to enable outsiders to keep score. The third is that this should be done with a degree of historical awareness. I'm struck in the discussion over the last 2 days of the epidemic ignorance about what agencies have actually done, especially those in the United States. When you take a look at the U.S. program, going back through what Tim called the winter, the winter of no enforcement, there are a striking number of programs that don't fit and focus significantly on economic disadvantage and vulnerabilities. Let's think of a couple. I would look at the program that's been built to attack collusion in public procurement as being a striking example of a program that ticks many of the boxes in question. If you do a good job on this, and by the way, this is 17% of GDP in the United States, from federal down to local government, 17%. That's a big economy if you haven't been following it. What happens if you move the needle in the right direction? Well, you do get efficiency gains right away. Governments probably are able to buy more goods and services for the same amount of money. Second, most of what governments are buying, and by the way, the 17% is not puts aside the defense acquisition side of things. They're buying essential social services for which people who have lots of money contract around. People who have lots of money send their kids to private schools. They take helicopters to where they ever want to go. They don't go on the bad roads. People with means contract around all of the public services that are the focal point for public procurement. If you deliver good results in your public procurement system, well, you're largely distributing benefits to the second half of the income distribution, including to many of the dispossessed who don't work, don't even have a place to live. Another thing you do is you attack corruption, which is endemic in many of the collusive schemes that operate against the interest of taxpayers and individual citizens more generally. If you do this, you probably increase the sense of civic trust and legitimacy. Individuals touch the procurement processes results every single day. They drive on the roads, they ride the transit system, their kids go to the schools, they have the lunches. They see whether or not this works or not. It's a daily test in their minds about whether government is performing worth a damn. If you improve performance, even by a small amount in that area, I'd say you have a huge residual spillover for democracy and trust in public institutions. So I think you want public procurement in the portfolio. It astonished me that our first moderator for our first panel on the first day referred to the concern about bid rigging and public procurement as being, well, an epithet. It seems to me that if you want to hit all of these goals, you've got to have that in the agenda. Similarly, I look at the remarkable extent to which the public budgets for the agencies are framed in terms of sectors such as healthcare, transport, energy, food. They're not talking about the yacht cartel. Of course not. They're focusing attention on core services and concerns that, again, I'd assert have major concerns for individual citizens. And I think of a case like the South Carolina State Board of Dentists case, which the FTC pursued in 2004. It's targeted to provide a low-cost fluoride treatment for kids in public school systems in South Carolina. The first page of the FTC opinion explains who are the main beneficiaries. African-American kids from poor families in South Carolina who otherwise are not going to have access to good dental health care. In short, if you look at what in detail agencies have done, I think you find a remarkable amount of activity that's focused on economic disadvantage. Maybe agencies should call that out more directly and link it to the larger aims. But this has been part of the program, so it's not a big jump to say that this might be a focal point of attention in a program of public enforcement. Another element is that when you write decisions, they ought to be informative. You ought to show your work. When agencies take decisions, spell out what motivated it. Don't shroud the goals or objectives that you're seeking to perform. Lay out all of the motivating aims, and this applies to courts as well, and especially where you have trade-offs. I mean, the famous passage in the Brown shoe case where the court talks about the possible benefits of vertical integration wraps up by saying Congress appreciated that occasional higher costs and prices might result from the maintenance of fragmented industries and markets. It resolved these competing considerations in favor of decentralization. We must give effect to that decision. You could raise your hand in the courtroom and say, how much by way of higher prices are you willing to pay? Let's look at a trade-off here. 20% more? Suppose that the price reduction was going to be dramatic. How much are you willing to pay if you're faced with a choice between those price reductions, output increases, and the benefits of decentralization here? If you're going to do the trade-offs, I think you have to explain what the exchange rate is. Not with apology. You can say we're doing what the legislature meant, but you can't hide the choices that you're making in doing this. And when tensions arise, you have to explain in a transparent way how you resolve them. You wrap up the year with a report that talks about what you did and how what you did is linked to the goals that you set out at the beginning of the year that you said you were going to pursue. Yes, indeed, that is also published in a draft. So you have a public consultation in which people can comment about how well you did. Did you pursue the right goals? Did you go about picking projects to advance them effectively? And last, yes, you have a program of ex post evaluation, which asks the same questions. What were your stated objectives? How well did your projects advance those objectives? Lay out the objectives, lay out the projects that you had in mind. How, at the end of the projects, did you make progress in accomplishing these things? If you do these things, whatever your goals happen to be, you've made yourself far more accountable and legitimate. And the formative figure in many ways for this was Phil Arita. It wasn't Bork. Arita's the guy who said, yes, Congress had many things in mind. What do you do with the broad goals? Arita simply said, you ignore it. Why do you ignore it? You ignore it because it can't be applied effectively. Well, I think if you go about it in this process, you start to move in the direction of identifying ways in which to apply a framework that accomplishes those legislative objectives and others, and you're doing it in a way that makes it clear to outsiders what you're doing and how you're doing it.
Well, Bill, so I like the focus on goals, objectives, strategy, processes, the way you break it down and essentially saying I'm stepping aside from trying to define an alternative, highfalutin alternative standard, okay? Because if you do these things, then you kind of accomplish things in practice rather than sort of talking in general. Now, a common feature of this panel is, in fact, that it has neatly ducked the question, which is, what are we going to replace that efficiency-based consumer welfare thing with very good reason, but none of you has offered a direct alternative, unlike the previous panel. So not so fast, we'll take you back there because I'd like you to express views on what you heard earlier today. So let me start with what I would, I think, fairly categorize as one side of the debate, which is the paper by Herb and Fiona, which is more in favor, I think it's fair to say, of the status quo, on the basis of the principle that price and output are things we can measure. And so at least we've got that. All those other things are much bigger. But I think it was interesting that in the discussion, Herb, you said you acknowledged that even price and output, simpler as they may be, particularly output, are often difficult to measure, and you as cardinal measures. And so you then say, well, we are interested in ordinal measure, directional. And my experience personally as an economist at the coalface, as I said many times, is that output changes even are really impossible to measure in any meaningful way. So because we make inferences from things that are not very interesting, like market shares or stuff like that. So how does this panel, each of you who want to comment, feel about the persistence of that idea? Is it something you still feel some warm feeling for attachment, or is it something that you agree we need to move on from?
Well, can I just say one thing? I do think that at least in the cases that I talk about, that's all a second order question. I mean, the first order question is just trying to get some kind of economic rationale, whatever your standard is, incorporated. We have some very foundational problems that we need to solve in these really important cases. So talking about, much of the conference has talked about issues that are not of pressing importance in the healthcare sector. And by the way, Bill says that his sector is 17% of the economy. My sector is 19.5% of the economy, so I win. The other thing I will say is that, and I said this to Herb, I mean, in most hospital mergers, they increase labor, they increase hospital output, but they destroy the local economy. And I don't know how generalizable this observation is, but if what you care about is the standard is, does the acquisition expand output or not? That would pass Herb's test, but I think it would be disastrous for the economy. Now, I think that if we're talking about other standards, I think that Eric's standard on market power would probably be more appropriate. But again, I'd be a little worried about generalizing it across industries. I think one thing that's wonderful about economists is, especially economists in antitrust cases, is that they're very grounded with the market that's right in front of them. And they ask very particularistic questions. They force judges, they force litigators to go through a systematic analysis of what the particular transaction or conduct is going on. And that, I think, is the most important thing, more than having any kind of overarching theory.
Any comment?
The vocabulary is bankrupt. It's worse than bankrupt. It's a distraction. If you mention it, you've got to be ready to drop the gloves and start fighting right away, because people go for each other's throats without even defining terms. What do you mean? What's encompassed by it? It's such a barrier to effective communication now. So I would say that, yes, within the meaning of the statute, protect competition. Someone asks, what do you mean by that? All right. I go through the list of the considerations we have been talking. Output, as Herb defined it, price, quality, innovation. That's on the list. I'm concerned with distributional effects as well, at least as a prioritization principle. If I have a choice in deciding what my program is going to be, I'm going to say, I'm going to give major emphasis in my program to people who have fewer means for two reasons. One is, arguably, they're the ones who need it the most. But second, I have to build some political support for my program. I have to sit in front of legislators and explain what I'm doing. I'm not going to sit there and talk about my indifference to their needs. I can debate one by one whether or not the specific objectives that are being urged upon me, sustainability, climate, others, are things that I think I can handle. But I have distributional concerns clearly in focus, which is why I'm fond of the procurement agenda. But whatever I do, whatever those are, and that's how I would have laid them out, I explain what I'm doing every year and saying, these are the ones. And by the way, these are the cases, the advocacy programs, the programs to try to knock down in the whole of government theory going back decades, artificial barriers to access to the market. These are all the things I'm doing to accomplish these objectives. And I'd tell my larger audience, if you've got a better idea, I'm listening. But these are my aims.
Andrew, do you have any comment?
Yeah, what I'd like to add, and we really haven't discussed it in these 2 days, is to put this issue of the consumer welfare standard into some larger historical context. Clearly, antitrust began to change in this country by the late 1970s. It was actually before the Reagan Revolution. It was before the Reagan Revolution brought different leaders to the agencies, different judges to the courts. It started to change because of 4 appointments to the Supreme Court by Richard Nixon, and then a 5th by Gerald Ford. And so when the Reaganites arrived in Washington, they had a Supreme Court that was very receptive to something, and Frank Easterbrook referred to it last night. The literature of Chicago had been developing for 40 years, but they hadn't hit a moment like that where politics and power aligned along with a Supreme Court that was receptive, and that facilitated some very significant change. It didn't mean that they won all of their battles. It didn't mean that Bork got the consumer welfare standard that he envisioned, that he wanted. Baxter and Monsanto wanted to change the per se rule against Dr. Miles, and a Democratic Congress yanked his chain and pulled his funding and said, you're not going to argue that before the Supreme Court. My point is this, is that it makes no sense to sort of single out this one piece of change, this standard, without thinking about the larger context in which it arose and the larger context in which things began to change. Now, this could be depressing to today's reformers to think about, gee, Director and Levy, they wrote their first article in 1947. Do I have to wait 40 years for change to happen? Reformers always want change to happen more quickly than that. I think the big question for today's debate for these 2 days is, are we at a moment that is receptive to this kind of change? Is the political power there? Well, to some degree, we've talked about it. Yes, the political power is there, but it's pretty shaky political power. It's not uniform political power between the two branches of Congress. I'd venture to guess we have a Supreme Court that's a little bit unpredictable on antitrust. Yes, they rule strongly for the plaintiff in the Alston case, but man, that is about the most anti-plaintiff, pro-plaintiff decision you can read. It is dripping with all kinds of statements pulled from other cases like Trinco, skepticism about antitrust, skepticism about private cases, and that's what defense bar lawyers are going to cite in case after case. I was talking to Christina yesterday about what was missing from the panel that was bashing junk economics. Junk lawyering was missing from that panel. But you know what? Junk lawyering is well armed right now because of years of Supreme Court cases that embrace presumptions, that embrace arguments, that have armed burden of production. Twombly, oh, you got to be plausible. It's not just about conspiracy. It's got to be plausible market definition. You got to have plausible market power. You have to have and what does plausibility mean? It means what a judge sort of judges to be plausible, and then you don't get past pleading. Summary judgment, burden of production. Well, that's very high. You have to go well beyond. Now your evidence has to be plausible. So the combination of procedural changes, political changes, judicial changes, have all led to why we're all here debating the current state of antitrust. And unless we really think about the broader context, we can sort of blow as much smoke as we want. That's the nice way of saying it about, gee, what should the standard be? But I think Christina used the phrase, somebody used the phrase, when the rubber hits the road, how are we going to advocate these things? Who's going to be listening? And what kind of changes can we make that can be effective? Steve Solom's paper lists lots of different types of articles. He notes lots of changes that have happened during this period of retrenchment. It has not all been one direction. There have been plaintiffs' victories. There have been important cases that plant seeds that can be used. That was partly why I wrote my paper. It lists a whole line of cases that are plaintiffs' victories, that lay out theories and possibilities for relatively easy probabilistic wins. We have to, at the same time we're challenging the big ideas, we can't lose sight of the battles we can win by using the tools we have available.
Christina, can I add one point to Andy's discussion of context? I think it's very valuable in seeing the development of the program over time and doctrine to consider the forces that drove it. I loved Carl's presentation where he said, let's look at specific examples and see what we think of them. A case that was a real hinge for this, that introduces competition, not competitors, more directly into the field of vision is Brunswick in 1977, where the plaintiff's claim for damages basically was monopoly profits minus the profits that would be gained with having a second rival in the market. And the Supreme Court scratched its head and said, that can't be right. Unanimously said, no, it's a Thurgood Marshall opinion. And that is the modern instance in which the court uses the famous phrase, competition, not competitors. It's happening at a time when the US economy is stagnant. We're running in the direction of 20% inflation, 20% interest rates. The literature is filled with documents that say the US has lost its edge. The future is in Asia and in Europe. We're not going to be able to perform effectively. So how is it that efficiency comes into view? It's in that context. The most powerful declarations of the egalitarian vision of competition law appear in my view, it's Alcoa, it's certainly Brown Shoe to take the two pillars. When are they done? It's when the United States has no economic rivals in the world. So in Brown Shoe, it's possible to imagine the court saying, are we willing to pay a little bit more for the sake of having this fragmented set of industries? Of course, we can afford it. Nobody talks that way after the crisis in the economic system begins to develop in the 1970s, which means that these goals are going to change again. This is a malleable system, and it depends a lot on this context.
I want to. Carl mentioned in his remarks the Utah Pie case, and Bill just mentioned Brunswick. If Brunswick had been before Utah Pie would have been dismissed for lack of antitrust standing for the same reasoning that the court reached in Brunswick. If I can add one more thing, I thought this was very ironic, maybe entertaining, but Frank Easterbrook last night mentioned his article, Limits of Antitrust. It's amazing how that article has continued to influence and frame the debate. One of his big points is that judges don't know what they're doing. That was one of his points in that article. Juries certainly don't know what they're doing. So he reasoned from that mistakes are likely, and that built his argument that false positives are going to, and he repeated it last night, they're going to get embedded, they're going to be hard to reverse. And so from judicial lack of competence, he reasoned to very permissive rules because of fear of error. And over 2 days, I've heard extraordinary agreement that judges lack expertise and competence. So we have this great agreement, except it's led to an argument for a return to brighter presumptions, bright line rules. That's exactly what Chicago was responding to when the Limits of Antitrust was written. We've had this over-deterrent system of per se rules. So here we are, we've come around, and I think we need to do better than sort of going back to the kind of bright line per se rules that existed. Not all of them were really good ideas, but we can do better today with presumptions, maybe with some revised and informed per se type rules. But it's important to realize that we actually have to have some faith in the rule of law. We can't toss that term around and say at the same time, judges don't know what they're doing. Judges are going to have to decide these cases. And if you believe in rule of law, you have to believe to some degree in the judicial system. An attack on judges and judicial expertise is sort of over and over. You are saying you do not believe in rule of law. And antitrust is not any more complex than securities, environmental, complex criminal conspiracy cases. We do ask our federal judges to do a lot of different kinds of cases. But this notion that antitrust exceptionalism, that somehow, we're in an area that's really hard to understand, ignores the reality of the larger judicial system. Sorry.
Well,
but I don't feel strongly about anything.
No, not at all. And junk lawyering, I am very familiar with that. Just enough for me to be rude to my own side without being rude to the lawyers too. But I mean, so much content here. And of course, you talk about the context, which is very much what in some way drives what, for example, Tommaso is talking about when he talks about rebuttable presumptions. I mean, and what Eric implicitly talks about, because to your point, we have the pendulum has swung. We have come all the way out of the Chicago cycle, which resisted presumptions before, because the view now is we are in an environment in which there is a sentiment. I mean, Tommaso said, I'm not happy with where things are, so we need to do something. And so this something cannot be more of the same, more of this exceptionalism, more of this complication. One thing to think about is this notion of some bright rules, some presumptions. And so you mentioned that you're not against them in principle. The question is going to be, how does one structure them? But would you like to elaborate, all of you, on this idea and how warm you feel towards it?
Yeah, I'll take a swing at the pitch on merger control. You could say that the presumptions over time have become significantly weaker. Look where Bill Baxter's guidelines sought to draw the line. And in a rough sense, on coordinated effects, those were designed to stop 6 to 5. And the agencies fought that battle in a number of instances in the 80s. They fought it even above the threshold. So we've had a drift away from that vision in a number of ways. how do you restore the frontier that at least was set at that point to make the presumption more robust? This is where the research agenda, I think, is very important. In the field that Barack knows much better than I do, the effort to restore effective merger enforcement in the hospital domain based on better empirics drew upon a research program that suggested that the assumptions courts were using routinely were badly out of line. Now, sadly, that took a while to build the research. With it in hand, the FTC was able to go back into court more often and have successful results. And I'm simply wondering whether do we have enough evidence before us? Can we marshal that evidence? We think about a strategy, sector by sector, to go into court and say, document the drift. That is, this is how the perimeter is narrowed. And the inner fortress is all that's being defended at 3-2, 2-1. This is where it used to be. This is why we have to go back out to the earlier frontier, especially for coordinated effects, where the really interesting research on cartelization now shows that you can run really effective cartels with 6 or more members. To build that empirical case, I think if we ask, how do we get back out to the presumptions where they were in the 80s? Part of the answer is you build the evidence, you assemble it, go to the courts and say, this is what we know about the effects. This is the drift. Here's the restoration.
I'd add to that in the following way. I mean, antitrust is law, and in that sense, there is the reliance on presumptions and analogies, and we see all the weaknesses of that epistemological approach in antitrust cases. The analogies are misapplied. The models are a little bit too coarse. I think that the story that Bill is telling about the FTC having to go back and do its homework is both a victory story in the sense that they didn't really develop presumptions. They just developed some really good empirical methods. The sad part of the story is that they had pretty good empirical methods beforehand too. They got better, but the earlier methods just weren't working. And they weren't working not because there were better methods out there. They weren't working because there were certain presumptions, certain legal analogies, certain twists of words and semantics that judges were using to get to the wrong outcome. To the degree that it was lawyering that got us into this problem, I worry that presumptions are just another kind of lawyering.
Andrew?
It is another way of lawyering. It is, but let's separate out competition policy. This is something that has been discussed over the 2 days. Law enforcement is just one type of competition policy. Law enforcement is case by case, and it is law enforcement. So it's subject to the same framing, the same system, using burden of pleading and production and proof, and presumptions are traditional things that we use in the law. None of that is unique to antitrust. The role of experts. It's especially important in antitrust, but the rules for experts, including court-appointed experts, apply to all cases. Class actions. The Supreme Court has shown its great hostility to class actions, which has really affected private enforcement, which again, we haven't really talked about for the conference, but private enforcement needs help, and the agencies could be helping it. So it's not that in lieu of, because there's barriers to law enforcement, that you drop it, but you do think more broadly about tools. And I think the agencies are doing that. The whole of government effort is about competition advocacy across the government. The FTC's efforts on rulemaking, I don't know if they have the authority. We can put that debate off for another day, but that's an example of trying to expand the tools that are available beyond case-by-case law enforcement. So I think part of the answer, Christina, is that, and the word tools has been used in Europe even longer than here, is you have to consider the broader range of tools. Right now, the hope that Congress was going to create more tools doesn't seem very likely. So you work with the tools that you have. And creatively. And
exactly, you have to stretch the tools.
You have to stretch the tools. Yes. I'm working on a short paper about the importance of, I'll do hanging quotations. I don't like them very often. I'll do it right now. Small monopolization cases. The history of antitrust is full of small monopolization cases that really came up with very useful principles. Lorraine Journal is just a classic example. What are the chances the lawyers who litigated Lorraine Journal in 1951 thought we'd still be talking about that case? But you think about that case, it's fascinating. New technology, AM radio, is challenging the incumbent, the monopolist newspaper. I'll bet there's a lot of newspapers that wish they could still say that about themselves.
Both two-sided markets.
Both two-sided markets. A weakness, a vulnerability, advertising. And you look at that case, and it has lots of very current themes: raising rivals' costs, reducing rivals' revenues, and that case lives on. Well, that case didn't take 10 years to litigate. It didn't involve the largest impact on the economy, but it's a building block. There are some cases like that that are pending before the agencies now. Dentsply is another good example, not the largest case ever brought, but Dentsply is an important Justice Department case that established some useful principles about exclusive dealing. And I won't say anything like it was pulling teeth to get it through.
We've had,
I wouldn't say that.
When you look at the history of different agencies and the U.S. agencies, you have programs that show how you can carry out extensions, how you can restore frontiers. And they involve a good awareness of where you are, how you got there, a willingness to take chances, creativity at the margin. And I think what we lose in our system so often, for a couple of reasons, is an awareness of how that took place. So that if we're thinking, how do we get back to the summit in some of these areas, there's a way to climb. But you forget how you got up there. You don't know what the path is. You're not willing to listen to guides who went up before. And if you marshal that kind of know-how, there's a way to get back. But there are these kinds of techniques and methods. Other organizations study them pretty carefully to advance by learning. What a surprise. If you study those episodes, I think there's a lot there to suggest how, within any framework you want, how you reset the boundaries in a direction that is more compatible with the larger objective of the system, but also accounts for these emerging developments that you were referring to yesterday in talking about ecosystems.
So, in fact, at my conference last month, I had a panel on new law, new posture. I think a lot has to do with posture rather than necessarily new law. Now, I saw Eric leave, and it's a pity because I wanted all of you to comment on his margin proposal, but also, we can do, but also in the interest of time, I was wondering whether I can open it up to the floor and for people to comment so as not to monopolize. So David has got a question.
I don't want to pick on Barack, but I'm going to pick on Barack. First of all, I mean, the Rooney Rule just manifestly does not work. You look at the Brian Flores case, he's suing the NFL because he was fired for winning. I feel like just as you're not going to cure racism by taking a meeting, you're not going to cure the failings of precedents with a tutor. And the other point, and I mean that's a minor point, but the other point I want to make is that we actually did this. In 1976, the George Mason Law and Economics Center started a 2-week, all-expense-paid conference where up to 40% of federal judges went annually. They did it for 23 years. And a 2018 paper showed that it had a marked and quantifiable effect on future rulings. Judges were more likely to vote against the National Labor Relations Board. They were more likely to vote against the Environmental Protection Agency, and their criminal sentences got longer because they were exposed to this line of reasoning. So there are some of us in this room and much more of us outside this room that think that creeping economism is actually the problem. And particularly where the biases come in through that. I should also mention that about 105 corporations funded the Law and Economics Center conferences that went out there. So I thought that was something to bring to the table.
Yeah, no, I'm not sure that article establishes causation. I think that there's a significant selection effect on judicial appointments that Andy was talking about. But more seriously, look, I do believe that judges are people who want to get the right answer, who are pressed for time, and who, just from a purely cognitive perspective, rush to judgment based on heuristics. And that's the cognitive mechanism that I'm targeting. I have a paragraph in my piece that acknowledges the severe shortcomings of the Rooney Rule, not just about the Brian Flores story, but some other more systematic studies. I have another paragraph distinguishing the failure of that rule with the possibility of this rule working. To be brutally honest, I put in the Rooney Rule as a catchy thing. I mean, look, these are Article 3 people. And I think it's a very, look, and
that's a far more publishable title.
Article 3.
Article, yeah, how to convince the unconvincible. I mean, no. And I don't think this is a capture story. I think this is one about ideological heuristics that are reversible. That's what I think.
David, I want to know if any of those judges disclose their trips. Never mind.
There's a question over here.
Interesting.
Thank you. So I have a question for Bill. So I don't know. So when I hear you, I'm hearing basically a descriptive account of what agencies are actually doing, maybe more in the UK than in the US, but it's actually happening, right? And so normatively, I'm seeing your paper as an argument for, so your question, or the question that we should ask maybe is, who should be defining the goals of antitrust? Is it courts? Is it agencies? Is it another branch of government? Or, is it Congress? And I see actually the three of you engaging with that question. So, some of you are more interested in giving the power or the prerogative of determining the consumer welfare standard or goals of antitrust to courts, and others less. So maybe you want to all comment on this, but it's specifically for Bill.
I see in the first instance, it's the agency that's going to be the catalyst through the kind of disclosure I mentioned, by, in a clear and non-apologetic way, saying this is what our program is, this is why we're doing it, this is what we see to be the whole point of our enforcement program. These other audiences will see that. If Congress doesn't like it, there is plenty they can do about that. They can bring you up for hearings. They can conduct investigations. They can say, that makes a lot of sense. We like that. We don't regularly come back and do a restatement of the law. Maybe they should every, say, 100 years. This is what we said in 1890. We still believe it. This is what we said in 1950. We still believe it now. To have that process basically of renewal. But one major audience is the Congress in this process, with the agency being a catalyst. And indeed, it's the courts as well. It's the courts with the agencies guiding, backed by this research capability, backed by the analytical approach, and backed by the legitimacy that comes with using a process that distills a program that I think is faithful to the conception of the statute, to modern social needs in many respects, and the courts in a position to judge using their interpretative authority to decide where to go. But it's the agency that sets it in motion with honest, full disclosure. But maybe the main audience is ultimately the Congress, which has to, every year in the US, has to pay the bills for you.
I'll just say briefly, I'm a big fan of Bill's paper for the same reason I'm a pretty big fan, although less so, of my paper. I mean, I think that Bill's approach, it enhances transparency, it enhances accountability, but I also think it's a disciplinary device. I mean, if you say what's important, you're more likely to follow what you think is important. So I think it's actually a very effective way of focusing priorities on an agency. Focusing an agency's priorities.
I mean, for example, there's no question that the FTC brought the South Carolina State Board of Dentists case in many respects because of the target victim audience there. No doubt about it. And in a move of transparency, Commissioner Thompson's opinion for the commission on the front page lays out the facts. It's impossible to read that page without getting a sense of why this case is here and not some other case. Now, the agency might have done a lot more to say that economic disadvantage in this sense is a major prioritization principle, and to describe other matters that were consistent with that. That could have been done more fully, but that's an example of how the agency, I think, is a catalyst. Part of the audience was the Congress. Part of the audience ultimately was the Fourth Circuit Court of Appeals.
So let me give the last 1 minute to Andrew for a final comment that you may have, and then we need to really go to Luigi for the wrap-up.
Let's not let the debate over standards obscure the useful cases and useful principles that really don't rely on that debate about standards.
Well, that was less than a minute, but I think it's well done. Oh, you want to ask a question? Okay, then quick.
Two quick questions. One question for Andy. So I read your paper and I mostly see you saying there's a lot of like cases we could be winning in the current, under the current standards that we're not taking. But most of the cases you cite are either quick look cases or Microsoft. So and I think Microsoft might come out very different after Trinco. So I wonder if you think these are winnable cases. And for Bill, just to finish, so in a way your proposal is very much less bold than I would have imagined, because you're mostly asking the agencies to grade their own homework. They have to produce their own reports, do everything. Something that's interesting is to notice that the US antitrust agencies are probably the most opaque agencies anywhere in the world. We discovered this because we actually filed a FOIA about something relating to mergers, and I didn't know, but everything that relates to Hart-Scott-Rodino is FOIA exempt. You cannot ask a single information. Or in other countries, actually, when you file a merger, you have to publish a notice of merger. This happens in Brazil. In Brazil, for example, because we are concerned about potential conflicts of interest in the agency, everything that happens in the agency is public. You have to file public reports. You have a case. You have to have public versions of the opinions, which are also redacted for confidential information, but you know what's going on at the agency. So don't you think you're giving the agency too much leeway to grade their own homework? I think this was fascinating.
Not if they're really great instructors, and can do a good job of that. I think they're, for starters, if you have a process where you are doing more complete, honest disclosure, then you have a better informed debate. Second, I think there's a role for external review too. That is to have in effect an audit, an academic audit perhaps, where you bring in outsiders subject to some confidentiality requirements, but let them report on the results. And last, I think there are good disclosure habits that can be replicated. John Quokka's talk that kicked this off, that data set he had on his slide, 1996 to 2011, guess who decided to form that program and put that data set out? You know what kind of opposition there was inside the building? Death threats? I mean, having other people taste my food? The reaction was, if we deconstruct all of this information and explain what the decisive factors are, then they'll know what we did. Yes, they will. And Malcolm Coate, God bless him, did the painstaking job of going through and extracting this information. That's something we did and ran basically from 2005 up through 2011, and it is a shame that was discontinued. That's worth doing not just at the FTC, but at the Department of Justice as well. That was really helpful disclosure. You pull that out of John's book, it's not nearly as interesting a book as it is with it. And that was utterly voluntary, not compelled, not FOIA'd. It was just done because we ought to have a debate about this. That's a custom and norm worth keeping.
We can have more discussion, but I don't think Trinco has anything to do with the U.S. Microsoft case. I don't think it changes at all the point I made in the paper about deception. It had nothing to do with refusal to deal. Yes, the Trinco narrative is a troubling narrative for single firm cases. I also mentioned the allegation in the Epic versus Apple case, and there are some links in there to other articles that have been written about deception by monopolists and how we might treat those similarly as information impairment cases. I put it out there not as a finished idea, but I think it's something that can be worked with.
So first of all, thank you for resisting up to the end. I will be brief. So before we conclude, I would like to remind you that in advance of this conference, ProMarket published a series of articles penned by many of the scholars here, outlining proposals for amending and replacing the Consumer Welfare Standard, Now we've decided that we bury them, so we have to replace them. If you have not already read them, I highly recommend them for you to read them. And also, if you are inspired, outraged, or would otherwise comment on the topic that we are discussing at this conference, I would encourage you to send your thoughts to ProMarket. We hopefully put together a little ebook with all the thoughts so that people can get them all in one place. Additionally, I would like to take a moment to thank everyone who made this event happen. As you know, executing these events takes a village, and I'm very proud to lead such a terrific team of people. In particular, I would like to thank our videographers, Gabriel and Chris, and the Glitcher AV technicians who have been live streaming recording these 2 days, our Stigler Center research professional, Thomas, Joshua, Federico, and Quadja, for the assistance in room setup, question and answer, and also Utsa for promoting the conference across social media and our platforms. I would like to thank Brooke, Andy, Walter, and Will for providing a standard editorial coverage of the conference on ProMarket, and our administrative team, including Brianna, Rachel, Sebastian, and Chris, for the planning, logistics, and the execution of the conference. Last but not least, my fellow conference organizer, Guy and Filippo, for making this sixth conference really a success. Before I start with my concluding remark, I want to put on your calendar that the next conference will be on April 18, 19, 2024. So, having thanked all the people, I want to thank actually all the audience for enduring this experiment, which is not easy because we come from different perspectives, both ideological and disciplinary, and sometimes it's not easy to be together in one room. Sometimes it's not easy to understand each other or tolerate each other. But we have done it, I think, in a fantastic way. I thought that yesterday, the panel that was in the evening led by Filippo with the two judges was really an example of what intellectual discussion is. And in a world where intellectual discussion is disappearing because we throw things at each other and we cancel each other when we open our mouth, I think that this is really inspiring. I think that this is what Chicago is. The second thing is I really learn a lot. I always learn tremendously in this conference, but I think this one I learned even more than the other ones. And I will not have time to thank individually all the people I learned from. But I think that the most insightful part that I got is actually very simple, is what Eleanor said, that basically the consumer welfare standard was simply a way to exclude non-market values from the conversation. And actually, in my work with Oliver, I found in a different area, the one of corporate governance, how economists more or less have done the same. They have basically exclude some non-monetary value from the conversation, saying that that was the right thing to do, and then became the norm. And I think this is dangerous because I love economics. I think economists have a lot to contribute to the conversation for their expertise. But one thing that they should not do is substitute their expertise for values. In a democracy, who gives values is the people in this Congress, not us, not the lawyers, not anybody else. And I think that reminding this to all of us is extremely important. I wrote a short paper in the American Economic and Review paper and Proceeding in 2020, making sort of the political limit of economics, because I think is enormous. And by coincidence, today, an episode of my podcast with Bethany is coming up with a book by a sociologist that criticized deeply the overtaking by economists of all the agencies. I think she overdoes it, in my view, but I think there is something truth to it, that the takeover of economists has, to some extent, substitute some non-specified values for democratic values. And maybe because of my civil code background, but in all this discussion, it reminded me of something I learned in my actually civil law class in as an undergraduate. In Italy, when you do economics, you also have to study law. And there is this distinction that in Latin sounds de jure condita or de jure condendo, which is whether you discuss the law that should be made or the law as it is made. Now, I grant you that it's much easier in civil law because judges don't make law. In common law, it's more complicated to make this distinction. But it's a very useful distinction because one thing is how you interpret the law as it is, and the other is what you wish the law would be, okay? And unfortunately, many of these proposals, not all of them, but many of these proposals and many of the discussion mix the two things. And I think that as economists, we which things are efficient, and we can decide what we count in efficiency. Some people put pollution as part of the efficiency. Why not? Some people put destroying the local news as part of efficiency. Some people put lobbying or lack of lobbying as part of efficiency. Some people put other sort of weight differently various things like food desert or minority welfare and so on and so forth. We are all free to do that. But that's basically our values, our individual values. I don't think we have much to contribute on that as economists. What we can contribute as an economist is saying, is this more or less competitive? In a sense, I think that to some extent, Eric has it right when he goes back to the Sherman Act and say, I take literally the Sherman Act and see what the Sherman Act means. And as economists, if we reason de jure condita, that's what we should do. If we want to say what we would like the law to be, that's a different chapter. We can speculate all the things, but that's a different story. And I actually learn also a lot from somebody who's not here, Paul Tucker, who is actually a central banker, but wrote a very interesting book called Unelected Powers about agency in general, and say if you are an agency, you have to have a very clear mandate, because the decisions belong to Congress, not to the agencies. And I actually find it very scary that in the United States, the agencies take over. And this is not just the antitrust. The SEC is even worse, because I was at a debate a few years ago in which a member of the SEC said, oh, we're trying to do the best not to apply this that Congress said because we don't think it's right. And this is an agency saying that the agency should apply what the Congress said and not something else. So I think that, and I think Matt Stoller was right in saying we don't want to have standard. I think we want to have test. My understanding, and I'm not a lawyer, is whenever there is a principle, then judges, etc., try to find a test on how to apply a certain principle. So I just thought this morning, what is a security in a security offering? There is a AWI test. It's not going our standard, and it's not really trying to maximize any efficiency, etc. It's trying to interpret the law. So I think that what we need to do is first interpret the law, and then in the future try to think what can we do better. And to do better, I think we need to understand better the impact of what we do. I was very disappointed yesterday that many economists think that the antitrust is a epsilon in a grand scheme of things. I don't think that that's the case, but I think it's incumbent upon us to show it, first of all, to our own colleagues, to convince our own colleagues, and then the public at large, that this is not an half of a percentage point in growth, which, by the way, half of a percentage point per year is great. But I think that it's not a minor thing, it's a major thing. And I hope that future conferences will deal with this and will nail how important antitrust is. Thank you very much all for participating and contributing so much.